was not me.
Wouldn't be.
Back in my neck. So I have to. All right, let me. And then there's a moment when it comes out, it's like, well, anyone would do that. Thank you.
I mean, the point is, I was just going to pull.
I assume an easy case.
So I'm so
Yeah, yeah.
That's great. I immediately came up with it.
What happened last night? That's the norm.
It is the norm. No, it is the norm.
If you don't
Sharing
do this 12 hours
appointments
before,
with-
that's going to be shit.
That's right. Okay, I think we should begin. So we've got a full day. For those who don't know me, I'm David Posen. I teach constitutional law here at Columbia Law School, together with Michael Shudson from the Journalism School. I've organized this conference, and we are delighted to have everyone here, especially for this early morning panel. For those who couldn't make it last night, the conference got off to a great start with keynotes by Cass Sunstein and Tom Blanton, and response by Peter Strauss, and we look forward to continuing that momentum today. Regrettably, I have to say we've lost one of our panelists. Nadia Hilliard from Oxford University had unexpected travel difficulties, and so sends her regrets. We wish she could have been here, but FOIA stops for no one, so we carry on with what is still a fantastic group of panelists for this opening panel today on FOIA's place in American law, politics, and society. I think we're going to have a historically inflected discussion about FOIA, the First Amendment, and the trajectory of the open access movement in this country. I'm going to just introduce the panelists very briefly. Each of them is going to speak for about 7 to 10 minutes. Then I'll get things started with some opening questions, and we'll open up to the room after that. In the order in which they'll be speaking, Fred Schauer, to my immediate left, is the David and Mary Harrison Distinguished Professor of Law at the University of Virginia. For nearly 2 decades before that, he was the Frank Stanton Professor of the First Amendment at Harvard. Fred is one of the most influential legal theorists alive. He is perhaps especially influential and renowned for his work on the First Amendment and freedom of expression. His most recent book is The Force of Law, published by Harvard University Press in 2015. And though it is not one of his best-known works, I can't help but mention that Fred published a short essay in 2011 called Transparency in 3 Dimensions, which I fear contains more wisdom in about 20 pages than all the articles I've ever written on the subject combined, or on any other subject combined, and is a great piece for those interested in an introduction to transparency theory. Fred's going to speak about the relationship between FOIA and the First Amendment and the connections more generally between positive and negative rights and different visions of constitutionalism. Although that summary does not carry the force of law, so you're free to deviate. To Fred's left is Mark Fenster. Mark is the Cohn, Wagner, Nugent, Hazori, and Roth Tort Professor at the University of Florida Law School, where he teaches in the areas of administrative law, property, and torts, among others. Mark is a leading scholar of government secrecy and transparency. Over a long series of deeply thoughtful, provocative, and theoretically rich articles, Mark has challenged many of the most ambitious arguments made both for and against government openness and advocated for more contextualized, nuanced understandings of the work that transparency does. Mark is currently completing a book manuscript titled The Transparency Fix, A Critique of the Informational State. The Transparency Fix is also the title of an article that Mark published in 2012, which I highly recommend to anyone interested in an intellectual history of FOIA's origins. Mark's going to speak about the history of FOIA's passage and the significance of the fact that it gave us a right of access to government records under statutory administrative procedure rather than under the Constitution. And then finally, we have Sam Leibovich. Sam is an assistant professor at George Mason University and a historian of American politics and culture with particular interest in mass media, democracy, civil liberties, and the role of the U.S. in the world. Sam received his PhD with distinction from the University of Chicago and then held postdoctoral fellowships at Rutgers and NYU before coming to George Mason. Sam's first book, Free Speech and Unfree News, The Paradox of Press Freedom in America, was published by Harvard University Press in 2016. The book offers a comprehensive account of the history of press freedom in the United States from the dawn of the 20th century to the present. Free Speech and Unfree News also contains a remarkable chapter on FOIA, on the early years of FOIA, which I also highly commend to this audience. Sam is going to offer some remarks on what agencies expected of FOIA at its enactment in 1966, how those expectations have held up over time, and how FOIA has responded or failed to respond to the rise of official secrecy in the national security area after World War II. So we're delighted to have such an exciting panel and such range of intellectual depth and breadth on it. Without further ado, Fred.
Thank you very much. I am delighted to be here, delighted to be talking about this topic. As per my assignment from Dave, I will be a little bit abstract, a little bit theoretical, a little bit pedantic, but I don't mind that. I'm a professional pedant. Pedantic is what I do. So hopefully this will provide some background to what will take place over the rest of the day. So more specifically, I've been asked by Dave to talk about the relationship between the First Amendment and the Freedom of Information Act. And in order to do that, I want to start with the proposition that the United States Constitution is largely especially in its rights provisions, a negative document. That is, the United States Constitution, especially as understood, especially as interpreted, especially as most literally written, and especially in its rights provisions, is largely about telling the government what it cannot do, rather than telling the government what it must do, rather than imposing affirmative obligations. The rights provisions of the U.S. Constitution in general keep the government from interfering with individual action, private action, non-governmental action, but rarely require the government to facilitate the effective exercise of those rights. For those of you somewhat familiar with the more or less modern philosophical literature, Isaiah Berlin's quite prominent two concepts of liberty that distinguishes positive liberty and negative liberty fits very well with this. The U.S. Constitution is largely a document of negative liberty and not particularly a document of positive liberty, not particularly a document of facilitating the exercise of rights or requiring government to do things rather than prohibiting the government from doing things. So there are some number of examples of this. The Second Amendment, regrettably, in my view, says, to dramatically oversimplify, that the government cannot restrict gun ownership, again, to oversimplify, but nothing in that requires the government to provide weapons to people. Even the most enthusiastic proponents of the Second Amendment, and I am not one of them, but even the most enthusiastic proponents of a robust Second Amendment do not go so far as to suggest that actually providing people with weapons is part of what the Second Amendment is all about. Similarly, again, to dramatically oversimplify, under existing interpretations, under existing constitutional law, although there is a right to for a woman to have an abortion in consultation with her physician, as a matter of constitutional law, there is no requirement that the government provide the facilities or provide the funding for that, as long as the government, again, to oversimplify, keeps away from the decision made by a woman and her physician. More broadly, unlike South Africa, for example, in the United States, there is no affirmative, positive social welfare right to health care, no affirmative, positive social welfare right judicially enforceable to housing, and some number of other things that one finds in the Constitution as interpreted of South Africa, a particularly exemplary positive rights kind of document. Unlike some Eastern European constitutions, the U.S. Constitution does not contain provisions providing for pensions, providing for welfare benefits, providing for some number of other things, and creating, once again, as has been the case in the not so distant past in Hungary and Poland, for example, judicially enforceable rights to pensions of a certain level, judicially enforceable rights to unemployment compensation at a certain level, judicially enforceable rights to various other financial benefits of this kind. And getting a little bit closer to home, unlike some state constitutions in the United States, California and West Virginia, for example, the U.S. Constitution does not contain a right to education. There is no constitutional right under the U.S. Constitution to require the government, require any government to provide an education. Existing First Amendment doctrine is largely of a piece with all of this. So if we go back to 1974, in Saxby versus the Washington Post and Pell versus Procunier, the Supreme Court said that there is no affirmative right under the First Amendment of access to government facilities, government buildings, and the like. This was reaffirmed and emphasized 4 years later in Houchins versus KQED. Once again, whether we think of it in terms of freedom of information, whether we think of it in terms of open meeting laws and the like, the lesson of Saxby and Pell and Houchins is largely that as a matter of direct application of the First Amendment, there is no First Amendment right to access to government facilities. As famously put by Justice Stewart, who, interestingly in this regard, was one of the most fervent advocates for treating the press clause of the First Amendment as having separate, important, operative provisions. Nevertheless, Justice Stewart said, the Constitution itself is neither a Freedom of Information Act nor an Official Secrets Act. So, obviously, there are exceptions to this, as there are exceptions to almost everything. One exception is the constitutional right of public access to trials under Richmond newspapers. Another, even more broad-based exception is so-called public forum doctrine. That is, under public forum doctrine, there is an affirmative right of access to streets, to parks, and sidewalks, nothing else. The traditional public forums, a right of access to streets, parks, and sidewalks in order to engage in First Amendment speech kinds of activities. These exceptions notwithstanding, in general, the First Amendment, to use the by now trite phrase, is far more of a shield than a sword. It doesn't guarantee the effective exercise of the rights that the First Amendment, in fact, protects. And in fact, to quote another well-known and by this time trite quotation, but appropriate because he's a graduate of the Columbia School of Journalism, as A.J. Liebling said in 1960, freedom of the press is guaranteed only to the person who owns one. And in that sense, one can understand that under our system, under the American Constitution, under the understandings of the American First Amendment, the Freedom of Information Act is largely a positive legislative supplement to a largely negative Constitution and a largely negative First Amendment. Now, let me just say a little bit, even more speculatively, about the implications of this. Under some circumstances, to say that certain kinds of rights, especially positive rights, are best left to legislatures rather than courts is not necessarily a bad thing. One of the things that happens when courts, as in South Africa, enforce positive rights requiring government expenditures is that courts find themselves in a position of allocating scarce governmental resources, and often allocating scarce governmental resources on the basis of who was the first to the courthouse. That is, when we leave the allocation of scarce governmental resources to a court, and it finds that there is a right to X in the first case that happens to be brought, if there is no remaining money for the positive right to Y, it turns out that the allocation, the prioritization between X and Y is largely the fortuitous matter of who who brought the first lawsuit. The extent to which this relates to the Freedom of Information Act is largely a question of just what is the cost of the Freedom of Information Act. And here I mean cost not in the broader sense that I gather was the source of, let us say, spirited discussion last night, but rather cost in a somewhat more direct monetary sense. In a world in which most agencies have Freedom of Information officers and Freedom of Information departments and on and on and on, the Freedom of Information Act is not free. And once we understand that the Freedom of Information Act is not free, in the same way that we understand that free speech is not free, then we at least have to think about the advantages of courts as opposed to legislatures in requiring the expenditure of money and therefore in requiring certain allocations rather than others of scarce governmental resources. I will finish with just a quick observation that none of this is to deny that the background inspiration for the Freedom of Information Act is in part overlapping with some of the background justifications of the First Amendment, but I say in part intentionally. Very little of the Freedom of Information Act is about self-expression or self-realization or autonomy. A little bit of it is about the search for truth. Most of it is about democracy. Even more of it is about the value of checking government, checking governmental abuses. And I will therefore finish with the observation that many of the mechanisms that may make it harder, including the Freedom of Information Act, for bad governments to do bad things are also the mechanisms that at times make it harder for good governments to do good things. And with that, I will stop.
Thank you, Fred. Mark?
Thanks. I cover in very different ways some of the ground that Fred just covered. What my work is interested in is not only FOIA itself, but what we talk about when we talk about transparency, when we talk about open government. It's jarring to think that the scope and range of individuals and institutions who claim fealty to the idea of transparency. Both of the main speakers last night, I think, notwithstanding significant degrees of disagreement regarding what it is that they were talking about, would agree generally with the idea that transparency is good. The Obama administration and the journalists that consider the Obama administration to be highly secretive both agree that transparency is a good thing. John Moss agreed that transparency was a good thing. Transparency International and the anti-corruption advocate community that they helped spur agree that transparency is a good thing. The digital transparency movement of app developers and open data advocates all agree. Julian Assange agrees. Each of them have extremely different visions of the state, and different theories of the state and different theories of how the state should govern. And they therefore talk past each other while claiming fealty to the same idea, which is, I think, really fascinating as someone who's really interested in intellectual history. And of course, Michael Schutzen's book talks about this as well. So that's one observation from last night that I want to give as an introduction to these brief remarks. But the second is the extent to which, and Tom Blanton's talk made this explicit, there is this great love-hate relationship with FOIA that, with any 50-year-old law is going to be inevitable. That on the one hand, it's the awesomest thing. It provides remarkable amounts of information and rights. On the other hand, it's the most frustrating thing in the world because we can never get it right. That's really interesting to think about how we could have a law that is so much a site of administration and fantasy that we can both love it and hate it at the same time. So I want to think about that while by utilizing the ideal of a constitutional right, without getting into the doctrine of it as Fred just described, for FOIA advocates as a kind of silver bullet to the problems that FOIA faces. Would FOIA's primary purpose be better served if, in fact, we could recognize or create an individual constitutional right of the public to government information? If we could magically pass an amendment to that effect. Now, the distinction between a constitutional right and FOIA's administrative mandate for the state to free its information may seem unduly academic, the lawyerly picking of proverbial nits. But from the period prior to FOIA's enactment to the present, scholars have called for the recognition of a constitutional right to know. The idea that these approaches are distinct helps reveal, I think, what FOIA advocates are after and why they and we often feel so frustrated by the statute. By embodying a fantasy object, the elusive constitutional right reveals not only what FOIA is not, but what it cannot be, and ultimately what cannot exist in our constitutional system and administrative state. I want to approach this question via two quick historical snapshots, key moments in the intellectual history of FOIA and the right to know, and both of them have some relationship to Columbia University, and I will point that out as we go along. The moments concern important figures in transparency advocacy. Harold Cross, in a landmark book published a decade prior to FOIA's enactment, and Thomas Emerson, in a landmark article published a decade after FOIA. First, in 1953, Columbia University Press published The Right to Know, a fairly dull book by a retired media attorney and media law professor at the Columbia School of Journalism named Harold Cross. Cross worked with the American Society of Newspaper Editors who commissioned the book, and his vast knowledge and talent in understanding and synthesizing existing legal doctrine gave him considerable influence over the press, the interest group most interested in addressing government secrecy and most capable of using its political influence to accomplish its goal. Cross's book compiled the existing, as of 1953, state and federal laws on informational access across federal and state government. It's presently unreadable, in large part because of the success enjoyed by those who initially relied on Cross to advocate against secrecy. It collects and restates a set of laws that it helped make obsolete by statute and in some instances by state constitution, including the federal statute whose enactment we celebrate here. The book remains interesting for two reasons, I think. First, it rehearses a set of general claims and theoretical proclamations about the necessity of information access for a democratic political system, claims that have proven robust and long-lived. And second, for Cross's strategic decision ultimately not to strongly pursue a constitutional basis for informational access. It's not that Cross ignored the possibility or value of a constitutional right to know. That is what he named his book, after all. And he strongly advocated a constitutional right of access under a broadly interpreted First Amendment. But at least regarding the federal administrative state, the bulk of his book was instead an argument for a lesser second-best solution, the amendment of the relatively new Administrative Procedure Act to include an informational right. He closed The Right to Know with the argument that, and I'll quote here, "The time is ripe for an end to ineffectual sputtering about executive refusals of access to official records and for Congress to begin exercising effectually its function to legislate freedom of information for itself, the public, and the press. The powers of Congress to that end are not unlimited, but they are extensive." This was in 1953, 13 years before FOIA's enactment, and one could imagine language like this being used still today to argue in favor of FOIA's amendment. Cross neither explains the distinction he saw between a constitutional right to information and a statutory obligation on the state to disclose, nor does he suggest whether he or his press collaborators should prefer one to the other. They are merely alternatives to the same goal, and he considered, quite presciently as it turns out, the statutory path to be the more likely one to succeed. But the distinction seemed to make a difference a generation later, when the leading First Amendment scholar Thomas Emerson took up the same issue in his influential 1976 article, Legal Foundations of the Right to Know, an article, too, that seems not quite dull, but rather beside the point today. Emerson hoped to place the right to know within the First Amendment and alongside his own preferred theory of the amendment as protecting the right of the speaker to self-fulfillment through self-expression. The right to know would plug holes left by the First Amendment's primary purpose. Now, his idea of the right to know includes lots of different things, but for our purposes, the most important one is that he viewed the concept as extending to, quote, a constitutional right in the public to obtain information from government sources necessary or proper for the citizen to perform his function as ultimate sovereign. A right that, he wrote, quoting again, would extend as a starting point to all information in the possession of the government. Now, he immediately backslid from that position, readily conceding limits to this right, including to the president's right to executive privilege, sensitive national security data, trade secrets, personal privacy, and so on, which begs the question, what is this constitutional right that Emerson wants, and how is it distinct from the Freedom of Information Act? Curiously, Emerson only barely mentioned the FOIA, and only after he had offered his constitutional scheme. He noted that the FOIA, quote, adopts much of the basic pattern just outlined, unquote. He complained in passing that some of the statute's exceptions are, quote, excessively broad, unquote. But he praised its mechanisms for judicial review. He concluded by stating that, quote, acceptance of the constitutional right would provide a firm foundation for further development and close gaps in the legislative structure, gaps which he didn't describe in any detail. Indeed, the article's absences and utter lack of prescience are extraordinary, especially in contrast to Cross. Emerson ignored the case law that had already built up around FOIA, as well as the 1974 amendments intended to strengthen the statute in the wake of that case law and in the wake of frustrations with the statute's enforcement and reach. Nor did he demonstrate any interest in imagining how an abstract constitutional right would avoid FOIA's shortcomings. Nor did he foresee the waning of the Supreme Court's interest in expanding civil rights and civil liberties, and how his abstract right might survive an increasingly conservative court and self-protective executive branch. Emerson merely assumed that a broadly understood constitutional right would surely provide broader protection than a statutory right with explicit obligations. In a brief comment on Emerson's article, Walter Gellhorn, a key founder of modern administrative law and longtime professor at Columbia Law School, dismissed Emerson's argument for its airy abstractions based on a bizarre faith in the judiciary to interpret and apply a minimally defined right. My point is not that Cross was right in recognizing the best path for success, and that Emerson poorly argued his point and failed to contemplate the potential shortcomings of his approach. I agree with that, but that's not my point. Rather, my point is that Emerson's desire to wish away the difficult questions that FOIA has faced since its inception is symptomatic of a widely held desire to solve the administrative and bureaucratic problem of the state's informational asymmetries. FOIA is not perfect. Its mechanisms are too slow, its compliance with it varies among agencies and administrations, and courts have proven to be frustrating enforcers. But there is no magic solution to these problems. In his response to Emerson, Gellhorn wrote that, quote, "We mislead ourselves by presenting every problem that confronts contemporary society as a justiciable issue to be decided by aloof judges under the rubric of constitutional principle. Surely a restatement of the inherent endless rivalry between constitutional lawyers and professors and administrative lawyers and professors. But we also mislead ourselves in thinking that every problem that FOIA has failed to solve can find its solution through the right statutory amendment or the right institutional innovation, or if only those judges had some backbone, or if only we could get it constitutionalized. The problems that FOIA has faced for 5 decades are intractable features and bugs of a constitutional system that disperses authority within a vast administrative state. We should take this opportunity to celebrate what the statute has accomplished and pause, if only for a moment, in the ceaseless effort to try to fix problems that are not entirely the statute's fault. And to return to the discussion last night, if we agree that transparency is a secondary value, as both Cass and Tom did agree, they disagreed, however, on the primary value. And when we disagree with that, we are disagreeing with the state that we want transparency to accomplish and to perfect, and what we want transparency to represent, then our mechanisms for transparency, imperfect FOIA or the imaginary constitutional right, will disappoint in what it delivers with respect to FOIA or by its failure to appear. At least we have 50 years of contested imperfection. Thanks.
Thank you, Mark.
Good morning. It's a real pleasure to be here, and this flows very nicely because my comments this morning are really a consideration of the statute itself and how that emerged out of the drafting process, which is a consequence of sort of an absence of a broader positive right to information or to the news. What you get instead is one particular statute, which comes out of a process that it's no great mystery that the LBJ administration was opposed to throughout the proposal of FOIA in the mid-1960s. In 1965, 27 agencies testified to the Moss Committee with their opinion about FOIA. Only one, the Civil Service Commission, if you're keeping score, was not opposed to the act. The other 26 were all opposed. Behind the scenes, you see there's really kind of constant memoranda back and forth about the effort to try to kill the bill in Congress or stop it coming to a vote. Ultimately, by the end of 1965, early 1966, it's pretty clear that those efforts are going to fail. Congress continues to pass a bill. It's not seen as publicly feasible in the context of sort of the credibility gap, to block a bill devoted to freedom of information. So the administration has to switch gears and try to come up with ways to sculpt FOIA to make it more acceptable to the agencies without putting themselves in what White House counsel Lee White called the awkward position of opposing freedom of information. You sort of can't be opposed to it publicly, but you can try to sort of do harm minimization behind the scenes. The first strategy is to draft an alternative bill to FOIA. Comes out of the DOJ. They'd present that to Moss and ask him to adopt that instead, and he rejects it as more antithetical to freedom of information than having no adjustment to the APA at all. So that's sort of dead on arrival. The second strategy is more interesting. Basically, the DOJ says to Moss, you can keep FOIA, we won't veto it, but we insist that we can write the House report to explain the legislative intent behind the bill, the meaning of the exemptions, and we'll hope that that will sculpt the judicial interpretation and also the administrative application in the Attorney General's implementing memoranda. And what you see is if you look at the draft bill that the DOJ proposed in 1964, then you look at that has sort of very broad exemptions in FOIA, then the Senate report has very narrow explanations of what the exemptions are, and then the House report returns to those DOJ draft explanations. They're quite large exemptions, and those are what get written in to Clark's implementing memoranda and actually kind of shape the substance. So one example of this is Exemption 2 for internal personnel records. The Senate report says we think this will cover things like lunch hours and parking policy. The House report says it will cover internal rules and practices which cannot be disclosed to the public without substantial prejudice to the effective performance of any significant agency function. A much larger category of things fall under the exemption. So I think this is kind of an interesting political history in and of itself, and I'm looking forward to the oral history panel because there's still some questions about the deal making. I mean, one of the things that FOIA doesn't do is deal with Congress, so we don't actually know some of the deal making behind this. But it's interesting of itself as a kind of historical moment. It helps shape the meaning of FOIA and its exemptions. And I also think it's a nice vantage point to sort of think about what FOIA does and doesn't do, right? What were the agencies actually concerned about? What were they worried that FOIA was about to do? From that position, we can see what FOIA accomplishes and doesn't accomplish over the course of its life. So in my remarks today, I basically just went back to the LBJ library and looked at what the agencies were saying in the lead up to the passage of FOIA and what their concerns were. The first observation is something that they were not concerned about at all, which might be surprising. They weren't concerned about national security information. There was no worry that FOIA was about to interfere with national security or undermine the classification system, and there's a very simple reason for this. That victory had already been won. All of the freedom of information advocates conceded that there was a need to exempt national security information. Moss understood that to be a very broad exemption that would basically reference the executive order 10501 under Eisenhower that created the modern revised the classification scheme in 1954. I think this is really an important point because the classification system was still very new in 1966. It was only established in 1951 by Truman. There wasn't a long history of classification. It was established by executive order. And at no point until FOIA had Congress actually conceded the legitimacy of the president's right to classify information for national security. And there's a sort of irony in the Freedom of Information Act being the first time in which Congress concedes that actually the executive has broad rights to declare information secret for reasons of national security. I think the slip here is that it's one thing to say, as James Pope, one of the leading freedom of information activists, said, that none of us wants genuine security information to be released. It's one thing to concede that as a kind of normative value. It's another thing to assume that the particular bureaucratic mechanism that had been established by the executive to define security information actually is protecting genuine security information. And as Tom Blanton mentioned last night, and I'm sure many people in the room know, routinely defense and intelligence community investigations into the classification system note how much it overclassifies information and how much it's incentivized to overclassify information. The irony is that FOIA actually just concedes that right to the executive, and the courts have then been fairly deferential ever since, saying that this sort of limited ability to review the decisions among the executive about what information should be classified and should not be. Obviously, that's revised in 1974, but then as the administration develops new arguments for the need to defer, sort of the Glomar defense or the mosaic theory, right, that had limited implication in actually picking apart national security information. So FOIA is quite weak, actually, in the area of opening up national security information, and that was by design. So if they're not concerned about national security information, what are they concerned about? Two things, really. The first are particular regulatory functions of the state, and in particular, areas in which the state runs up against economic activity. This takes various forms. There's a lot of worry that contract negotiations will be hampered if sort of negotiating manuals are public. But then individual agencies also have concerns about particular functions. The NLRB and the FCC are worried about informants on law violations, will be less likely to come forward if their names can be FOIA'd. Department of Labor is worried about enforcement. Fed Reserve is worried about monetary policy, and you sort of run the list. The only organization that remained entirely opposed to FOIA, well, not entirely opposed, but stuck to its guns and didn't even like FOIA after the House report was written, was actually Health, Education and Welfare. They're the agency most concerned about FOIA, even in July 1966, are still counseling that the president shouldn't sign FOIA, which I think sort of should give us pause. The expectations of the agencies here are, as we've already discussed, fairly prescient, right? FOIA has been used overwhelmingly by corporate interests. We've talked about the Quokka article already a couple of times, but there's something new about that. By 1971, there's a survey of editors that finds that almost none of them have used FOIA. The first 3 FOIA cases that go to the courts, one was a Shell oil company trying to get information about land patents, one was a group trying to get information about Department of Defense contract manuals, and the third was a shoe company in Puerto Rico trying to get information from the NLRB to ward off an unfair labor practices charge. Right? And there's sort of been a long history thereafter of private interests using FOIA for their own commercial advantage. The question that I have for the discussion today and more broadly over the weekend is, I'm not entirely sure what we should think about that in normative terms. It's obviously a little dispiriting or sobering that this is the main use of FOIA. I think it's important to remember that the regulatory state is much less legitimate than the national security state in late 20th century America, and it's important as well to remember that the public, freedom of information advocates like to talk about the public as the beneficiary. I think this kind of lens reminds us that the public is very diverse, and some sections of the public have much more ability to use sort of tools and rights than others. But I'm still not sure whether how upset we should be about the corporate use of FOIA. It's unclear to me whether they're using it to advantage them. Individual corporations are using it to advantage themselves vis-a-vis economic competitors, kind of taking advantage of information inequalities in the state for personal gain, in which case you just increase transparency and you remove the ability to sort of do information arbitrage, and that seems like not necessarily a problem. The tougher question for me is whether or not FOIA is actually undermining the capacity of the state to do regulation, right? And I'm just not sure what I think about that question. It seems to me that the agencies in the 60s thought that it would, and there's some evidence to suggest that it does, but hopefully we can talk about that more today. The second area, apart from particular regulatory functions, are sort of a broad set of concerns about what we could call the administration's theory of good governance. Some of these are concerns about bureaucratic cost and headache. Some of these are concerns about, basically there's a constant argument that FOIA tries to introduce a simple self-executing word formula, that's a quote, instead of the discretion of agency heads. And one of the agencies actually proposes a 10th exemption that basically would reinstantiate the any good cause found exemption in the APA. I mean, it's sort of interesting that even in the 60s, there's a sort of older progressive era notion that the administrative heads have discretionary authority and the public's not to be trusted. But that takes a particular form in 1966 in concern about executive privilege and the deliberative process, and worries about what they call operating in a goldfish bowl. Right? This argument we heard last night from Cass Sunstein about chilling candor and discussion in the administration. I just want to say 2 points on this and then I'll wrap up. The first is it's, I think, very interesting that the executive privilege gets sort of written into or inserted into the meaning of the Exemption 5 on deliberative process of FOIA at a moment when executive privilege is at probably its highest point of legitimacy in post-war American history. Executive privilege really only emerges in its modern form in the mid-1950s as a result of the McCarthy era. It's actually used to sort of protect administration files from McCarthyite investigations, which means it's legitimate with liberals by the early 1960s. It will then be discredited by Nixon's use in the 1970s. So FOIA's passed at a brief moment of legitimacy for this kind of thinking. The second question is the normative question, which was sort of raised last night about how we think about a deliberative process and its importance to democracy. I'm also sort of ambivalent on this question and curious to talk about it more, but the one thought I have is that the way in which the administration was thinking about this question in the mid-1960s seems not to have changed very much and today, based on last night's presentation, which is interesting because it suggests that keeping deliberative process information confidential hasn't actually done much to minimize the problems of a public overreacting to information about deliberative process. Right? In some ways, it seems to reproduce it because as information leaks out or comes out in various forms, it's misrepresented. It actually creates more of a gotcha moment if you can find out who said what to whom. And if the ideal is to have a public that's kind of indifferent to who's saying what to whom in the deliberative process, perhaps keeping that information confidential is not the best way to go about doing it. But that's a conversation I'd also be interested in having for the remainder of the day. Thanks.
Okay, great. Thanks for those wonderful presentations. So I'll pose a question to each of you and then open it up. So I think a theme of these remarks is that FOIA is doing work in our system that would clearly be seen as constitutional in other systems. And then the question arises of what to make of that observation. I read the panel as getting increasingly pessimistic about that way in which we've put quasi-constitutional weight on FOIA since 1966. Maybe I could try to put a little bit of pressure on your takes as I see them. So Fred, who I read as the most optimistic about this this route we've taken, there was a suggestion in your remarks that what's healthy, what's attractive about not going the route of judicially enforced constitutional rights here is that decisions have to be made about the allocation of scarce resources, and the legislature is better positioned to do that than the judiciary, so we can be grateful that FOIA has put that allocative decision, that distributional decision, in the hands of a legislature rather than courts. But on one view of FOIA, that's interestingly precisely what Congress did not do in the design of this law. As I said last night, FOIA is the rare entitlement program with no eligibility criteria. Any person can make a FOIA request without any showing of need or interest, a particular interest in the information. So yes, there's a tiered fee structure and there's some tiering in who can get expedited processing or not. But essentially, Congress throws up its hands at the allocative decision and invites a kind of ad hoc free-for-all of who can get access to this public good. And as Sam suggests, corporations have proven the most well-resourced and relentless in pursuing it. So should we be less sanguine about this move to a legislative rather than a judicially enforced right if Congress isn't going to go about doing firmer ex-ante allocative decision-making? Maybe I'll get each question out and then we'll just go down the line in as much as they flow. Mark, so I would say that there's something very compelling about Mark's deconstruction of our debates on FOIA as embodying very different starting points about what kind of transparency we're seeking. As Mark suggests, Julian Assange has maybe a libertarian, anarchic view of what transparency means or should mean. Cass Sunstein has a welfarist view in which transparency facilitates better cost-benefit analysis. Tom Blanton has an anti-abuse, pro-accountability vision, I think, of transparency. And FOIA is like a cipher for these, or a grid on which these different competing first-order visions clash, and we project our hopes and fears. So I find that, again, immensely helpful for deconstructing the debates and the sense in which we might be talking past each other when we talk about FOIA's issues. But is there anything we can leverage constructively from that observation? The fact that FOIA reflects these contested primary conceptions of transparency. Is there anything we can do with that? It is a genuine question, not a rhetorical one. For example, might we pick one and start to move FOIA in a certain direction, or realize from historical study that FOIA really was designed to embody maybe the Blantonian conception, and therefore we should be prioritizing that. I mean, is there anything to be gained, constructively, prescriptively, from the realization that FOIA embodies these competing understandings of transparency? And then finally, Sam, who I read as the most pessimistic, I guess could your observations be made even more pointed and suggest that FOIA has almost become an ideology in our system? Because I heard you say that FOIA basically leaves untouched the national security state, and in fact legitimates it perversely. We could also say, by the way, that maybe FOIA is a kind of congressional concession of the legitimacy of secrecy more generally as the background default condition, which need only be disrupted in case of a properly formulated request. That's another interesting feature of FOIA. Nothing need be disclosed unless and until a properly formulated request comes in. In that sense, is it also legitimating secrecy as the default condition? But on the other hand, we have agencies like HEW, Health Education, sorry, what is HEW?
Health Education and Welfare.
Thank you, and welfare, that feels FOIA to be quite threatening. So in that juxtaposition, could we fear that FOIA is doing the least work where it's most needed? Ira Katz-Nelson is a famous historian here at Columbia who's drawn a distinction between what he calls the crusading state, in which public institutions of this country dole out overwhelming violence abroad with little democratic oversight, and what he calls the state of procedures, in which public institutions are too weak to check private economic power. And he says the U.S. embodies this schizophrenia around that we have the crusading state and the state of procedures. Could you take your remarks to say FOIA has emboldened and legitimated the crusading state, left it untouched, maybe even legitimated it, while weakening the state of procedures, which basically does social welfare policy in this country? And if you're a certain type of left liberal, might you be very concerned about that trade-off? So Fred, maybe you can start and take
sure.
the line.
So I think I'm not sure I agree with your characterization of me as optimistic. That may attribute to me a more normative position than I have. The older I get, the less interested I am in my own opinions. So part of what I thought I was doing is at least suggest that there is a way in which, for better or for worse, treating access to information as a legislative matter and not a direct constitutional right fits with a fair amount of the background, at least over the last half century or more, theory of American constitutionalism, which is a different question from whether there ought to be a different theory and so on. Now, that said, two brief observations about this. I agree entirely that if we are concerned about prioritization and if we are concerned that courts are not particularly good at it, then I think you are right to say that the way that things have developed with the Freedom of Information Act replicates the same kinds of problems that we would have if courts were to do this more directly, and that if we are concerned about prioritization, it would be nicer if Congress had done more about that. Now, when we think about prioritization, we also have to think about what the underlying values are. I was not here last night, so I'm not sure how much the discussion of got into this question of corporate use of the Freedom of Information Act. It's worthwhile mentioning, as Dave and I have talked about a little bit recently online, it may be that one of the things that FOIA does is serve certain kinds of what we might call due process values. That is, I have not done a statistical survey of this, but most government regulation is corporate regulation, at least at the federal level. That is, most federal agencies that are doing regulation are regulating corporate activity. If that's right, then we should neither be surprised nor appalled that the targets of that activity would disproportionately want to find out what the activity is, what it is going to be, and what the basis of it is. If we were thinking about government activity that regulates individuals, due process values would suggest that those individuals ought to have a fair amount of information from the government that's regulating their individual activities. If we think about that in the context of corporations, a due process-y kind of value might suggest that corporations would have a legitimate due process kind of interest in finding out information from the entity that seeks to regulate their activities. One other observation that goes to the optimism point. One of the interesting and important things about the First Amendment as such is that it has valuable symbolic spillover effects. That is, when Columbia University, which is in no way as a matter of legal doctrine restricted by the First Amendment, seeks to regulate student or faculty speech in some way, everybody screams First Amendment. That's not necessarily a bad thing. The way in which the First Amendment has leaked out into private institutions and the culture at large has valuable consequences. Whether that's also true about freedom of information, if it were constitutionalized, would be a more debatable proposition. After all, one person's transparency is another person's privacy. One person's transparency is another person's privilege. If it turns out that claims of privilege, whether lawyer-client privilege or press privilege or psychotherapist privilege, were routinely rebutted in public debate by claims of transparency, I'm not sure that would be a good thing. If claims of individual privacy were routinely rebutted by, yes, but on the other side there is transparency and that's a First Amendment value, I'm not sure that would be a good thing.
So regarding positive things, there are a lot of really important and interesting ideas that people have come up with regarding amending FOIA, some of which have been enacted, some of which have not been, creating institutional innovations, including inspectors general, which unfortunately we didn't hear about today, independent commissions of various sorts, other things of that sort, some of which are ad hoc and some of which are systematic, and many of which have been written about by folks in this room. I'm not sure that I am pessimistic about the ability of any one of those things to solve the riddle of FOIA and to create the kind of transparent state that presumably everyone wants. So I'm not your guy for that. What interests me, though, is in thinking about the admission of priors to an extent. The fact that at its most frustrating last night, and I blame neither of the speakers, was that they were talking past each other because, Cass set this up at the very beginning when he talked about the elephant of FOIA and the fact that he only knew parts of it, and there were parts of it that he didn't know. And the parts of it that he didn't know were the parts that were extremely important to Tom. And the parts that were extremely important to Cass were not uninteresting to Tom, but were not part of what Tom sees when he sees the Freedom of Information Act. Given that, and given the fact that I think both of them are, because they have strong interests in their particular vision of FOIA, and Cass's has become quite personal since his period within the Obama administration. It's impossible to think of some sort of consensus around those different visions. Other than, my plea and my suggestion would be to think about ways by which those two different visions, I suppose the elephant could be seen in its whole and can be seen as an imperfect piece.
Mark, I just follow up and ask, is it right to characterize your position that we're neither better nor worse off with FOIA versus a constitutional right, that road not taken, because in either case, the deep conflicts about visions, competing visions of the administrative state would continue. That couldn't be resolved either way. And in either case, the right would underdetermine outcomes about who would win in a given case. So we shouldn't get hung up on statutory risk.
Exactly. And that sets aside the institutional question of would this understanding of the First Amendment then apply to Congress and the judiciary?
Yeah.
So would it not
Okay.
apply more broadly? But I'll leave.
Okay, great. Thanks. Sam?
Yeah, so I find the Katz-Nelson distinction very helpful. And it's in the back of my mind as I was thinking about FOIA. What's less clear to me is whether that's just a kind of conceptual homology, or like FOIA will represent the same strengths and weaknesses as the state more generally, and that this it is an expression of post-World War II American attitudes to the state, right? I mean, that would be not that surprising. What I'm more interested in is, I think, what is also in your question is if there's a causal relationship between FOIA and the development of the state in these forms. And there, I think, it depends which part of the dualism you're talking about. I think on the secrecy side, there is a clearer causal relation in terms of legitimacy. Less because Congress, by approving FOIA, but by approving of the classification system in FOIA, helps fully legitimize it, but more because that was the opportunity to imagine a different way of doing national security classification. And there's a particular irony here that is just worth paying attention to, that in the 50s, what people wanted with FOIA was dealing with national security secrecy. That was the concern that led to interest. That's where it turns out to be the least effective. Corporate interests are not that concerned about secrecy until afterwards. There's not advocacy, there's not testimony on behalf of the Chamber of Commerce or anybody for FOIA, as best I can tell. There's a little bit about science, big science wants transparency. But so that's kind of interesting, that it doesn't play out the way you would expect, and that's the chance you would have had to have a different national security classification system in place. As I said, I'm really not sure about the regulatory state and how we should feel about whether the claims that the regulatory state is making in the 60s are prescient in that they capture that there is some tension between effective, robust regulation and transparency, or whether they are just kind of other ideas about governmentality that we might not like as much that would be compatible with transparency. I'm less sure.
That's fascinating. Great. Okay, so let's open it up. I see Seth Kramer from Penn Law School.
Okay, a couple of thoughts. First of all, the conception of FOIA as non-constitutional kind of interests me, because if one were to have a constitutional right in some sort of firm fashion, the systems that have positive rights generally have a tropism towards proportionality. So that what you would get is not a hard-edged trump, but rather the courts involving themselves in some level of trade-off in light of some broader value, which is, it seems to me, in large measure what FOIA is. That courts have parameters set around them by Congress, but a great deal of the action is in defining how the trade-offs take place. What is good cause? What is a powerful privacy interest? What is valid classification? So on and so forth. And conversely, it seems to me that FOIA at 50 is a part of the small c constitution of the American state. It's inconceivable that it would be repealed, just as it was inconceivable that it would be opposed. So that's one set of thoughts. Second set of thoughts has to do with the role of economic interests as a primary set of requesters, and indeed probably the leading set of requesters. If, as I do, you think of one of FOIA's major functions as providing a last-ditch check against secret barbarity. What you want to have is a system in place when it becomes necessary that can be invoked and that won't be revoked under pressure. It seems to me that the fact that you have a series of powerful economic interests which are interested in FOIA sets up exactly that structure, right? When the ACLU and the Business Roundtable both have interests, FOIA is not going to be revoked in time of crisis. And when the Business Roundtable, which is much better funded, has an ongoing set of requests coming before the courts, you have a jurisprudence that can be invoked by ACLU. So it seems to me that the breadth of potential requesters is, in some measure, not a bug, but a feature of FOIA. And I'm curious, Sam, by the absence of business enthusiasm, I had thought Don Rumsfeld, as a congressman, was one of the enthusiasts for FOIA. And I had thought that that was in part because of a desire to hold back the overweening state, but I may be wrong.
Sam, you want to jump in?
Yeah, I heard an absolutely from the crowd somewhere. My read on Rumsfeld in that moment, and I haven't done a lot of looking, is that it's just partisanship.
Yeah.
That it's just scoring points on the LBJ administration, and I don't see a lot of substance, political ideology behind the move. But I might be wrong, I haven't looked in a lot of detail. I hear the point that, and I sort of am reminded, and I thought about this last night too, in Tom's comments where he talked about, it's fine, we want to, a strong FOIA should be strong across the board. It sort of reminds me of sort of the critical theorists' observation about the public being kind of constituted by capitalism, right? You're going to have both, and that's fine. I kind of see that point. I guess, as I said, I'm agnostic or something about the corporate side, and all I really want to point out is that that's where it's strongest and it's weakest, where you might think the case is cleanest around national security. And that's not to say that then people can't do good work, right, because it's on the books and can fight against it. It's just to say that FOIA was not actually designed to be a particularly good device to deal with the classification system, and it's been kind of contorted into that thereafter. And nor was it conceptualized as being a particularly good way to wrestle with the regulatory state, but it's turned out to be very good at that. That was my point, but does that answer the
I
question?
don't think we disagree.
Yeah.
I think Fred.
On your first point, it's clearly right that most of the constitutional regimes that are aggressive enforcers of positive social welfare rights have proportionality principles, but it is very rare that those proportionality principles, although they produce non-absolute rights, result in what we might call trans-topical considerations. So when the Constitutional Court of South Africa in the Grootboom case recognizes an enforceable right to housing, it wasn't considering the question of how much of the money on housing would be better spent for antiretrovirals against AIDS. And conversely, when the same court was deciding the treatment action case about antiretrovirals, it wasn't considering. So I'm not sure that that proportionality entirely, although partially entirely, deals with the prioritization problem. I think you're right that FOIA is these days small c constitutional in the sense that it's inconceivable that it would be repealed. But since my job this morning is to trot out trite phrases or trite quotes from the past, let's not forget the one of never argue with the fellow who buys ink by the barrel. That is, an attempt to repeal FOIA would engender enormous negative press reaction. How important that is as opposed to this being a deeply infused deeply internalized public value is a difficult question.
One quick comment, and that's we should remember that FOIA is enacted after the Administrative Procedure Act, and the APA itself was strongly advocated by the business community. And so the business community might not have cared that much about FOIA, although it has now, because it becomes another anti-regulatory tool, but the APA already was in place for that purpose.
Seth, I just have to add, I think there may be a tension between your 2 points. The first one being that FOIA's has small c constitutional status, unimaginable it would be repealed. Fred adds that the press would go nuts. Second point, let's be grateful for corporate engagement around FOIA because it creates a resilient cross-ideological coalition, but you don't need that corporate support necessarily, or at least not to the degree we have it, if FOIA has attained constitutional status and is unrepealable on moral or legal or other grounds. So, I think FOIA's FOIA.
I can respond to that.
Okay, so I have Peter Strauss and Mort Halperin, and then keep your hands up if you want to jump. So Peter Strauss, please.
Thanks. I want to start by saying if one looks at the Constitution as a whole, what one has is that, and not the Bill of Rights. If one looks at the Constitution, what one has is what I could describe as an intransitive positive document. That is, it is a document that creates bodies that have rights to create obligations, and of course they use them. That leads me to say, I hope that a general theme of this weekend, it seems to me a general theme of this weekend, ought to be FOIA is a continuing struggle between Congress and the White House, because it seems to me that's what it's been, Congress and administration. And in that respect, I was struck by Sam's access to the letters to the president from the agencies in relationship to the adoption of FOIA, because I think that in a way confirms something that came out as a somewhat disguised point of agreement between the 2 main speakers last night, which is there's a difference between immediate access and historical access, and there was an agreement that historical access was worthwhile. Well, maybe Sunstein kept saying, I don't know how much value there is to it, but it seems to me you've demonstrated that there can be significant value to it. And Congress accepts itself from the Freedom of Information Act. This provides no defense against our requests. But I'm unaware of, perhaps there is, a congressional practice of demanding agency letters to the White House about pending legislation. They invite agencies to come and testify to them. Of course, that's open and public. But I think they do not interfere with the private communications between the White House and the agencies about pending legislation, which is in its own way an implicit recognition of the temporal value of exemption B5. The one other thing I'll say is that if one is thinking about allocation, one needs to think about it in 2 respects. One is allocation in relationship to who are the plaintiffs. And here what one can observe, as I think I showed last night, is that the exemptions that capture or defend against the requests of individuals are much more frequently invoked by a major factor than the exemptions that involve corporate interests. And Congress, I suppose, is aware of that. But the other area of allocation is dollar allocation, the F-35 allocation that was mentioned last night. And here I was reminded of a question I posed to my students when I was first teaching criminal law in Ethiopia, where there is a right, I think it's a constitutional right to education, and it wasn't being provided to prisoners. And so I asked my students, all right, you're Minister of Education, you have $100 million more than you had last year. Where are you going to put it?
Thanks, Peter.
Nothing in any of that is anything I would disagree with. Certainly not the allocation point, I think you are right at the beginning that one of the things that constitutions, of course, do is constitute. Or in jurisprudential language that nobody came here to listen to, the Constitution is power conferring. That has a positive dimension and not just a negative dimension, and I think you're right to mention that.
Should we move on? Mort Halperin?
Yeah, two quick comments. One on the resource allocation. I've always been attracted to the argument that what we should say to every agency is you can't spend any money on your own public relations until you've met all your obligations under the Freedom of Information Act. So the choice is between giving the information to the public that it's asked for and giving the information to the public that you want it to have. And I don't think there's a single agency in the government that could not fund all its FOIA work out of its public relations budget. I also wanted to comment on the issue of what difference does it make if there's a constitutional right. As you know, many countries, the courts have established, and international courts like the European courts have established the constitutional right. And I think when they have, the major difference is that they see a requirement for the government and then the courts to take account of the public value of the information, to the public's ability to understand what the government is doing, which we don't have at all. Our system says you release it unless it's covered by an exemption. And so the whole court review is it covered by the exemption? Not, yes, it's covered by the exemption, there would be a little bit of harm, but it's the government torturing people, and therefore we're entitled to know it. And someday I think we're going to have a Supreme Court justice who says, yes, it turns out that the First Amendment is a Freedom of Information Act. But until we get there, I think we ought to think about trying to legislate this major difference. It would be drafting is simple, getting it done would obviously be harder. But we ought to say, as the President sort of said in his non-reviewable provisions, that the public value of the information has to be balanced against the harm before a decision is made to release.
Right.
There is an interesting empirical project for somebody to do who has empirical skills that I don't have, to compare the U.S. with the regime in some country that is consistent with what you were saying about a sort of constitutionalized right to information. The empirical project would be to say, if we treat constitutionalization as the independent variable, and the dependent variable is how much information is actually out there, that's an interesting question to which I'm not sure of the answer. That is, to put it differently, it is not clear to me that in countries that have more or less constitutionalized public access to information, that government information is more widespread and more generally available than it is here.
I agree that'd be fantastic to know, although I'm not bullish on the ability to get an empirical handle on what's causal there. But Mort, I'll just say, so other countries have statutorily made the move you're suggesting and put in a public interest balancing into their FOI laws. So there's precedent for it, and it also picks up on the debate that's now erupted around leakers and whistleblowers, who also, under our system, in the First Amendment context, cannot make a public interest argument that could be weighed against their violation, say, of the Espionage Act. So there's a sense in which our system just doesn't do public interest balancing around disclosure or non-disclosure, and we could shift there either statutorily or through judicial construction of the First Amendment.
Just two quick points. One is that as a comparative point, I think we'd have to situate that balancing test within the history of the American judiciary, both as an institution and in a conception of what the judiciary is supposed to do. That is, we can't simply wish away the role that the judiciary has played and the small c conservative role that it plays. And the second thing is to recognize the extent to which, when we're looking comparatively, looking formally at the kind of legal obligations that are placed on the state and that the judiciary is supposed supposed to enforce shouldn't come without recognizing the extent to which, as Seth has described in the sort of ecological conception of disclosure, that so many things get disclosed outside the context of the formal Freedom of Information Act, which might be different from the U.S. and other countries.
So in interest of time, I've seen two more hands. I'd ask that maybe we can get both questions out quickly first, and then last chance to respond, and then we'll break for a little coffee before the next panel. So I've seen Tom Blanton and Roy Peled, and I'm sorry if I missed anyone.
Thanks very much, David. I'll try to be short. I rise in defense of Donald Rumsfeld, and so because just to say, I think he actually, yes, there was huge partisan motivation. In the 50s, Republicans were totally opposed to FOIA because it was attacking the Eisenhower administration. In the 60s, they turned. But I think Rumsfeld was actually genuine in his entire peroration when he became the lead Republican co-sponsor of FOIA in '66. He talked about the intrusion of government into personal and corporate life and the need to expose the regulatory state, if you will. And I think that's genuine. I think, there's never monocausal explanations. And I think that was deeply felt, ideologically felt, and to his credit, actually. And I would just say, I think, to both David and Mark, I think there was more congruence between me and Cass last night than your hearing. And I think the congruence, maybe it occurred at the end when he's talking to me on the side, maybe as he was anticipating going home to his wife, whose first job after college was an intern at the National Security Archive, and whose book, The Problem from Hell, was based on FOIA requests that we helped her do. And he said to me, well, I think that 25-year sunset I was attacking in that article in 2014, you're right, I was going too far on that, right? So I don't know, maybe it had an effect, but he says, I'm going to have to rewrite this whole input argument because, these cases about abuse and war crimes and genocide, you've got a point there, exactly. And I think he has a lot of points too. And I think the congruence really comes out in one of my case studies, the opioid prescription database, which took a FOIA request to get it, because commercial interests, the Medical Association, didn't want it out. But once it was out, it became one of Cass's high-value data sets and huge, I think, public value. And that's the congruence, which is both of us agree that if there's a solution to the resource question, it's proactive disclosure of all of this kind of data. I go way much further. I go into input data, not just output data, so that we can turn FOIA into a place where you can contest the release of information where there are genuinely competing values that our whole society will recognize, not just simply bureaucratic obstructionism or overclassification or the like. So, and a final word, defending the corporate interests. I think Seth is right. There were key moments in the 1986 amendments, for example, when Orrin Hatch was very eager to dramatically expand. We'd have twice as many exemptions, 7 exemptions, than Peter pointed out last night in that great slide if Hatch had had his way in '86. And a key intervention actually came from not just the Information Industry Association lobbyists, but from a company called Lotus that was based in Utah. That was one of his constituents. And so there are key moments where our law is better for the commercial interests that are involved. I gave the title insurance as a founding clause. Anyway.
Great.
Comments.
And Roy
I'll
Peled.
just make a quick note, leave other stuff for later, but I just wanted to know that I think I'm right saying that the corporate use issue is uniquely American. It's not like that in most of other countries with FOI laws. So I think it's maybe more a matter of U.S. culture and society and market than
By law
FOI.
or by practice?
Well, both. I mean, other countries have commercial secret exemptions and commercial interest exemptions, et cetera. But the massive use of FOI by the corporate corporations is uniquely American.
And maybe just in response to Roy's last point, one possible causal variable is that we may, at least now in the U.S., exist in a little bit more of a anti-regulatory libertarian culture than exists in most other advanced democracies, and that this may play some causal role.
I would just note, I think on the corporate concern that keeps getting aired, I think there are a lot of intermediate solutions. I haven't heard anyone propose corporations, non-media corporations, be prohibited from using FOIA. I think people like Cuoco, who's been invoked a number of times, just suggest they might pay greater fees, or journalists and civil society organizations might be expedited more aggressively. So we're in a, we're in an intermediate space, I think, when we're talking about possible reforms. Any last word, Mark or Sam? Thank you, everyone, and
Thank you.
10:15, over here. I just don't know whether.
Yeah, no, that's right, no. Right.
Thank you.
Yeah, that's 1% is amazing. Which are all subsidized.
That's good, that's good.
The DC Circuit decided to walk away, but the Department of Defense did not.
Good to see you.
panel, time-wise, because we have a hard stop when President Bollinger gets here at, 25 past 11:30. So we're going to keep this panel structured, not run over. There's a lot of interesting stuff to say. I'm Bruce Shapiro. I direct the DART Center for Journalism and Trauma here at Columbia Journalism School, which is devoted to reporting on violence, conflict, tragedy, and their aftermath. Let me quickly run through the panelists and who they are. Then I have a little bit of a framing comment I want to make. To my immediate left is James Hamilton from the Department of Communication at Stanford University. Jim has done some remarkable work that he will summarize, research into how journalists actually, in the real world, use the Freedom of Information Act, what the consequences of that work have been, and perhaps some of the holes. To his left, my friend Sarah Cohn, editor and reporter at the New York Times and also president of Investigative Reporters and Editors, with which Jim Hamilton has worked on some of this project. David McCraw, vice president and assistant general counsel to the New York Times, who has been deep in the belly of the beast on FOI issues for many years. And finally, Jonathan Peters, professor at the University of Kansas School of Journalism and Mass Communications. Let me just take a point of privilege to talk about this panel, but also why the DART Center is co-sponsoring this conference. Some of my staff, when I said, oh yeah, we're going to do this, said, well, why? We do trauma. What does the Freedom of Information Act have to do with trauma? It's a good question. So there are actually two reasons that we're co-sponsoring this. I'm very happy to be here. One of them actually is simply personal. As someone who entered journalism just a few years after the revised and strengthened Freedom of Information Act was passed by Congress over President Ford's veto, a veto greatly encouraged by those White House apparatchiks Rumsfeld and Cheney at the time. FOIA became immediately central to my own work and my own career as a reporter, and I realized in preparing for this panel that to this day, except probably for the First Amendment, there is no phrase in the English language that gives me a greater feeling of professional thrill and frisson than "this is a request under the Freedom of Information Act." It's simple pleasure to write that sentence, in part because it says something very important about the relationship of power and populace, the rights of the press, the relationship of journalism to government. It's a fundamental assertion of rights to be able to say that statement. And also because writing that sentence, or reading it, evokes every story I ever worked on in which the FOIA was employed, from stuff on public housing conditions to stuff on surveillance and spying abuses by government agencies. It also evokes memories of months and months and years of frustrating waits, and also the unexpected delight of massive boxes of FBI documents suddenly arriving on your doorstep. But there's also a more substantive reason that goes to the heart of what this important meeting is about. No issue is more important, more pertinent to the study of violence and its impact and aftermath than secrecy. Just as family secrets are central to protecting and enabling perpetrators of intimate partner violence and sexual abuse, so government secrets are central to the state's ability to violate the social contract and sometimes violate law by inflicting or facilitating or instigating violence, whether at the level of police shootings and other abuses of law enforcement, to torture and war, and central as well to the ability of government to cover up the larger impact of violence through incompetence and corruption in areas such as disaster management, public health, poverty, and so on. It's no accident that the Freedom of Information Act, in fact, emerged, or the strengthened Freedom of Information Act in particular, the reforms of 1974, emerged out of the same war, ultimately, and the same era of social conflict that created the psychiatric definition of post-traumatic stress disorder and forced this society and forced clinical professionals to look at violence in new ways. And the FOIA has been central to reporters' ability for decades now, and coming full circle from the veto of the FOIA from the Ford White House to issues of torture and war in the aftermath of the Rumsfeld-Cheney war in Iraq and the aftermath of 9/11. So the idea of trauma and violence actually goes to the ultimate value of the Freedom of Information Act to the work of journalists and to public debate. Jim Hamilton has done this remarkable scholarship on the impact, or on the use of Freedom of Information Act by journalists. It's far too wide-ranging for him to give us everything, but he's going to give us an overview, and then everyone else will respond, and I've asked the respondents to limit their comments to 10 minutes so that we have a good, generous amount of time for comments from the floor and questions. So.
Thank you. I'm an economist, so I'll start off with a product placement. I do have a new book coming out. It's called Democracy's Detectives, The Economics of Investigative Journalism. And if you give me your business card today or send me an email, I would be happy to send you a free copy. And of course, if you read it, there's an opportunity cost involved. But I would like to get the ideas circulating. So I approach investigative reporting as an economist, and IRE defines investigative journalism as original content about a topic of substantive interest to the community that somebody wants to keep secret. And those are three economic strikes against investigative reporting. Because original content means that there's sort of a fixed cost of story discovery and story creation. Topics of interest to the community that have spillover effects, economists call those positive externalities. People in the real world call those things that are hard to monetize. So when you change laws and change policies, it's hard for you to get rewarded for that. And then somebody tries to keep it secret. That means the government often imposes a hassle cost on you for trying to extract information about hidden actions or hidden information that they have. So I have always viewed the FOIA process as a way to potentially lower the cost of discovering stories. And I say potential because in part it's going to depend on the implementation of the law. So in my book, what I tried to do was look at how FOIA is used by journalists. And I did it in two ways. One is I found out that IRE had been running a prize competition since 1979 and had surveys about how journalists got the story. In order to win a prize, you had to tell IRE judges what was involved in your story creation. And there were about 13,000 surveys in file cabinets in Missouri. So I paid them to translate those into PDF and put them up on the web. And those are now available for all IRE members to look at.
And we thank you for that.
Yes. And then what I did was I did text mining. And when I say me, you should think of work study students throughout this discussion. So I had students do text mining of those PDFs, and I looked for particular terms. One of the things I looked at was use of government records, use of FOI, use of FOIA, and that allowed me in an imperfect way, because if the journalists don't talk about that use of data, then I'm not going to find it. But it allowed me to look at how, who was using FOIA. So what I found when I looked at stories from 1979 through 2010 was about 14% of the stories that had been submitted to IRE in their prize competitions used FOI or FOIA in the creation of the story. Some people used it more, so print journalists, which often are able to devote more time. And in my research, what I found is that the average time devoted to prize stories in IRE was about 6 months, so pretty long. Print journalists were more likely to use FOIA or FOI, 17%. Television journalists, which have fewer resources that they devote to investigative reporting, are less likely, about 12%. Magazine stories, about 7%. And if you look, though, at the stories that have major impacts, they're much more likely to use FOIA or state information laws. About 25% of stories that resulted in people being fired, about 25% of the stories that triggered audits, about 25% of the stories that generated investigations that led to policy changes used FOIA or FOI, and about 40% of the stories that triggered the review of government policies involved government records request, and about 1 out of 100 of those IRE contest entries resulted in laws being passed within a year. And I say within a year because, when you're applying for that prize competition, you might have published in June and then you're applying in January. So about 1 in 100 result in new laws, and about a quarter of those involved public records request. In terms of what was uncovered, about 1 in 4 stories that deal with sexual harassment, 1 in 4 stories that deal with misconduct, 1 in 4 stories that deal with waste used government records. A second way that I tried to look at how people use FOIA was to do FOIA requests myself. I'd been doing FOIA requests since the 1980s as part of my research. So I sent out FOIA requests to 35 federal departments and agencies, asking them for their FOIA request logs and the logs of FOIAs that involve fee waivers. And you can predict that the response was underwhelming. And so that is accurate. And I tried to supplement it with data on the web about FOIA requests. So what I was able to do was, for 14 agencies, I was able to look at, between 2005 and 2010, what FOIAs were at those agencies. And then I was able to separate out those that were from media organizations. So in those 6 years, at those 14 agencies, they included things like Homeland Security, EPA, FTC, NRC, MSHA. At those 14 agencies, there were about 3,300 FOIA requests made over time. So the first year, in 2005, the most frequent requesters were local newspapers. But by 2010, the level of request by local newspapers had dropped by about 50%, which isn't really surprising because newspaper employment in newsrooms had dropped by about 40% over that time. So overall, if you look at media requests from 2005 to 2010, overall they dropped that level by about 25%. Requests by local newspapers dropped by about 50%. Requests by nonprofit media dropped by 14%. So they weren't as impacted. And requests by other media had actually gone up. And by 2010, other media were the most frequent requesters. So who are other media? It's Bloomberg, it's AP, but it's also niche organizations who predominantly are serving the producer demand for information, the people whose business it is to do business in Washington. So corporate newsletters, people writing about EPA regulations for business interest. The modal experience, the most frequent experience, so there were about 575 media organizations that filed these 3,331 FOIAs, and the modal experience was that you submit one FOIA. There are, though, a set of what I would call heavy demanders, and one way to examine those is to look at a particular agency. So I looked at the EPA. Again, there were 146 media outlets which made only one request. But there were 9 outlets that submitted 20 or more FOIAs to the EPA. and these 9 outlets accounted for 40% of the agency's total. They included The Hill, the Denver Post, ProPublica, National Security News Service, the New York Times, Inside Washington Publishers, Associated Press, Inside EPA, and the Center for Public Integrity. So this shows how intensive investigative scrutiny of the federal government resides in a relatively small number of outlets with a mix of financial models, a nonprofit, niche outlets who sell the details of governing to business interests, and a great national newspaper that is able to aggregate up the attention of everybody in this room and sell it to advertisers and also ask for subscriptions. If you look across all the agencies, all the 14 agencies, there were 3 media outlets that filed 100 or more requests to pull information out of the federal government. So these 3 media outlets were the New York Times, which had 101 requests of these 14 agencies, the Center for Public Integrity, which had 121, and the Associated Press, which had 272. So each of them represents a different model to support investigative work. You have a daily newspaper that can spread the costs across a national, international audience, a nonprofit, and a news cooperative that's owned by local newspapers that are able to spread the costs over many subscribing outlets. So the good news is that you have these 3 outlets that are heavily involved in FOIA. As a contrast, there's a company called Input, and over this 6 years, Input filed more FOIAs than all 3 of those organizations put together. Input filed over 500 FOIAs. They basically took contract information and sold it to private interests. So when I step back and look at this, I have 3 conclusions. Number 1, government records requests are part of many investigative stories that do change lives and laws. I think the IRE data support that. Number 2, for FOIA requests in particular, the scrutiny that was generated by local newspapers has declined significantly. The scrutiny from other media has increased, but other media is more likely to be selling contract information or talking about the details of governing to business or special interest groups, and less likely to tell accountability stories that hold people accountable. And I do talk about, and my third point is that these high demanders, the small number of media outlets who are generating many requests, that should make you all concerned when you read about the financial fate of the New York Times, their contributions to the Center for Public Integrity, or the fate of the Associated Press. I do talk about FOIA reforms in my book, but most of what I say in my book comes from Sarah Cohen. So since she's here today, I thought we could segue to Sarah.
Wow, okay. Didn't know. That was really good. Well, my comment's a little, really, I kind of wanted to start just by saying what Tom and what Morton said is kind of where are exactly the points I wanted to make. I spend an inordinate amount of time, and always have, fighting for records that are clearly public, that there is absolutely no reason that they can't be released. There are things like calendars for public officials, grant audits, even FOIA logs. And so the idea that proactive disclosure could help in improving FOIA is a really important one. And I would hope that over time, that with proactive disclosure, that we would see fewer FOIA requests, not more. And the idea would be that if there was a real priority on getting the public data that the public clearly has a right to, and not waiting for a FOIA request, then the costs might go down. If it becomes a habit, if it's built into your systems, then you don't have to react every time that there's a question. So that comes down to a question that was hinted at in the last panel, which is, whose records are these anyway? Are these the records of the government that the public has to argue to release? Or are these the public's record that the government has to argue to keep secret? And I would argue that FOIA has turned that relationship upside down, that instead of having to make the case that something has to be kept secret because of so much damage that would be caused if it were public, we have to make the argument that it has to be released because not so much damage might be done if it is released. And to me, that's an upside-down way of thinking about open records and public records, and it's part of what creates so much cost. We have a FOIA in right now with the State Department in which we've been asked to narrow it down to exactly which records of a database we want, because the FOIA office is arguing that they will have to review every single line of a database before they can release it. Rather than working with us we're working with them to try to figure out if there's a way we can narrow it in some other way that doesn't make us know what's in it before we ask for it, but I don't know if that's going to be successful. There are the other point that I wanted to make was kind of one that's been happening over the last 20 years that I've been a reporter, and it echoes the issue of public relations staffs. And that is that as each administration becomes more and more obsessed, I would argue, with controlling the message, that bumps up against transparency quite a lot. And so if the choice is between controlling the message and transparency, controlling the message is always going to win. And that has become something that has really gotten in the way. So in my work, when I start asking for records, whether I start outside the FOIA request process or within it, the first question I'm asked is, what is your story? What are you going to be writing about? And when I answer that, without facts, that's very difficult for me to tell you, and I mean it. I don't know exactly what I'm going to be writing. When I write a FOIA request, I have questions, not answers. And so I'm treated as if this is crazy. Of course you know what you're going to write, and I can't really work with you unless I know what you're going to write. And the problem with FOIA for a bureaucracy is that it takes power away from the public relations people. If you have information and they don't know what you're going to do with it and they can't control how you have gotten it, then it takes power away. It means that they can't tell their secretary, they can't tell the White House what you're going to be writing about, and that they're going to be surprised, and that is not what their job is, to be surprised. So it is a power struggle between the public relations and the FOIA issue, and it's becoming much more severe. My third point is just that the confusion between, and I think this goes to the point of the last panel, the confusion between the goal of what I would call the open government movement and what I would call the public records attempts for holding government accountable. There is quite a bit of difference between those two communities, and it has gotten confused in one sense, and that is, you can see it in some of the calls for release to one, release to all. That's very much an open government kind of approach, and it ignores the idea that there is a great deal of discretion now in what records might be disclosed. There's a hard limit on what can be disclosed, there's a hard limit on what must be disclosed, but there's an enormous amount of discretion in between. So, for instance, when I ask for records that will disclose names and identities, if I'm doing that for the purpose of holding government accountable, that might be releasable in that context, and it might not be releasable in another context. Or it might be releasable, but it might not be released in another context, that the purpose matters. And once you say that everything has to be released to everybody at once, what you've done is take away all discretion and leave it to the least common denominator, which probably means no personally identifiable information ever gets released under the Freedom of Information Act. It is no longer a balancing act between invading personal privacy and public interest. It now becomes, by definition, it's invading personal privacy. So I would want to think about how we can look at FOIA a little bit differently based on accountability versus based on the transparency issue. And a lot of transparency becomes propaganda. And I know I've been criticized for saying that, but the open government movement of this administration, at least, was to release information in a way and of a sort that was good for the government agenda and not necessarily needed to hold government accountable. So that would be one way that I would like to think about it. Thanks.
Thank you. David, more real world interventions here.
Well, you know, if all the reporters in the New York Times were like Sarah, I wouldn't have a job. So keep all this to yourself. I want to focus on Jay provides some really interesting research on what happens to requests and the delays and requests that actually end up getting information. I want to focus on another part of FOIA, which is the right to go to court. And I think there's a paradox here that as you see long delays, frustrations, information not being turned over to journalists, that on the other side of the house, fewer and fewer media companies are pursuing any sort of remedy through the courts. Even though that, to me, is one of the things that makes FOIA powerful, is that we have the right to go to court, have an independent decider make that decision. And we'll get into some of the limitations on that. But we looked at a period to 2013, 2015. The New York Times had filed 14 FOIA lawsuits in that 2-year period. The rest of our peers nationwide collectively had filed 6. So we had 14, the rest of the group in combination had 6. Now, when you see yourself that far outside the normal curve, you either know you're a genius or you have mental health issues, and I will reserve comment on that, and I hope you will too until I'm finished here. So why is that? You know, why is it that we are out there doing this? Why are we going to court? Because you know, any of you who are involved in this know that the losses mount rather than the victories. And it goes back to an idea that first came to me in a case that I litigated in 2004, New York Times versus Department of Labor, where our tremendous investigative reporter, David Barstow, have been looking at where were the most dangerous places to work in America. And the Department of Labor puts together a table of the 13,000 most dangerous places, but they don't order them. So you don't know who's 1 and who's 13,000, and that seemed really important to us to figure out whether you're tops in killing your workers or whether you're just 13,000th in that list. And we received a very, very long and nice letter back from the Department of Labor, which explained to us that they would have to ask each of the 13,000 companies whether that information could be released. Apparently, it's a trade secret if you're killing your workers. And they knowing they were talking to a lawyer, they knew I wasn't good at math, so they did the math for me that this, in fact, would take 30,290 hours to do that, to go out and ask people and then to process it. And because, again, being a lawyer, I didn't know math very well, they pointed out that's 15 work years. In 15 years, they'd have an answer for us. And it just struck me that maybe a federal judge would find that offensive, too. And I went into federal court for the first time in that case, and Judge Shinlin, recently retired from the Southern District now, pointed out to the government that isn't it a little odd in a statute that talks about 20-day periods that you're talking about 15 years? And the government responded by saying, well, we haven't actually denied this request, so the New York Times can't come to court, to which she responded, you mean 15 years from now the Times will have standing? And they, unfortunately for them, answered yes. And so it occurred to me that you know, that why isn't this used? Why isn't this tool used? In part, as we'll get into, is very difficult. But to me, I see it as both. The reason I am the outlier, the reason I am out there doing these cases, is that is both a micro and a macro level of justification here. The micro is obvious, that going after that information sometimes matters for our reporters, and it is incremental. I never go into these thinking that we're going to get that big, important vein of information. But for our national security reporters, when we get the government to unredact a little bit, it's telling in 2 ways. One is what we find out, and also what the government considers secret, especially in the age of Snowden. You know, like, what is it the government still considers secret? What basis they consider that? That is helpful information too. But so we look at it incrementally, and sometimes we actually do get, and especially on Sarah's side of the house, if we're looking for data, getting data tables, getting those kind of things where there's very little likelihood of there being exemption is important. But I also look at it in the macro level. I was struck a few weeks ago when I was watching the documentary Gideon's Army by Don Porter, who is a former media attorney who became a documentary filmmaker. And Gideon's Army deals with public defenders in the South. And one of the people who was interviewed in there talks about, in the system of criminal justice in the United States, the cop decides who goes to jail now. Because cop makes the arrest, public defender says you have to take a plea, court accepts the plea, it's never reviewed. That decision is never reviewed, and that person, under all the pressure, ends up. So do we really want a system, one of the public defenders said, where the cop decides? I feel in a much less grand way about that in terms of FOIA, too. Do we really want a decision where it's up to the agency? If the agency decides no, that's it, that's the end of it. And that's why the litigation part of this, I think, is so important. I have a case where, in my view, the government contradicted itself on how it did the search, and I was able to convince a federal judge to require the agency to talk about what happened during the search. And what you find out is the appeals officer puts in a declaration, says, I relied on the FOIA officer. The FOIA officer puts in a declaration that says, I relied on the person in the office that was looking for the documents, and the person who was looking in the office said, well, I didn't really understand the request quite like you wrote it, but I don't have anything. And that can't be the answer. It can't be the answer that the ultimate decider is the cop on the street or the FOIA officer, that at some point in a macro level, I think we have to hold the government to its proof. Obviously, at the macro level and at the micro level, as people mentioned on the first panel, the law is skewed very heavily towards the government. There is, of course, a presumption of good faith that goes into the declarations they put in. The courts will show deference and are required to show deference to some level. And discovery is extremely rare, which is, if you step back, is sort of a strange creature in civil litigation. The people who, if you went into, if the New York Times sues somebody we have a contract with for breach of contract, the idea that they could come and say, we did everything possible and you shouldn't have the right to look at our documents or depose our witnesses would seem foreign to the civil litigation in the civil litigation context. But that's exactly it. The people who hold the documents also get these presumptions. This all came to a head for me recently because I wrote a blog post for Just Security, which begins, when will federal judges be more like State Department PR flags? And I'm hoping that none of my judges have read it. But I was struck by this because think about what happened during the Hillary emails. The intelligence community says those documents contain classified information, and a State Department PR flag comes out and says, well, that's what they say. We disagree. Okay? You then have the president in an interview a couple of weeks ago saying there's classification and then there's classification. That now is part of our standard brief, and we put that in a recent brief to the NSA, and the NSA came back and accused us of taking sound bites from the 24-hour news cycle, to which we reminded them in our reply that perhaps the president was the commander-in-chief and they shouldn't really be talking about him that way. I don't think I've ever referred to him as the commander-in-chief until then. But my point is that what I would like to see and what I hope to see in some sort of misguided campaign, and I think the people at National Security Archives, the ACLU, EFF are much, much further down the line on this than any of us on the media side are. And that is try to push those rules so there's something that comes closer to real review, because I do think it will have an effect on the overall system. I'm not naive enough to think that when we threaten to sue over a particular request that it really has much bearing on a FOIA officer because it's going to be handled at some other level. But I do think overall changing the law, making it so that as people go to court that they would have more success for stuff that's really in the public interest would have an effect on the overall system. I mean, one of the things that we find, and this is the other point I'd make about litigating, is that many times we sue, and the effect of that is to suddenly have an AUSA, for a $400 filing fee, we get an Uber FOIA officer. The AUSA who comes in and goes to the agency and says, I got a federal judge who's going to want to know why you haven't answered this request. And many of our requests just end in a settlement because we get the documents. And that we're talking about who's privileged and who should have information and the democratization of FOIA is not right, but we're not going to walk away from that. It's an important part of what we think of as the request process. But what our real hope is that by pushing the law and by pushing the request, that maybe some sanity in the request process results. I'll finish with what I mean when I say that, you know, can we come to some sort of sane response? Because obviously there are things that government has a right to keep secret, many, many more things that we should have right to get to. But one of our reporters in Washington was doing a book on Abdul Muttalib, the fellow who was convicted of trying to blow up the plane as it came in Detroit on Christmas Day a few years ago. And so Scott Shane was looking into that. He made a request to the FBI for files pertaining to Abdul Muttalib. And the first thing he got back was a letter from the FBI saying, could he provide a certificate that Abdul Muttalib was dead or gave the FBI permission to release information about it? Scott thought this was odd since they had just been intimately involved in putting the guy in Supermax where he was not allowed to get communication, and maybe they knew that he was alive, okay? And maybe they knew that he really probably wasn't available to give a certificate. Which, okay, but we understand that's what the rule, that was it. So Scott said, well, what rule allows you to ask me that? To which he responded, you'll have to file a FOIA request to find those rules. The system shouldn't work that way, and I think it can work so much better.
All right. John. Okay, thanks, Bruce. So about 5 years ago, I was conducting an interview series with the Harvard Law and Policy Review about major figures in First Amendment law. These were people who have moved the ticker, made a mark in some way, people like Floyd Abrams, Martin Garbus, Lee Bollinger. And I asked one question across all of the interviews. And the question was, what is the most serious threat today to free expression? And the responses were fascinating, in part because they varied so widely. One of them said that it was the Citizens United decision because it perverted the marketplace of ideas. Another said it was the willingness of too many people to be selective in their support for free speech norms. And yet another said it was government surveillance and the chilling effects that has on speech. I hadn't thought about that series for some time, but in January, as I was kind of taking stock of 2015 and some of the cases that I had either written about as a commentator or had been involved in as a lawyer, my mind wandered to a variation on that common question that I had asked in that interview series. And the variation was, what was the most serious threat last year to a free press in the U.S.? And it's not a simple question to answer because it depends on how you explicate and define some terms. One of them would be free press, another threat, another most serious. But for me personally, when I really broke this down, the thing that occupied most of my time professionally in 2015 were efforts by government agencies at all levels to shield information and events from public view. So my comments, more or less, jiving with Sarah's there and Jay's, they're going to be a little bit broader than just the Federal Freedom of Information Act, and I'll make reference to some state cases as well. So I'll give you some examples here of 2015 disputes. A township sued a citizen who requested public records to obtain relief from its duty to respond and later asked for attorney's fees. State lawmakers tried to kill a program designed to help citizens resolve public records disputes without the need to litigate. Other lawmakers used Sunshine Week, ironically, to propose bills to make it more difficult for citizens to obtain law enforcement records. A police chief prohibited a citizen from photographing public records as he reviewed them. States continued to keep secret their capital punishment protocols. A city sued one of its citizens for copyright infringement after he posted to YouTube edited clips of city council meetings that the city had made available as public records. St. Louis County charged journalists in connection with their Ferguson news gathering, and the list goes on. It's nothing new, of course, for government agencies and officials to try to minimize their exposure and public scrutiny. But nonetheless, I worry about the resources and creativity that the government expends to parry the press and public. I worry about the shrinking budgets of newspapers, historically the most likely to litigate to compel disclosure, as supported by Jay's most recent research. I worry about secrecy's effects on the democratic accountability that our system is supposed to beacon, and I worry about that beacon, the example that we set for other nations that some of which look to us as good shepherds. We can't afford, and I realize, I'm preaching to the choir here. We can't afford to be to be home to the government that sues records requesters and shrouds in secrecy its capital punishment protocols while refusing to release information about deaths in police custody. We simply have to do better than that. Professor Hamilton's work illuminates not only the importance of public records to stories about making changes to lives and laws, but also the economic challenges of investigative reporting and how in some cases the FOIA, both the federal FOIA and the state versions of it, can reduce the cost of that reporting. More broadly, just 6 weeks ago, some of you may be aware that Knight and partners of the Knight Foundation released a survey finding that editors nationwide are losing confidence in the press's ability to fulfill its role as a First Amendment defender, largely because of economic pressures. 65% of editors said the industry is weaker today than it was 10 years ago in terms of its ability to pursue legal action related to free speech and open government. That, as I'm sure you all know, is partly what prompted Knight and Columbia to partner to create a new center dedicated to speech and press rights in the digital age. It's a cliche to say that the disruption of newspapers and other traditional publishers has also created opportunities for independent journalists and for startup news organizations. But equally importantly, that disruption has implications for the legal landscape in which journalism is practiced. Established news organizations tend to have institutional knowledge that can guide their pursuit of public records, while independent journalists and startup organizations typically don't have the resources to have a bunch of lawyers on retainer, and many don't yet have the institutional knowledge to guide them. That's significant, and I also wonder about the ever-increasing number of speakers in the public sphere, their understanding of freedom of information principles, and what that means culturally for all of us. In other words, to the extent that some of the new speakers and new voices, the new entrants into the journalism industry, to the extent that some of them lack institutional knowledge or more generally lack an understanding or an appreciation for freedom of information principles, it could have a deleterious effect not only for them but for all of us. FOI laws treat some people differently from others through fee waivers and the like, but their underlying principles are indivisible, and they apply generally to all of us and equally to all of us. So it's important to be mindful, I think, of any cultural acceptance of FOI restrictions, creating a culture in which FOI principles lose some of their central values. So what I mean by that is if you don't understand your rights, you might accept restrictions that you otherwise would not. And the net effect, I think, is to create or feed an environment in which FOI restrictions are okay. And that could be erosive, of course, for everyone's rights. And with that in mind, I've been trying to do my small part as a professor who teaches at least one class of all undergraduate journalism majors every term. I've found that giving students a thorough grounding in accessing public records is feasible even in a compressed reporting class or a general media law seminar in which time tends to be short and the topics list tends to be long. I mostly use it's a mixture of readings and hands-on activities and use class time for discussions about students' experiences in gathering certain government documents. Sometimes I use a semester-long project, a team project that's spaced out and completed in addition to other exams, other assignments, and so For example, borrowing from an idea developed by David Coulier at the University of Arizona, I've taken a traditional FOIA audit and added a twist that makes FOIA a little bit more personally relevant for students. And it's in the form of buying a house. Each student, each team is assigned a real house for sale in their local community. And then they're told to find everything that they can about the house and neighborhood through public records. So they tap into property records, crime records, zoning maps, airport noise maps, environmental records, among others. And not only does the exercise show students the wide range of records that are available and how to obtain them, pre-test and post-test surveys have indicated that the exercise has increased understanding of and support for freedom of information principles more so than traditional FOIA audits, chiefly because the object of the assignment, buying a house, felt more relevant to the students and their personal lives. The experience, I think, seems to demystify for students the FOIA process. And many students believe at the beginning of the class that they either have to be lawyers or trained specially in the law to draft a FOIA request or to file one. By the end of the semester, as I've told some friends of mine, the students are basically like, the FOIA version of the Kool-Aid man, essentially wanting to just crash through every government wall that they can find. And as one student told me last year in an email, and here I'm quoting from it, it's honestly exciting when you finally get the information you requested. My friend and I made a drinking game out of redactions. One sip for every line we could not read. By the end, neither of us could see, let alone read. So on that note, thanks for your time and attention, and I look forward to the discussion.
Thank you, John. I think we may move that drinking game into Sheila's Stabile Center for Investigative Journalism. We may have to adopt it. I have a question I want to throw out to any of you on the panel who are interested in this. FOIA is a federal law, but we as journalists and it as law relate as well to state freedom of information laws, and we are in a global period of reform in the information regime. If any of you could adopt whole hog into FOIA one reform, either from an existing state law or from another country, to the benefit of journalism culture and benefit of reporting, what would it be?
I have at least one, but in Florida, about 15 years ago, they adopted I don't know whether it was a rule or part of a law, that said that every new government system had to be evaluated not just in terms of how it will keep secrets secret, but how it will make what could be public public. And so at the inset of every new system developed in Florida is the expectation that at least the public portions of it can be extracted relatively easily. And that alone would change everything. And just as an example, the kind of problem that David talked about in terms of the Department of Labor, I have never successfully ever gotten a federal contract under FOIA. And the reason is that it always has to go back to the company, for the company to review all of it to see which portions of it can be released, that it doesn't think are secret. There is no segregation of the secret and non-secret parts of that up front. And so that executive order means that I can't get contracts at all. So that idea of building in openness, building in the concept that parts of this are public and that they have to be able to extract the public portions would make a huge difference.
Anyone else? Yeah.
So I would love to see the federal government use the word market failure more when it talks about journalism. And the reason is that when Sarah has a lot of data to use, going forward, we need more algorithms to process that data. And right now, the government has great software to do that, and it's usually associated with the war on terror. And it's not stuff that circulates as open source. And I worked for the FCC for a year on a 400-page report about the information needs of communities, and the word market failure was only used once in a footnote because they forgot to take it out. Because the idea is that it's very controversial in DC, but if you think about journalism and you call it a market failure, and by market failure what I mean is that when the New York Times tells a story and it changes public policy, those benefits are dispersed widely. And last night, Cass was talking about a welfarist approach. Yeah. In my book, what I do is I actually do 3 cost-benefit analyses of journalism stories, where I go and I talk to the editors, I figure out the actual story cost. Mm-hmm. Then I go and look at how public policy changed. So for instance, a story that costs $200,000 in North Carolina about the malfunctioning of the probation system actually changed the probation system. And I studied that and saw increase in prison costs, increase in probation. And I found that in North Carolina, in an 8-year period, 580 people were murdered by folks out on probation. And the reason I can say that is that the newspaper spent 6 months to discover that fact, and it cost them $200,000. That reform caused murders to go down. It took me a while to estimate it, but I was able to estimate the drop in murders in North Carolina because of the probation reforms. And then, using Cass's own OIRA numbers of $9 million for a statistical life saved, I was able to show the net policy benefits. For every dollar spent on that story, there were $200 in net policy benefits. And the reason I think that's important is that right now the government funds a lot of software, a lot of algorithms at the National Science Foundation, at the archives, but it stays locked up and it's not circulated. And I actually know of a government agency where a proposal was put in and they said, we love this software idea, just take the word journalism out of it because we don't want people to see that. And that was hard because the proposal was entitled Computational Journalism. But long story short, the thing that I would love to see is for people to realize that when people on this panel tell stories, it spills over with many positive benefits. It would be great if accountability was seen as a public good, if what journalists do was seen as a public good, as worthy as R&D in academia for algorithms as other areas.
Okay. Well, I was helping a group in Kuwait draft their FOIA law, which has not yet passed. And when I got to the end of the draft, it said that there would be a 1-year prison term for any FOIA officer who missed a deadline. I want people here to know that I actually oppose that. But it was an interesting discussion. I do think that in a lot of the states, when there are independent bodies, Bob Freeman's here from the Committee on Open Government in New York, some AG offices in some states, some they're designated by a variety of things, councils on freedom of information, that may not have official power to force an agency to do something, but are respected by the agencies and taken seriously. I do think it helps keep you from having to go to court, and at the same time reins in some of the independent decision-making that goes on at the agencies where, and I understand this, if you're a FOIA officer at an agency, there's a lot of pressure to do the cautious thing. Moving that outside of the agency, having a fresh voice, I think sometimes helps in a lot of ways to free that up.
John, any thoughts on this?
Yeah, I'll just add that as a complement to what David was saying about the importance of the right to litigate, I've also had an interest in alternative dispute resolution mechanisms for FOIA. And specifically, I've more or less enjoyed the experimentation among the states, and there's a recent development in the state of Ohio, and it is as recent as of about a week and a half ago, in which Ohio has been tinkering, going back about 2 years now, with methods by which a citizen can file a complaint with one state agency or the other to try to get either an ombudsman or a mediation program, or in some cases, the Inspector General's office involved to issue an opinion on the releasability of a particular record. And as of about a week and a half ago, the Ohio legislature passed a bill that I believe right now is awaiting the governor's signature that would enable, for a $25 filing fee, a citizen who is unsatisfied with a state agency's response to a records request to go to the Ohio Court of Claims. The Ohio Court of Claims could conduct a mediation, or if it believed that a mediation would not be fruitful, could issue itself a binding decision. That's a major departure from current Ohio law, which had a non-binding, completely voluntary mediation process that had a gigantic blind spot in it. The mediation process was housed in the state attorney general's office, which, as is the case in many states, is responsible for defending state agencies. As a result of that, it couldn't mediate any public records disputes involving a state agency. So most Ohio FOI advocates are talking about this as the biggest FOI change in 25 or 30 years. So I'll be curious to see how it pans out, and then I'll circle back and tell you if I think that's something we should adopt wholesale.
It's a deal. All right, questions from the floor? Does someone have the talking stick here? Heather there. And when you speak, identify yourself for the sake of the video. Thank you. And the rest
Hi,
of us.
I'm Heather Brooke. I'm going to talk more tomorrow, but I was really interested to hear what James Hamilton said about the economic balance of FOI. In Britain, where I mostly practice, the journalism has been a bit, there's sort of, the economic costs of doing factual journalism are really high. And one of the things I want to ask all the panelists, in terms of politicians and their view of FOI, it seems very contradictory. On the one hand, they do everything they can to put obstructions in place, and then they also claim to want a thoughtful and sort of in-depth press that looks at factual elements. But by costing out factual journalism, in Britain, they've created a type of journalism which was mainly based on scandal and gossip mongering and celebrity and PR. And so I'm wondering, how can we sort of get politicians to think more in terms of a longer interest rather than holding this contradictory position where on the one hand they claim to want a thoughtful press and yet they put this massive cost obstacle in the way of doing that kind of factual journalism.
Okay, good. Thoughts, anyone? And keep your thoughts concise, because there are a lot of questions in the room, and 20 minutes to discuss them.
My only response is that sometimes I think it's the middle layer of government where the costs are put in, and that if you actually talk to the politicians, if it got to that point, they might not put that many costs into it, that it's a kind of a bureaucratic stasis and less of a philosophical approach to it, but I'm not sure about that.
Anyone else? Jim?
Well, part of the good news about the computer-assisted reporting and the data work that Sarah does is that it does allow you to go from telling the story of a bad individual to a broader story of a bad institution. And so that's what data allows you to do. And in my book, what I do for that is I trace the career of one investigative journalist over 40 years. I actually hired him. He's retired, and he investigated all his previous investigations in his life. And so it was Pat Stith, who was a Pulitzer Prize winner at the News and Observer. So he did over 300 investigations, and 31 laws were passed in North Carolina because of his work. But what I looked at is writing about water quality. In the 1960s, he wrote about water quality by going and looking at a collection of 120 houses in a low-income minority area and writing about that just group of houses. By the year 2000, he was able to write a story about all wells in North Carolina that had been tested and show the inadequate implementation of federal regulations. So what the data does is it allows you to expand the geography of what you write about, and also allows you at a broader, deeper detail to tell the story. So the reason I'm responding this way is that a lot of sensational or human interest stories just talk about a bad doctor, and what the data can tell you is about a bad hospital system or health system. So the good news is when they do invest and use the data, it tells a broader story and can change things.
Okay, yeah.
So,
Get the mic to you, and again, self-identify for the case, for the sake of video.
Peter Strauss, a question for David, which will have a very short answer. Has the New York Times ever gone to the Office of Government Information Services for mediation? And if not, why not?
Yes, we have, and we have in the past found OGIS to be very helpful in overcoming delay. When there's been an inexplicable delay, they have intervened for us, and it's been useful. I am still getting documents from one agency. The reporter has long left. The story's no longer of interest, but whatever O just did scared them, and they continue to send documents.
Okay. Yep.
I'm Bennett Cass, and when I left the Hill, I went on private law practice. I do a lot of real estate, a lot of condominium laws. And I'm interested in what David said about litigation and what you said about the new Ohio law. It's great, but there's a problem. When my condo clients come to me and say, we got a problem with our association, we can't get access to our records, what do? In Montgomery County, there's a wonderful group that allows people to get access. In the District of Columbia and many other states, they can't afford the lawyer. So I think to some extent, some of these laws are wonderful, except they're glossed over, that make the politicians look good, but they know full well that the public can't afford even to go to the small claims court. They need a lawyer, and that's a real problem.
Thoughts, maybe as that relates to small news organizations, and then to Nina in the back there. No? Okay.
I actually wanted to ask a question of Sarah about the problem of getting contracts, and I'm surprised that nobody has talked about the impact of government outsourcing and privatization on the ability to get what really would have been public information before. Detention, prisons, Medicaid, et cetera.
Yeah, it is becoming a big problem, and in some states, we're able to get records because when a private company is doing effectively a government job, they are subject to the law. The government has to get the records back from them, but I think David would probably have a better answer in terms of how that's affected our reporting more.
I mean, it's a huge problem because a lot of these fall under state laws, and a lot of the state laws are very weak about who is a government actor and therefore subject to the public records laws. And you see the outsourcing, and I know you and I have gone down this path in terms of prisons. That they make a contract, and while that private entity is essentially doing government function, they're outside the law. We see it in New York, and we've fought this in several places. Just to give a more banal example, the Central Park Conservancy essentially provides the government services in Central Park except for the policing. And they take the position that they are a private entity, and there's a school foundation that takes the same position. I do think it's a hole, and unfortunately the law has not been very good about filling it.
Okay. Yes, here.
Michael McKinnon, I'm the Freedom of Information Editor for the Australian Broadcasting Corporation. I work with about 1,200 journalists and producers on FOI requests. Just a couple of observations. The reform, I think, that might be useful in our Act, our deliberative exemption is a twofold test. The second part of it is a public interest test. On balance, is it in the public interest to release? Secondly, the importance of FOI. We routinely FOI'd emergency response times in hospitals. They're now released as a matter of course because of the FOI actions that we've taken on that, though we are FOIing to see there's a secret list, and I suspect there is. And finally, on the basis of whether we can appeal, I think up to my 94th or 95th appeal in the court or tribunal, I'm not a lawyer, but the vast majority are settled at the steps of the court where the documents are all handed over.
I just wanted to mention something on the second point, that is something that we as reporters have to do more, which is kind of train public officials that, yes, we're going to come back every single week and ask for the exact same record, and you might as well make it easy because every week you're going to see us here. And when there are important records like that, turning it into a habit is probably the most effective way to get it open.
Yep, sir. Over here.
Hi, Julian Zelizer from Princeton. Someone mentioned this, but how does the ability now to leak massive amounts of documents on the web impact FOIA? Legally, politically, it seems to have changed the nature of the conversation, given what we've seen with WikiLeaks and other, other data dumps. So
I've
this-
had one rejection of which I was able to turn around, but one rejection based on the mosaic theory that used the idea that releasing a public record when combined with WikiLeaks would then result in something bad happening. I don't remember exactly what it was. It was kind of a last-ditch effort to try to not release the records, but I do think that that means that I actually think it's done the opposite. It's made things more secret rather than see that there isn't that much harm when things are released.
Okay. Over here.
Tom Sussman, Washington, D.C. First, I want to just throw out a candidate for the answer to your question about what could be incorporated into the U.S. FOIA regime, and that Mexico has a perfect answer to that with its centralized commission, that with a central portal, transparent handling of requests, the decision to require disclosure, and the ability independently to override agency decision-making. We come nowhere near that with the Office of Government Information Services, but we're on our way. Looking back at the title of this program, of this panel, what difference does FOIA make? There's both last night and this morning, there's a lot of beating up on business use of freedom of information, and perhaps some of the panelists will reflect on what's been my experience for a number of years working in the business community and with FOIA, is that a tremendous amount of information is made public because of business requests. We don't think about it. Customs, public lands, guidance and manuals, inspection materials, SEC and FTC advice and letters and comments. All this, you get this all the time. I mean, it's there, it's published, it's online, but it took litigation by businesses to get it out there. And so I think businesses perhaps should have to pay more. That's Margaret Quokka's complaint, and I agree with that. But to suggest that somehow that's an unintended use, I mean, I always thought that one of the purposes of FOIA wasn't just to disclose inner workings of government, but to uncover secret law. And that's a lot of what business does.
Right, and I applaud the, well, I'm going to be in trouble with some of my reporters, but I applaud the government's push to make documents public to everyone. And so what it links up is corporations have the resources to pursue those things get released. You no longer have to go to Shell and say, could you share those with me, or ask the government, whatever you gave to Shell, give to me. They're going to post them online. The reason I hesitate is, of course, we're in a business of selling information, and we would really like to get the scoop when we do all the FOIA work and get our stuff and write about it first. The government seems to think the public interest should prevail there. It's a little hard to argue with that. And so, and I know it's unpopular to some of the reporters that this release to one is a release to all, but I think in the end, it's in keeping with what FOIA was intended to do.
Okay. Mark, yeah. Please.
Mark Fenster, I wonder if, given the positive experiences that you might have had with bureaucrats, if you could model an agency internal processes and internal structures that would do the best possible job of releasing documents in ways that you wouldn't have to litigate and that you wouldn't have to go to an ombudsman or some sort of mediation for it. What would it look like? I mean, obviously, part of it is contingently finding the right person who might stay in that agency for a while. But if you could model a bureaucracy, what would it look like?
I'll try to maybe turn that upside down a little bit. What I find the most frustrating in terms of us as requesters is the lack of knowledge of their own records that most agencies have, and that you actually have to do all the research for them to figure out what records might exist and what they might look like. So if you could model something that would give whoever is evaluating the request the knowledge of whether or not it exists, how to look for it, and how it might be extracted, And I don't know where that sits in an organization. It might sit better. I mean, I don't know anything about the legal implications of this, but it might sit better in an inspector general's office that knows a lot about the record keeping of the agency, or in an auditing function. But somehow the structure of it would have to be someplace where they would know much more quickly whether or not this was a reasonable request or not, and be able to work with people in order to make it reasonable. And of course, incentivize somehow the release rather than the protection from release.
Okay, Tom Blanton.
Thanks. Tom Blanton. I just wanted to comment on something Julian was just asking about, which is what are the massive leaks? How's that changed FOIA? And I think it's a classic complex situation. It's worked both directions. I sort of disagree with Sarah. It made some things worse. In some congressional testimony, I called it wikisteria, right? Because inside the government, they were telling Air Force officers you couldn't look at the New York Times database anymore because, oh my God, there were classified documents in there leaked by WikiLeaks. It was insane. And it took some folks in the Information Security Oversight Office to say, wait a second, if you're an intelligence officer and you want to do your job right, you better know what's in the WikiLeaks database, because the other folks certainly do. On the other hand, the Snowden leaks has created a night and day openness change in the intelligence community. I mean, I did a chapter in a book called After Snowden, Heidi and Carter and other folks were writing, just pointing out that in fact the government in the 2 years after Snowden actually declassified and published more pages, and they're available online, than all the Snowden partners have so far published. Now, a Snowden page is worth probably 3 government pages because of the drinking game problem that you get all blacked out yourself as you try to read the government stuff. But it's a fascinating thing, and even people who've retired from the National Security Agency say, gosh, I sure wish that we had gotten some of that stuff out before, because we wouldn't be facing so much of a legitimacy problem now. So I'd say with the intelligence community, Snowden has had an enormously positive effect on the Freedom of Information Act and declassification. I think on the wiki cables, there's still this residual extraordinary, it's fed the bureaucratic resistance. And I was just in a session with a RAND Corporation analyst who said, no, his biggest fear was just that the Securocrats were going to come after him if he reads some wiki cables. And that's why I think David needs to add another soundbite to his great briefs on Freedom of Information Act. And that's the one where Colin Powell, the 4-star general, former National Security Advisor, former Secretary of State, says about the intelligence community classifying some of his AOL.com emails. Those were unclassified when I sent them. They're unclassified today. I want them to release them so some air-breathing mammals can check for themselves. Okay. Get it into your briefs.
Okay.
All right?
Any quick closing, either in response to Tom or any other quick closing thoughts?
Yeah, and I think that in terms of the ecology of information, leaks are always going to be very powerful, and David Posen's written about this in eloquent ways. Which FOIA is never going to replace that. It's always going to be down the line from it. But I think it is part of the whole ecology of information. Leaks, actual public acknowledgement, access through the First Amendment to court documents, FOIA, it all becomes of a piece. And as Tom was saying, it has scrambled the deck, because we had a variety of national security requests pending. Things became public because of what Snowden did. When we go to court, we're arguing in 2 different languages, because we're saying what the document is via Snowden. The government's denying it exists.
Okay. I would just thank James Hamilton, Sarah Cohen, David McCraw, Jonathan Peters. Thank all of you. Look, this is a contradictory time for FOIA. This is both an authoritarian time in which agencies are being pressed to close off information, and it's a libertarian time in which there is public sentiment for transparency. So the conversation we started here today will continue, I think. Thank you. We'll take a minute to reshuffle furniture. President Bollinger is here.
Okay, I now want to introduce the President of Columbia University, Lee Bollinger, and First Amendment scholar. Please, thanks for joining us.
Thank you very much. I just want to say a welcome to everybody and say I'm pleased and proud to be supporting this conference. Michael and David, of course, are great figures in this world, and this is a tremendous gathering. So let me just say a couple things about Colombia, a couple of things about this issue. I think it's important to say that there's no more significant area than freedom of expression, freedom of speech, freedom of press, transparency, information, the way in which the public and the academic world have access to ideas, to knowledge, information. All of that space that we think about, it's extremely important for universities to take these issues on. I mean, it's really a very natural kind of extension of what it is we do every single day in every context. It's extremely important that we play this kind of role in the society and in the world of trying to think through these issues. Here at Columbia, I think we have really taken some very great steps. Of course, this school is, is naturally disposed to doing all this, and we have some great faculty, the law school as well, filled with people who are working on First Amendment and openness issues. The engineering school, the data science initiative, the library has a new wonderful database of declassified information, the largest, I'm told, in the country. So if you go around the institution, you have the schools, you have the faculty that are really, really top-notch and working on these. As a university, I've tried to find ways to take these issues on. And you heard last night from Agnes Calamard. This Global Freedom of Expression project is something that I started 2-3 years ago and brought in Agnes to direct. My own view is that this is where the action is going to be increasingly. It's just a globally connected world, global issues, and it's an incredibly understudied, underappreciated area, I think, by American academics. I mean, First Amendment scholars, I think, are simply unaware of these changes that are happening. We look at any First Amendment casebook, any constitutional law casebook, and you will not find mention of Article 19 of the regional bodies. I mean, it's, I think, a whole new world for us. One of the things that is happening there is simply in this Global Free Expression initiative is to create a database, a website where you can go to and you can find decisions throughout the world coming down about free speech, free press, openness, academic freedom, and the like. And the idea there is create a sense of a kind of unity, a body, a jurisprudence that is evolving that people will begin to refer to and think of it as some kind of coherent system in the way that I think we did 100 years ago in creating the area of freedom of speech and press, First Amendment. It really didn't exist as a specialty until about 100 years ago, really 50 or 60 years ago. So I think that's opening up, and we're trying to, really trying to move into that area. And then we just announced, I'm sure you've heard, the Knight Institute at Columbia University, been working with Alberto Ibarguen, the head of the Knight Institute, on this for a year or two. And the Knight Institute is giving $30 million, and we're committing at the university to provide another 5 to get this started, and I'm committing to raising another 25 as a base of endowment of 50. I'm reasonably confident that within a period of 5-10 years, we will have a much larger endowment to work with. And the sense of the world that we have, that's the motivation behind creating this, is that the great decisions that were reached in that 1960s, 70s period, when most of the jurisprudence that we take today is the basis of our notions of free speech, free press, those were often led by traditional, what we now think of as traditional media, who had both the resources and the ethos to drive the litigation and resist and work on the definition of the doctrines. And with the internet and the consequences for the business model of the traditional media, it's not at all clear that the resources are there, although the ethos is still there. If you look at the new media that are on the internet and Facebook and Google and so on, there you have no question of the resources. It's a question of the ethos. Really, are you prepared to go through the battles that are necessary to create the doctrine that will become the tapestry of free speech, free press in the country over time? And the third point is that there is a revolution in communications taking place that changes the reality in which these doctrines and laws and policies and so on have been created and will be created, and we need a place that is lodged in a university that has that kind of infinite sense of perspective of being permanent, objective, nonpartisan, willing to fight for these values and to be sophisticated about them. And over time, we think that the combination of really great research and a willingness to act in the form of serious litigation will be beneficial. So if you look at Columbia and you look at this great conference and the scholarship that's done here, the outreach, the work, the law school, all the places I've mentioned, and these university-wide initiatives, we hope this is a place that will be a meaningful player. And the second thing I would say, and the last thing, is that I think from my perspective, if under the First Amendment, the right of access is sort of the missing pillar for free speech, free press. I don't know quite, my own sense is that happened because it arose in a period where there seemed to be a kind of waning of enthusiasm, that is in the 1970s and early 80s, a waning of enthusiasm for new doctrine and developing constitutional values. And that was too bad. It's there. I think it's, it's one of the interesting things when you look globally, because the United States is something of an anomaly in that. That is, right of access around the world is a much stronger, I think, kind of part of freedom of speech, free press. But it's the missing pillar. And so, what you're talking about here is really important in that sense, trying to build up that pillar, I think. The related point I would make is, as it was just pointed out, in the sort of complex system of disclosure of access to information, Pentagon Papers is where we look for one major dimension of that. And it has seemed fairly clear to me over the past 5 to 10 years that the conditions, the underlying reality that gave rise to Pentagon Papers has very significantly changed. And it poses a question that it seems to me we'll be facing over the next decade of, have the balance of interests on this that led to Pentagon Papers, have they changed in such a way that the system we set up, that messy, chaotic system of the government, can keep whatever it can get away with, and the leakers can act, but they're not protected, and the press will be protected, at least against injunctions, etc. Whether that system really makes sense in a world in which it's not Ben Bradley who is making a decision about what to publish, but Julian Assange, and whether it's not a few pages, but millions and millions of documents. And I just think that that will be a crucial kind of question, and intimately related to that will be, is there a coherent way of getting access to information in the society that is not as much through the kind of leaking process? And the FOIA world is that world. So it seems to me that what you're thinking about here has all these radiating kind of consequences for the bigger issues of free expression, freedom of thought, freedom of the press. And I think it's also clear that of the areas we might select to really move in this Knight Institute and Global Free Expression, this area of access strikes a number of us as extremely important and promising. And so we would welcome any thoughts and ideas you have coming out of this conference for that purpose. Thank you very much. Thank you.
I don't care. This is fine. Just either end. Put me on an end. Okay. What time are we starting? In 5 minutes? Okay. All right. Okay. Hi, Julian's all.
Where am I sitting?
Getting a picture. Yeah, of course. Thank you so much.
What time are we ending? What time do we end? 10 to 1 or 1? Okay. Sure. Sure. Don't worry. Why don't we start with you?
Start with me?
Yep, and then Benny, and then Tom. Thomas.
Okay, if you could retake seats. The next panel is about to begin on the oral history of the Freedom of Information Act.
I think it's optional. People have been sitting, but if you prefer to stand, feel free. I don't care. Okay, everyone, we're going to get started now. This is our oral history panel, the origins of FOIA. I'm Julian Zelizer of Princeton University. And our panelists today, let me just quickly introduce them. Morton Halperin of the Open Society Foundation, also worked for several presidential administrations and other organizations, who was involved in the passage of the 1974 amendments. Benny Cass, who was legal counsel to Representative John Moss during FOIA's enactment, and Thomas Sussman, who worked with Senator Kennedy during the 1974 amendments. Unfortunately, Bill Moyers can't be with us today. He had some cataract surgery, and he wasn't up to it today, so he sends his apologies. Before we start, each person I asked to just share a recollection, a story, something from the period in which they were involved on this issue, to give us some insight into the legislation and its history. I just wanted to start by kind of putting out, I think, 5 principles that have been important since the start of FOIA, that put some context onto what the founders were trying to do, and those who continue to defend it have been trying to do. The first is very simple, that access to information is essential to our democracy. This is a principle that was very important in the 1960s. The legislation is passed during the Cold War. And if you read Michael's terrific book, he really highlights how central that was to a lot of the debates. This is very much a mainstream sentiment, that this was part of what made our system distinct. So from opening the White House to the public many decades earlier, to providing information to how we make our decisions and what the debates were, this is part of what American democracy should be. A second is the principle of the right to know, which is a very important and powerful political value. And I think overall the supporters argue that even if problems emerge, as Cass Sunstein talked about last night, which are familiar critiques of openness that makes negotiation difficult, on the whole it's better if citizens, journalists, activists, organizations from business to environmental groups can see how things happen, why they happen, and what happened. We will be better off, and this is a right that should be protected by the government. And there's many examples, as we heard last night, where it's very evident the added value of being able to find this out, and not just a check against the abuse of power or corruption, but simply to have a better qualitative understanding for journalists, historians, writers, and again, average citizens about how we've reached our decisions. A third is, it's not a surprise this legislation comes in the 60s and is amended in the early 70s. It comes out of a distrust of government officials, which is not imagined and made up. This comes in the context of Vietnam and the Pentagon Papers. It comes in the context of Watergate. It comes in a context where many Americans learned that when public officials tell you, trust me, believe me, this is how it happened, the journalists got things wrong, there is reason to believe that they are not telling you the truth. And this gave a lot of bipartisan power, certainly in those decades, to FOIA and its expansion and strengthening. And I think today it still very much remains an important part of the debate. I think that came out last night in the debate that took place. And that's some of the skepticism probably for some of Sunstein's critique of what FOIA does today. The discovery of the Church Committee in the mid-1970s is yet another backdrop for why this legislation continues. A fourth is that information is about power in American politics, and we can't forget this. It's not a surprise that Donald Rumsfeld, who was part of Rumsfeld Raiders in 1966, a group of Republican renegades who were challenging the power structure of Washington right alongside liberal Democrats, believed that access to information could change the dynamics, certainly in the White House, but in different ways, not with FOIA, but with other sunshine reforms on Capitol Hill. Controlling information, being able to restrict information has always been fundamental in political battles in Washington, D.C. And so often for partisan reasons and often for different causal rationale, FOIA has been part of this effort to prevent monopolies on knowledge. This is really, I think, pretty important to what the whole program has been about. And finally, and here I'd probably disagree a little with last night's presentation, I actually think FOIA in part aims to protect public officials, not harm them. And I think this is especially pertinent based on my comment in an age of WikiLeaks and in an age of Snowden files, that there is a value to being able to actually look at the record of what happened. And there is an incentive for officials not to evade creating a record that ultimately can be released, but putting their decisions down on record. And I think overall, obviously in 1974, it didn't work this way for Richard Nixon, but the benefits of the recordings, the presidential recordings, have given us a much richer and more complex understanding of the Nixon presidency, of the Johnson presidency, and the Kennedy presidencies, that if we didn't have that record. And I think FOIA shouldn't just be seen as a tool, an adversarial tool for public officials, but it's actually a way to get an accurate record, an accurate basis from which then to evaluate how things went. And I think in this current media age, not media age, in this current technology age, when you're going to have leaks and this information's coming out, you can try to hide it all you want. I think in some ways FOIA becomes all that much more important for government officials. So we're going to go in the order of the table, and I'll turn it over to you.
Thank you. It's a great pleasure to be here. I want to talk about the national security exemption as it was amended in 1974. As we heard earlier today, the original assumption, I think, in the original act that we're celebrating at this conference was that national security was really not covered. It was a kind of throwaway line. Of course, things that affect our national security should be kept secret. Nobody expected, least of all the agencies, that the national security agencies, that they would really be covered. And anyone who made a request before 74 for national security documents got a letter back saying, thank you very much for your request. We're very busy, and if someday we're not busy, maybe we'll look at your request. And nobody really expected very much to happen. But three things came together which made it possible, I would argue, for the first and last time in our history to do something legislatively about the exemption for national security information in the Freedom of Information Act. One was that there was pressure to amend the act in other ways so that this process was moving forward and there was a chance, therefore, to do something about national security. But much more important was the era that we were in. We had, for the first time in our history, a president who had not been elected by the American people. We had a president who had been driven out of office in part because he had used national security claims to hide various kinds of illegal activity. And this was, as I suggested, I think the only time in our history since the Cold War at least, in which the Congress of the United States was willing and able to pass legislation over the objections of the president and the executive branch where they claimed that the enactment of the legislation would harm national security. Congress passed several pieces of legislation, the War Powers Act, probably the most notable one in addition to the Freedom of Information Act. It has not been willing to do so since, as Watergate receded, as the intelligence scandals receded. The legislation that was passed afterwards relating to national security always was passed by a compromise between what the FBI, the CIA said they needed and what the public interest community wanted. This was the only occasion when it was possible not to do that. And the third thing that brought it into very sharp focus was the Supreme Court decision in the Mink case, which basically said that the FOIA as written, and I think it was a correct reading of Congress's intent then, basically said that the courts, specifically said the courts cannot look at documents in camera, that was no part of the process because the only thing the court had to do was to make sure that the government thought that it had properly classified the information. And if the government came in and said, you have properly classified this information, that was the end of the process, and therefore essentially the Mink decision said that there is no court reviewable right of access to national security information. And so we had a point where the Congress was willing to take this on, but it wanted to do so in a way that did not lose its ability to enact the overall legislation, and therefore it meant either bringing the executive branch along or having enough members of both houses to override a presidential veto. And overriding a presidential veto where the president is saying this harms national security is, I think this is the only time that's ever happened, certainly in the period since World War II, this is the only time that has ever happened. Now, an in-camera review, it turned out it was possible to reach an agreement with the executive branch on this, and that happened pretty quickly and was embodied in the legislation as it came before the House and the Senate from the committees. Tommy, who's deeply involved in this, may have more to say about that. But basically, the compromise that was reached was to say that if the court was persuaded by government affidavits that the information met the standard, then it did not have to conduct in-camera review. That in-camera review was not essential, that did not have to occur. But on the other hand, the legislation made it clear that the court had the right to insist upon in-camera review, and that if it was not satisfied by the government's explanation of why the information met the standard, that the court should look at the documents in camera in order to be able to make its own determination. The second thing that was agreed to quickly, almost as an afterthought, and was touched again on this morning's panel, is not to try to write a standard. For every other exemption in the Freedom of Information Act. The government said, the legislation says it may be withheld if it'll interfere with a law enforcement investigation or violates trade secrets. The Freedom of Information Act on national security information simply punts to the executive branch and says information properly classified pursuant to an executive order, which means that Congress isn't saying what the standard should be, and also that Congress is leaving it to the executive branch to change the standard. And a change in the executive order changes the standard under the Freedom of Information Act. As far as I can tell, nobody proposed trying to change that. The fight was about the third issue, which is what was the standard the court would use to decide if the information was properly classified pursuant to the executive order. The government's initial position was, we'll tell you. And if the government says we have properly classified this, all the court should do is ascertain that the government had in fact said that in a proper form. The position that the advocates wanted and that the senators and the House members were supporting was de novo review by the court of the decision, that the court would look at the information the government had, would hear the government's argument, and would decide de novo whether the information was properly classified, that is, whether it met the standard for classification in the executive order. The government then was willing to compromise with reasonable basis, that is to say, information can be withheld under the first exemption if there is a reasonable basis for concluding that the government's decision that it met the standard was correct. And some version of that was in fact in the legislation as it came before the Senate from the Senate Judiciary Committee under Senator Kennedy's leadership. There was strong concern in the Senate, led by Senator Muskie, that the standard gave too much deference to the executive branch. And there was therefore an amendment adopted with overwhelming support, with warnings, as always, we will lose our veto-proof majority if we do this, which adopted the de novo standard. And the de novo standard had also been adopted in the House. And therefore, when the conference committee met, it really did not have a lot of space. But it had a letter from the President of the United States saying he would veto the legislation because the legislation as written provided for de novo review, which was, of course, both unconstitutional and bad policy, and therefore would require a presidential veto. He threatened to veto on two other issues as well, but I think the focus and the crux was on the national security issue. So the conference committee was trying to figure out how to avoid a veto, or to make sure it had enough votes to override it, but confronted with the fact that it had the same language essentially in both houses. And so the compromise, as always, was to say something in the conference report. And I was then working for the ACLU. Tommy was working for Senator Kennedy, and I remember to this day him contacting me. I cannot remember, maybe he does, whether it was a phone call or in person, to say that the administration was asking for a paragraph in the conference report. And it required, I'll read you the sentence, accordingly, the conferees expect that federal courts, in making de novo determinations, will accord substantial weight to an agency's affidavit concerning the details of the classified status of the disputed record. And Tommy asked me whether I thought, that was acceptable. And I remember making one of many predictions which turned out to be very bad. I said, I think it's okay, because we have two things in it. One, it repeats de novo review, makes it clear that it's de novo determination, and says that it should accord substantial weight. And I said every judge is going to accord substantial weight, whether or not we put that in the document. So that that language was put in the conference report. The bill went to the president. He vetoed it. There was then an override in both houses in which everyone was very clear that the president had vetoed it because it had de novo review. The opponents of those wanting to support the veto said they were against de novo review. The sponsors of the bill said we should have de novo review. The bill was enacted over the president's veto, and of course, the executive branch immediately announced that there was no de novo review in the standard at all. And much worse, the courts went along. So that when asked about what happened, my quick answer is we won in the Congress, but then we lost completely in the courts, and we always lose in the courts, but we always end up winning, or often end up winning. And what I mean by that is the courts have continued to say no de novo review, and they've gone to extraordinary lengths. My favorite one is the case that the ACLU brought on my behalf for the names of the National Security Study Memoranda for the first 9 months of the Nixon administration. And one of them was France after de Gaulle. And I offered an affidavit that said that I was the one who had named that study memorandum, because I was on the National Security Council staff under President Nixon, and that I was the one who had classified it. And the reason I had classified it was that General de Gaulle did not concede that he was mortal, and therefore would be very insulted if we were doing a study called France after de Gaulle. But that now that de Gaulle was dead, most Frenchmen acknowledged that this had come to pass and that no harm would result from releasing the document. The court's reaction was that that it was irrelevant what I thought, that deference to the government meant not asking anybody else, no matter what their expertise and experience might be, as to whether the document was properly classified or not. It remains to this day the case that not a single document on national security has been made public over the objections of the government by a court order. That's the bad news. The very good news is that, in fact, the National Security Archive is full of documents, as are other places. The Act, in fact, works for national security information. Vast quantities of information come out, some of it when requests are made, other times when lawsuits are filed, other times when judges start mumbling that they don't understand this. The government releases the information because it is determined not to lose. It is determined not to get an adverse decision. And so, in fact, the Freedom of Information Act now is used for national security information. It is extremely important to public understanding of it, even though the courts remain reluctant to apply de novo review.
Thank you.
Thank you. I'm going to start back. I arrived in Washington in the summer of 1968, and Benny will pick up from before that point. But I went to the Justice Department to give agencies, I worked giving agencies advice about how to comply with the new act. And that colored my thinking. It'll set the stage for what happened when I got to the Hill. And one of the agencies that came to the Department of Justice for advice was the Veterans Administration that had been testing hearing aids. A request was made by Consumer Union for the data generated from those tests, factual information. And VA said no, because the manufacturers give us those hearing aids for free, and they wouldn't give them to us if we made the data public showing that some of them didn't work. Okay. Or at least were not as good as others. And so we told the agency, oh no, there's no exemption for getting free hearing aids, and there's no issue of exemption for, you have to release it. And the agency said, okay, thank you for your advice, and they refused to release it. They got sued and immediately lost. So I got to the Hill with that backdrop, working on the Administrative Practice Subcommittee for Senator Kennedy with jurisdiction over Freedom of Information and the Administrative Procedure Act. And it was fairly clear by then that the research that I had done on where things were by the early 70s is that the law wasn't working. Ralph Nader came up to visit us a couple times and wrote an article in the Harvard Journal for Law and Policy saying the Freedom from Information Act was the title. And we were getting reports back from all of the advocacy groups that delay was a serious problem, costs being imposed, $10 a page from the Selective Service Commission. Various things that were just really egregious. And I want to stop and sort of note that during that time, I was on the receiving end of some phenomenally useful and interesting information, anecdotal for the most part. We didn't have the kind of research that's been presented here, that's been done since then, empirical, using metrics or algorithms. It was all individual stories, but they were pretty phenomenal stories. Mort was there, Ron Plesser and Mark Lynch for the Nader's Public Citizen Litigation Group. John Shattuck was at the ACLU. Dick Schmidt for, I think, newspaper publishers at the time, and the American Bar Association, which testified, proposed legislation, proposed amendments, was very much involved. And on the staff, the main Senate staff people were Harrison Welford, who was working for Senator Hart at the time and developed the 7th exemption amendment on the floor, and Jim Davidson, who was working for Muskie, the national security issues there. And so we had hearings in the House. Carlos Moorhead had taken over from John Moss by then, and we began hearings in the Senate, really pressed on us by all of the advocacy groups and the media. Okay. So I think Mort has identified, national security is interesting. That was an important issue for the National Security, Center for National Security, for the ACLU. It didn't loom so large, either within the Senate or House and Senate. As Mort said, the House quickly amended the first exemption. They thought that was an easy one. We had to back off in language, in report language, but we were able to keep it. The two more visible, the three more visible fights were time deadlines. The agency said, we can't possibly 15 days, we can't possibly 20 days. How about 60 days? I mean, these just are impractical. We can't do it. We had an interesting hearing where we had the Defense Department witness testify, and as one might expect, that was a great idea because, yes, sir, we can do it, and they do, and they did. And so, when the Defense Department, the largest agency, they also had a lot of resources to devote, said that they could handle the deadlines. That kind of gave us a standard to go by. The seventh exemption didn't loom so large in the public arena, in part because the Attorney General, Elliot Richardson, had testified and adopted or adapted some proposals that the American Bar Association had made that there could be criteria for application of a seventh exemption. The battle in the seventh exemption, law enforcement at the time files in the original Freedom of Information Act, the battle was in the committee. And in those days, the committee met behind closed doors. So we made but one proposal to amend the seventh exemption. Change the word files to records. Okay? There had been a lawsuit, I think Carl Stern's lawsuit, where the agency responded, the FBI responded that yes, of course it had files, but those were law enforcement files, and we don't have to. That's the end of the issue. And the court, the D.C. Circuit said, well, that is what Congress said. They used the word files, they used records elsewhere, so that should be the end. So we suggested that change. Senator Haruska, talking to the Justice Department, thought that was not unreasonable, and so we went into committee expecting that that would not be an area of disagreement. It turns out the FBI had given, and I was sitting in there, smoke-filled literally at that time because Eastland, Tunney, and Kennedy all smoked cigars in the executive sessions. Only staff was allowed in if you were working for the chairman of the committee, Eastland staff, or you had a matter before them, which I did, and Doug Marvin for Haruska. And I noticed McClellan had a white piece of paper, no watermark, no letterhead, that he proposed an amendment to change the word records back to files, and he had talking points. And those were given to him by the FBI, and we later learned from the wonderful memoranda that Tom quoted from yesterday that I got under a joint sort of FOIA Privacy Act request in the 80s asking for everything on me, and these memoranda all came out of great detail. I guess you would call them input transparency of the discussions within the administration and with Eastland and with Sussman and Kennedy and people of his ilk that would never agree with anything that we want and so on. Right? My ilk is not catching. I've grown out of it. But that really, because McClellan proposed that without any notice, he lost the amendment in committee, and that sort of led to a break between the administration and their discussions and the majority at the time, the Democrats. And so we went to the floor without administration support for the bill, freeing us up for amendments. Two of the amendments being the Muskie Amendment on to strengthen classification review, judicial review classification, and the other being the Hart Amendment, putting most of what we now have amended again in '86 for the law enforcement exemption. One thing that sort of doesn't come out, you think back now, wow, those are really major, important issues. That really must have taken staff and members' time and energy. I turned out, I went through my cron files from my basement, which I have, from that time period, okay? And I mean, some of you are probably too young to remember carbon paper. Cron files, one of them I dug out, Dear Professor Emerson, the Senate and House are locked in conference dispute over the Freedom of Information Act, asking for advice from various people. What was this all about? Sanctions. Okay? Probably I see a lot of heads nodding because you know it's in there. It turns out that was the most contentious issue. All right? The House didn't want it. Nader wanted criminal penalties, and Ralph kept coming back with those. And we had lots of negotiations. In fact, I had one of my little memos is from a guy who was working with me at the time, a young Harvard law professor who was doing airline deregulation for the subcommittee, who came up with an idea of let's have the courts impose the penalties but make them lower. And I told Professor Breyer that was a crazy idea. And so we ended up with a lot of compromise in that area too, before the sanctions, and we did get sanctions in the bill. And you say, well, what a disaster, that's never been used. I found a little note in a speech Senator Kennedy gave in February of '75 to a Ralph Nader gathering. He wrote then, or I wrote then, during the debates, the Congress referred to the new sanctions section as being designed not to punish, but to ensure that federal officials learn about and later follow the requirements of the law. From the crowd here today, it appears this objective is being achieved. So in some ways, I mean, I think the organization of the Association of American Society of Access Professionals grew out of the professionalization of the FOIA staff, grew out of a fear of sanctions. The educational program in the Department of Justice, I was part of the first one. They brought me in to debate or to discuss with Mary Lawton, who was in Justice at the time, the sanctions. And so, I think you can call it a failure in terms of it's never been used, but perhaps a success in terms of its effect that government officials now learn about the FOIA. Mort mentioned another failure, which was the thought that courts might someday look at classified information and decide they shouldn't be classified. And there's a third area which I'm very proud of. 99.8% of what we did with the 74 amendments. Congressional budget process required us to put a number. I see Blanton smiling because I've used this before, okay? What would the new amendments wind up costing? What's the Freedom of Information Act going to cost to, with all the time deadlines, attorneys' fees, okay? Segregability, so they have to now go through and segregate disclosable from non I came out with a number. What would you guess? 50 million? Nah. $100,000. I should end on that note. Sometimes you're wrong. I will confess that it was just a guess. And what a bad guess it was.
Thank you. Thank you.
You know, I appreciate this. As you get my age, you tend to forget a lot of things. All this has brought a lot of memories back. Michael's book has been fantastic. It reminded me of things that I didn't even remember what John Moss did. Talking about Ralph Nader, by the way, one of John Moss's deep regrets. Ralph Nader, a young lawyer, came to me, 62, 63, whatever it was. He's got this problem with the car loan, car deals, car things and everything else. I told Moss, I don't have time to do it. Go see the Senate side. We lost Ralph Nader as our client, as our person to be our lead. Brief background. I graduated from Medill School, sorry, talking about that, School of Journalism, Northwestern, 57. My journalism law professor was Jacob Scherer. He also taught typography. Does anybody remember what typography is? I can't remember. Bolito invented italics type in 1784 or something like that. I remember that, so back from journalism school. Jake Scherer encouraged me to go to law school, which I did. I got to Washington. I took the bar in Washington because they said it was the easiest bar to take, and I passed it. And I worked for the Maritime Administration, and to get out of the draft, I joined the Air National Guard. So to make a long story short, my Air Force unit was called up. I fought the Battle of Suitland Parkway. If anybody knows Washington, that's from Washington to Andrews Air Force Base on Suitland Parkway. I was bored to death, and by the way, interestingly enough, our general, there was an inverse ratio of rank. Our general didn't graduate from high school, I don't think, and the guy who couldn't get one stripe, Airman Basic, had a double doctorate, but that's neither here nor there. We had more doctorates and more lawyers in our unit. But anyway, I was bored to death typing stuff, and I decided to call John Moss because I'd heard so much about Moss because Jake Scherer was the first counsel to John Moss. So I called John Moss's office, and I said, I was a student of Jake. Any student of Jake, come on, I want to talk to you. I don't remember if I wore my uniform or not, but I walked into John Moss for a 15-minute interview. An hour and 45 minutes later, he offered me a job as counsel. I'm 24 years old, 25 years old. I mean, this is amazing. I left the military, got out, went to the White House, I went to the Hill, and the very first thing I got was a call. Sam Archibald, who was our staff director, and Jack Howard were off on some junket, and Pierre Salinger called, we got to see Moss immediately, or talk to Moss. Please come to the White House. I have to ask my secretary how I get into the White House. I talked to Salinger, and Salinger said, we are about to put an embargo on Cuba, and we want to keep the press happy, and I know Moss loves the press, so I want you to be a kind of a monitor of what's going on, and if you hear any problems, let us know about it. And then he told me an interesting story, which you may have heard. He said, just before we signed the embargo, I sent somebody out to all the cigar stores to get all the Cuban cigars for President Kennedy. John Moss was an interesting person. He was not an intellectual in any way, shape, or form. He was a pragmatic person. The Sacramento Bee used to joke, the paper there used to joke that if John Moss robbed the bank, our headline would be, John needed the money. They loved him so much. He got interested in what we used to call silly secrecy. We've had some examples here. He was so involved in that in the mid-50s. He and, by the way, he and Jack Kennedy were freshman congressmen at the same time, so they became very close friends. he had read Harold Cross's book. He brought Jake Sherrod to be his counsel. And Speaker McCormick was so impressed with the way he had been pulling out of information from the Republican administration in the 50s that he created this special committee called Government Information Subcommittee under the Government Operations Committee. He was an up-and-coming congressman, and that's how he started. And when I got involved, we were involved in what we call the silly secrecies. Example, the Navy telephone book was classified. No reason for it. The most interesting example was Business Week was classified. Why? Because there was an article that some reporter had written about a jet airplane that was still classified. I went over to the Bureau of the Budget to talk to the head of the Bureau of the Budget to ask him why he did that. An interesting side story. All of a sudden he said, quick, grabs me, runs me into the men's bathroom. We looked out the window. President Kennedy was landing in the helicopter in the whatever it was, and he was impressed, and I was impressed. There was President Kennedy coming out of the helicopter. Side story, but just a little story. When John Moss started to get involved in the FOIA, I was on the House side. He and I went to see Manny Seller, chairman of the House Judiciary Committee, because we wanted the bill to come to the Government Operations Committee rather than to Manny Seller's Judiciary Committee. And we had a discussion, and Manny said, John, you're great. I think you can have it. I won't object to it. And then he said something that I'll never forget. When you lie down with dogs, you come up with fleas. And John said, what do you mean? He said, be careful. Be careful of where you are going to be going with freedom of information, because it's not a popular subject with the administration. Democratic administration, by the way, at that time. So we started the whole hearings, and Tom talked about carbon. I once had a young temporary secretary, maybe 18, 19 years old, and I said, can you make a CC of that? Send a CC to so-and-so. What's a CC? It's carbon copy. What's carbon?
Right.
We didn't have cell phones. We didn't have internet. So here's a document that Sam Archibald and I wrote for John Moss's opening statement on March 30th, 1965, on the first hearings. We begin today introduction to establish a federal public records law. The bills are based on many years of study in the House of Representatives. And this, to me, we talk about national security. The legislation before this committee has been proposed to fill a legal void, a void in which the executive agencies have moved because of the ambiguities of the only general information laws which Congress has passed. I know that no one supporting the legislation would want to throw open government files which would expose national defense plans to hostile eyes. I do not believe, on the other hand, that government employees have any desire to impose the iron hand of censorship on routine government information. These two extremes are obvious. Our task will be to work out the details. We held numerous hearings. Whoever said earlier that one agency did support it. 3 minutes left. Oh, good. Thanks. We had one reporter who was opposed to it, Clark Molinoff. Clark kept telling us, very prominent reporter in those days, Clark kept telling us, when I get it, it's news. We disagreed with him, but so be it. With the 3 minutes left, let me talk about where we were. In '65, I moved over to the Senate Judiciary Committee under administrative practice. Said Kennedy, I won't go into details of privacy. Senator Long, who was chairman at the time, was more interested in privacy rather than freedom of information. One of the reasons I was not, Tom took my job because my committee was investigating privacy of Bobby Kennedy, and when Ted Kennedy came in and said, Benny, you're doing a great job, but
Adios.
goodbye. Anyway, I'll give you 6 months, he said, goodbye. So, anyway, to make a long story short, Ed Long told me, in no uncertain terms, go back and talk to John and tell him, we ain't going to amend the document, the FOIA. You take it as is, we can't do it anymore. So I had no choice. I talked to John Moss. John said, all right, what can we do? So then, in the meantime, the Justice Department got involved, and we were dealing with them constantly. I'm going to embarrass my daughter who's sitting over there. April 25th, 1966 was a very, 66? Yeah, was a very important day. She was born, 6 in the morning. The doctor said, your wife's fine, baby's fine. Your wife's not going to be able to see you for a couple hours. I said, great, because I have a meeting with John Moss and Nick Katzenbach, Attorney General. So I'm proud to say the first cigar went to Nick Katzenbach, the second one went to John Moss. They made it clear they did not want us to pass that bill, and we told them we can't do it. We want to pass the bill. So then Frank Rosencraft, who was, I guess, your boss at that time, and I had many, many, many discussions back and forth, and they ended up preparing a report which we all know is part of the history, and the bill ended up going to the floor of the House. Kenneth Culp Davis, professor of law at Chicago Administrative Law, has written a wonderful comment that said, in most cases, when the law is unclear, you look to the legislative history. With FOIA, when the legislative history is unclear, you look to the law. and that's the truth. Now, what happened on the floor? John Moss called me and said, Benny, can you come and sit? And he got permission for me to sit on the floor because he wanted me to answer questions. He did not have a counsel at that time on FOIA. And the bill was introduced, and John made a presentation and talked about it. Everybody else got up. And I can't remember, but we must have had 20 to 25 members of Congress come up to John Moss and say, John, it's great, but does this apply to us? And John, who I don't think had a real sense of humor, pontifically stood up and said, absolutely not. The First Amendment, the Constitution separates Congress from the executive, and therefore it does not apply to us. Fine, we'll vote for it, that's fine. So then came the interesting thing. Sorry Bill Moyers is not here. I hope he had a legitimate excuse rather than he wanted to be embarrassed because of what Lyndon Johnson said. We spent hours and days and I don't know how many times from the time the bill was enacted by Congress, and we didn't have to have a committee report to my knowledge, a committee conference. I was on the phone. Again, we didn't have emails, we didn't have cell phones, everything else. I was on the phone, and John Moss was on the phone constantly to every single publisher in the country to send wires to get in touch with Lyndon Johnson's office and Bill Moyers to sign the bill. Bill Moyers, the president was going to let it be a pocket veto on July 4th. It wasn't signed on July 4th because of its July 4th national history. It was signed because that was the last day that he could sign it. And as was pointed out last night, it was not even on Lyndon Johnson's calendar. I have to wrap up, but finally the bill was passed. John Moss died. He had other benefits also, other things. I mean, he fought auto safety, he fought the television scandals and the quiz shows and all sorts of other things. But anyway, he did have one sense of humor, I thought. He called me once from I hated working for him because he was in California, and I had to sometimes talk to him at 9 o'clock at night because he was still working. He called me one day, Benny, I just finished reading the first Attorney General report on smoking. He was a very heavy smoker. And I got so nervous I had to have a cigarette. I don't know whether he was joking or not. But the bottom line is the Freedom of Information Act was enacted, and as far as the policy, we know all the problems, but we didn't have a choice.
we were told, take it or leave it, and that's what you can do. Sam Archibald was our staff director, and I'm always intrigued by one of his comments, which I think is relevant. Sam used to walk, we used to go to lunch, and there were signs sometimes, United States property, no trespassing. And Sam would say, hey, this is our government, this is our property, why can't we trespass on our own property? And you know, and that's the attitude that we still have in this case. I just learned the other day, I don't remember the agency, there's a new, apparently the government's adopting a new exemption. Something to the effect that since people pay for the material, we can no longer release it free. I can't remember, I think it was EPA, but I don't remember. I hope somebody would find that out. I heard it on the radio and I unfortunately couldn't do it. And I'm fascinated by a clipping in the Washington Post of March 2016. A reporter, Justin Elliott, has waited 2 years to get an FOI Act from FEMA, and he has a sign, this is March 13th, this office has gone 492 days without releasing your document. Thank you very much.
Okay, questions from the floor. Raise your hand and...
Can I add one more
yes.
point? Because I was talking about John Moss. A number of us who work for John, either in the FOI area or in other areas, commerce, after he died, we created the John Moss Foundation. We unfortunately ran out of some money and things like that, so it's really not operating. But Sandy Benson, his staff, has set up a marvelous website, the John Moss Foundation. Look it up. There is a wealth of material from going back. Kathy Benson, she just saved everything that she possibly can, and it's all on the website. When I was doing some research on that, I found Bill Moyer's statement that he made. I found Bill Moyer's press release that to the president, Bill Moyers has approved this type of thing. It's a wonderful document. I don't remember the website, but you look at it, John Moss Foundation.
Yeah,
you could jump in.
Okay, yeah, just on the veto issue, most of you probably know that if Bill Moyers were here, he would say that President Johnson had two statements before him on the 4th of July. One was a veto, it wasn't a veto message, it was a public statement as to why he allowed the bill to be pocketed, vetoed. And the other was a signing statement, which we now, everyone quotes from.
Yeah.
As if, you know, this was you know, given to us from heaven. One of the things, curiously, in terms of history repeating itself, I found among my old files a September 74 memo from Tommy, which Senator Kennedy called me, to EMK, that basically says, Timmons has a 2:30 appointment with the President Ford today to get a final decision on the FOIA amendments. I told Haruska, Gurney, and Thurman that you'd call up the conference report today. I will have alternative statements for you, one if they sign, the other if they don't. So, I mean, it was quite up in the air. Most of you know the 74 Amendment veto was overridden in the Senate by actually, I think, 2 or 3 votes, but it was really one because Senator Hugh Scott had said that he would vote to support the president if his vote made a difference, and it turned out it wouldn't have because it would have been a 1-vote difference.
And by the way, the New York Times on July 5th, I believe the first edition, maybe the whole, had a story. It's not really a withholding of the under FOIA, but a story about how Bill Moyers had withheld that first press release, and he wouldn't release it.
Hi, David Posen. Mort, you spoke so interestingly about the practical failure of de novo review in the national security context. I think it bears note that that failure transcends the national security context. Paul Verkuel has a well-known empirical study where he found the federal courts affirm agency denial decisions at about a 90% rate across the board, which is a much higher affirmance rate than the rest of administrative law, which ostensibly has deferential standards of judicial review to the agencies. In the one area of FOIA where we have a de novo standard, we have this remarkable win rate for the federal agencies. So I think it's an issue that goes well beyond national security, and I wonder if that might color some of your analysis of what's happening in the national security context. What do you make of the fact that judges across the board seem to be, in practice, so deferential to agencies in all areas of FOIA?
Well, I think judges are like people. And they ask themselves, how can I get into trouble here? And if you refuse to release information because the Secretary of Defense says releasing it will harm national security, you're unlikely to hear a lot of complaints from whoever you care about. On the other hand, if you release a document that the government says its release will cause harm to national security, and it's released and there's harm to national security, you hear from a lot of people. And so their natural tendency is to say, this could not have been what the Congress meant. And it applies, of course, to disease and everything else, not just to national security. This could not have been what the Congress meant, and if they meant it anyway, so I'll apply the Novo standard, but I'll turn out the government was right and they persuaded me. I don't see any way to make that much better. But on the other hand, the truth is, not only in national security, but in every area, we get vast quantities of material. So I think the desire not to lose on the part of the government, the fact that judges are always coming close because the government is making absurd claims, keeps pushing things out. As I said from the floor, I think the most important change to make is to add a public interest override, because I think judges are much more willing to say, I accept your description of the harm, but I've now compared it to the value of this information to public debate, or the right of the public to know that the government tortured people, or knows hospitals are doing terrible things and won't tell us. Judges, I think, are much more comfortable and much more likely to do that than to say, oh, I've heard what the Secretary of Defense or the Secretary of Homeland Security said, but I have my own opinion of that.
I'd just like to, it's Greg Mitchner from the FGB IBAPI in Rio de Janeiro. I'm going to be presenting tomorrow, and I'm going to talk about some of the things that I'm going to ask right now. But I just wanted to thank you. Very interesting, and I think one of the things that attracts us all to this history is that this is real high political drama. I mean, pocket vetoes and veto overrides. This is spectacular. And the archetype that the United States has presented over the last 50 years in terms of variation in the strength of the law, from typically stronger during divided government, strengthening reforms during divided government, and then shutting down and closing during unified governments, especially Bush 1. I would just like your comments on this, because this hasn't been remarked, and it is also the archetype for laws around the world. Mexico has had a divided government, has a very strong law. Since '97, divided government. Argentina still does not have a law and has had unified government until this year. And so this is a sort of, it plays out very uniformly, and I'd just like your comments upon this, how the differences in unified and divided government, whether you believe this really is as patterned as it looks on the international level.
Yeah, I think it is. I mean, when the U.S. passed the Freedom of Information Act, except for the Swedish law that Tom likes to call to our attention, it was the only one. I used to debate a guy, an ex-CIA agent, and he would always say, the CIA is the only intelligence agency in the world subject to a Freedom of Information Act. And I would say, yes, but the Agriculture Department is the only Agriculture Department in the world subject to one, because nobody else has one. And the problem was that when you have parliamentary government, it's the executive that's in charge of the legislation, and no executive that's in charge of legislation will voluntarily subject itself to this. Executive branch officials, if you ask them in any country, will give you the same answer. If somebody wants to ask for something, they should, and if it's appropriate to give it to them, we will. And we don't want to waste our time persuading a judge that we're right. And so it's if you look at each country, it happened sort of by accident. I mean, in some countries, they have public member bills, and so that's the way, private member bills, and that's the way it passed. In others, you had some kind of divided government. It's now, I think, become a point at which every country that claims to be democratic thinks it has to have a Freedom of Information Act. But that's not where we were in 1980.
Yeah, I was just running through the various amendments going back. I think you're right that all of the FOIA amendments were at times of divided government in the United States. It's especially interesting because now that we have amendments pending on the, I guess, passed by the House, pending, hopefully something can be done in the next few months. But it's not a partisan issue. It's because the Democrats support the reform. So I'm not quite sure how that fits into the framework of, I mean, yes, we have a Republican-controlled Congress, but the legislation is legislation that was initially introduced by Democrats in the last Congress.
My name is Kyu Ho Yum from the University of Oregon School of Journalism and Communication. Maybe from a very, how can I say, this might be some kind of footnote question on the history of the Freedom of Information Act. I'm just wondering about the concept of person. Whenever we talk about the freedom of information, it is applying to person, not necessarily limited to the U.S. citizens. So when the FOIA was passed by Congress, whether the Congress was envisioning the global concept of person rather than the U.S.-centric concept of U.S. citizen in the context of implementation of the FOIA. So right now, foreigners are using the FOIA to cover about their foreign countries. So I'm curious.
Yeah, I mean, we go through this from time to time, keeping in mind the initial any person standard was really in some ways a reversal of the early Moss bill from the 50s that required, that allowed the government to release information to any interested person. And so moving that from an interested person to a person was an important step in and of itself. And through the years, it has often suggested that there be some limit on who can ask. And the only limit that's ever been worked out, the courts have said that a felon who is on the large, who's escaped from custody, is not a person and can't make a FOIA request, either directly or through counsel. That's the only one. Now, I practiced law in Washington for 30 years, and many people came to me and said, well, we'd like to know about this agency, but we don't want anyone to know that we're asking. And I got pretty good at it. And there's an organization up in Maryland that does it just for FDA, and there's a guy who writes access reports, Harry Hammett, and 2 lawyers in town, Scott Hodes. They do, their beards for FOIA requests. Okay? So if you want the law, the option to the any person standard is allow the agency to inquire into who the real party in interest is. And they'll have to do it in a penetrating way. I mean, I would never sign an affidavit saying that I'm the real party in interest if I'm doing it for a friend, a client, or a family member. But that's the alternative. And if that's likely to take the government more time, energy, and ultimately cost than simply responding without regard to who the person is. So this issue comes up time and time again, and if you think I have a rather facile answer to it, it's because I've given the same answer for the last 35 years.
Let me give an analogy. I've been out of FOI for many, many years, but I do a lot of condominium law work, and my condominium clients often want to have access to their books and records. And there's legislation throughout the country now. More and more legislators are saying you have to have a right to know, a reason to know why you're getting the documents. I was in court once on this very issue. My client wanted to know what the condo was spending for their managers, and they refused to do it. And the judge said, well, does she have a right to know, your client? Absolutely. She's paying for it, Your Honor. It's our document. She has a right to know it. But this is a trend that I see in other areas of legislation where the legislators are saying, yeah, you can have access to your own condo records, but you have to have a reason for that. And I think that's a very troubling forecast down the road.
There was a whole separate effort by the CIA to get themselves exempt from the Freedom of Information Act completely. And one of their arguments was precisely this. It says any person. That means the KGB doing a counterintelligence investigation against our CIA agents can make requests under the Freedom of Information Act, and we have to provide them with the information. But the problem is, once you move away from any person, then the government has the right to interrogate you about who you are and why you want it. And that, I think, most people think is not appropriate, that you have to give the government information in order to get.
Do you think, I don't do counterfactual history, but the world of journalism was so different in the 66 to 74 period. It was, you know, you and all the people you were working with were thinking of print journalism, of network, you know, evening news and Sunday shows and nonpartisan coverage and a much slower process. It's changed. All of that out the window, and we have a very different media world, more partisan, faster, multiple outlets. Would they have wanted a different kind of FOIA, do you think, in this environment? Would they have been as comfortable, John Moss, doing this in this media world? Or would they, do you think that was for that particular era?
I think John Moss primarily interested in access to government information, no matter who does it, whether it's in Facebook or whether it's a newspaper or whether it's some small town newspaper that's trying to organize it. Yes, he just wanted, so I think, I can't speak obviously because things have changed and things may very well change pre-Trump, but that's another story. I think John Moss, yes, definitely would have supported the same act. Maybe with some of the amendments that we've talked now, because we didn't think about it, they weren't, yeah, but yes.
Yeah, no, look, the term open data wasn't part of the vocabulary in the 70s. But I think I look at Senator Leahy as being sort of carrying the legacies from Senator Kennedy. He chaired the same committee with jurisdiction over freedom of information and authored or co-sponsored all of the amendments in the last, I guess, 30 years. And very with an eye, the 96 amendments was Electronic Freedom of Information Act. Well, that was the best they knew then because they were trying to reverse the Justice Department's crabbed attitude towards letting emails go or having access to databases. So I do think that the thinking on the Hill, just like the thinking in the advocacy community and the media, has come along to look at, electronic access database. I guess we have some discussion tomorrow on algorithms. This is all part of where we ought to be thinking today, and we never heard of it in the 60s and 70s.
Yeah.
I'll give Michael, our convener, the final. Do we have time? Well, ask, and if we have time for another, that'd be great.
One answer and one question. I wanted to answer Q's question about what about citizen rather than person. And my answer is I'm pretty sure when I interviewed you, Benny, some years back, should be in my notes somewhere, that I asked you that question, and your response then was, we never had anything else in mind except any person. The question just didn't come up. That's my answer, I think. The question is, and this is for any of the panelists or maybe for Sam, which is when did we start calling it a Freedom of Information Act? I mean, originally John Moss talked about it as a federal public records law. I mean, this is another footnote, but I don't know when it started to be called FOIA.
Yeah, this has always been kind of fun too, because I was in the Justice Department when the Justice Department produced the Attorney General's memorandum on the public records amendments to the Administrative Procedure Act. because the administration did not want to call it a Freedom of Information Act. Okay, and I don't recall, but I'm pretty sure Johnson's signing statement did not call it a Freedom of Information Act. Okay, but needless to say, as we began to realize that we needed something changed in it, it was the late '60s. I think Nader's Raiders that made so many requests and then issued so many reports began to call it a Freedom of Information Act about '68, '69. So by the time we were having hearings back, oversight hearings and legislative hearings, it was firmly ensconced as. I still have trouble using FOIA, and especially as a verb. That's my old way of thinking. But
on March 30th, '65, when we held the first hearing, Federal Public Records Law. That's what he was calling it.
Could you just talk about Ralph Nader? I mean, he's come up many times now, and just what was his role?
Sure. Well, I mean, it's interesting because I started in the Justice Department. Nader would come up and talk to us about freedom of information. He had, those of you may not remember, he had a group of Nader's Raiders. Yeah. And their goal was to look at agency processes and write reports on how agencies were working. Agriculture Department, Interior Department, various departments back then. You now will recognize the names from the names of the famous cases. Vaughn versus Rosen, it was Bobby Vaughn who was looking at the Civil Service Commission. Robertson versus CAB was Reuben Robertson, who was looking at CAB. Welford versus Hardin, that's the same Welford I was talking about who worked for Phil Hart. Hardin was the Secretary of Agriculture. Okay, so, and in that process, they realized that freedom of information was going to be a great tool for getting the kind of information, the papers, the records, the documents, the guidance, the reports from the agencies, except it wasn't. And so Ralph was sort of at the top of that group, seeing from all of them, Mark Green, the whole, how difficult it was to get information using the Act. And that's when he wrote his little piece on freedom from information. And he was very dedicated. He thought the sanctions provision would answer it all. I mean, he talked, I remember in his testimony, he said we ought to put stocks. Melanie, have you thought about that? You ought to put stocks outside of the agencies and just bring them up there and have the officials put in the stocks for a few days. Just the public humility. We don't have to have a criminal. In any event, he really felt strongly about that. But I think he was, certainly one of the major forces for reform. But all of the people whose names I mentioned, including Mort's, were all. I think it couldn't have been done without any of them. We got a lot of journalists in here. We've talked a lot about the press. Shame on you now. I mean, we would not have had the amendments, the original Freedom of Information Act. We would not have had 74 amendments if we hadn't had the incredible media participation in really massive advocacy in favor of legislation to continue this opening process. Where are they now? Where are they now? We've had legislation pending for the last 4 years, 6 years. They're not AWOL completely, but very hard to mobilize. Yes, they have, Rick Blum in, Washington who represents the media groups, and occasionally someone will come up to the Hill, but they don't have the mass, don't mobilize, don't coordinate the editorial. We had, for the 74 amendments override, we had hundreds of editorials in local newspapers on this issue.
We did in 65 too.
I think maybe, sure, there'll be one in the national press from time to time, but it isn't there, and I think it's one of the reasons why we have had such a hard time making any changes.
Time for one last question. We'll have to keep it short. Tom.
Because I'm the resident documents fetishist, I just looked up the LBJ signing statement, and you're right, in the front end of it, he calls it guidelines for the public availability of the records of federal departments and agencies. But in the middle of the second page, there's a paragraph. It says on the front, Bill Moyers wrote this. quote, "I have always believed that freedom of information is so vital that only the national security, not the desire of public officials or private collectors, should determine when it must be restricted." It's interesting. Phrases in there clearly adopted as a way of, but I think the real quarrel is over the phrase, and this goes to Greg's point, which is the rest of the world think freedom of information, the word freedom is a little devalued post the invasion of Iraq. And the phrase that more people, I think, would resonate with is the right to
Right to know.
RTI.
Yeah, RTI.
Right to know, right to information. Just a point global comparison.
Well, on that note, especially using documents to answer a question, please thank our panelists for a terrific conversation.
Let me just, we're delighted to have Melanie Ann Postad next on the schedule, giving a keynote, but we need to give you time to get food. So if you could please be as efficient as realistic, maybe in the next 10 minutes or so, get your food, come back to sit down, then we'll queue up Melanie. Thank you.
Good seeing you. Good to see you.
Is what?
Fifth to have FOIA. And then
Fifth.
you do it whatever. Sweden.
Yeah.
Colombia. 1880. Then Finland and Denmark. 40s and 50s.
It may be we certainly weren't aware of them.
Yeah, that. But
Yeah, that's interesting.
The Finns had one immediately when they got independence because
They took the
Swiss
Swedish.
one- The Swedish one is theirs anyhow.
Right, I see, right. No, that's interesting. I had not heard that.
The president then returned.
Part of this was sound too. But I mean, part of this was just adding this where it goes to partnerships page, and there's no slideshow. It looks like a video. As soon as it's I reckon you can. Well, I'm already connected. Whatever. I have no idea what Let's make sure you forward. And 5
Think. Well, it's very hard.
feel free to keep eating and continue as you wish, but I want to move on to the next part of the program and introduce Melanie Ann Postay, who is Director of the Department of Justice Office of Information Policy. Just a word about her background. She's been with the Office of Information Policy since, I don't think she's old enough, but she said the 1980s. Okay. She was Deputy Director of OIP beginning 1999 to 2007, became Director then, and ever since. So she's endured or survived or multiple presidential administrations and attorneys general, and she's still devoted to information policy and freedom of expression. So I'm very happy to introduce her. She's going to talk and answer questions. Melanie, the floor is yours.
Thank you. It's wonderful to be here and to spend 3 whole days talking about the Freedom of Information Act with like-minded people. It's really been fun for me. What I was going to do was start with by showing you a Justice Department video that we put together for the 50th anniversary, but I'm going to skip that and get right into my talk because I wanted to have time for Q&A, and the group is obviously really interested in Q&A, and so I definitely want to be able to talk with you all after my remarks. What we do at the Department of Justice, in my office in particular, the Office of Information Policy, we have, I think, a really wonderful statutory mandate, and that's to encourage agency compliance with the FOIA. So what we do is work to, in a multitude of ways, which I'll talk about in a minute, to try to make sure that all the people inside the government who respond to your requests know how to do so properly and are doing it in the best possible way we can think of. And then we also have an obligation to oversee agency FOIA administration. So all agencies report to the Attorney General on their administration of the FOIA. So we have an oversight function as well. So with those 2 hats, and I should say to the context of this is that there are 100 federal agencies subject to the Freedom of Information Act and thousands of FOIA professionals across the government. So we try to do a broad range of activities to reach all those individuals, reach all those agencies, all for the purpose of improving access to information. And since 2009 in particular, with this administration where we've had such a wonderful focus on Freedom of Information Act and such a real commitment right from the top to improve Freedom of Information Act, I really want to focus on the things that we've been doing since then. And I kind of arranged them in 3 thematic groupings. We've really done a number of things to improve engagement with requesters, to improve internal processes within agencies to make things work more smoothly. And then we're also working to improve or enhance agency accountability. So starting with our first thematic area, engagement with requesters. If you look at the President's FOIA memorandum, he had a wonderful line that it's important that agencies respond in a spirit of cooperation. So we've had that, and for agencies to recognize that they're servants of the public. So this was key right from the top. We have this concept of working in a spirit of cooperation. So we've tried to do many things in my office in terms of issuing guidance pieces, emphasizing to agency personnel the importance of good communication with requesters. And certainly from the conversations that we've had so far during this conference, I see so many times where occasionally I was very happy when somebody, I think Sarah Cohen, mentioned that, oh, the State Department had contacted her to work on how they could manage her request more efficiently. Now, she was maybe frustrated that they had reached out to her. When I heard that, I was delighted that they had reached out to her because, of course, that's a big part of what we think is important to do is to have more engagement between agency FOIA professionals and requesters so that you do get that human connection. You can have a meeting of the minds about what it is that the requester is seeking, and certainly where I understood her frustration, it is not up to the requester to understand the record system of the agency. Obviously, that is what the job of the agency official is to know what kind of records we have, to be able to relay that to the requester, and then kind of together work on a plan for managing a request, particularly a really big request. So those are sort of the two sides of the engagement with requesters. So we've issued guidance and made a big focus on trying to improve communication with requesters. Some things too, communicating electronically. This has been it was surprising to me to hear from requesters that the frustration of sending a request in and saying, here's my email, please contact me by email if you have a question, and then not having the agency respond by email. So we issued guidance to agencies saying you really need to communicate with requesters using their preferred format. And if they want to communicate by email or they want to communicate by telephone, that's the way you should do it. I really think that the whole FOIA process does not in any way need to be adversarial. The idea of it is it should be cooperative. All stems from the idea of working in a spirit of cooperation. So we've had many different things where we've talked about the importance of communication with requesters. We then also at OIP, we hold different events to foster dialogue with the requester community. So I engage regularly with what we call now civil society organizations, or the requester community, people who are interested in access to information from the outside. We do requester roundtables, town halls, brainstorming sessions. These are all designed for inside the government. It's important for me to hear from the requester groups. That helps inform me in the guidance that I give. Then I also think it's really important that agencies engage with requester communities. So one of the things we've been having agencies do is report on their efforts of outreach to the requester community. So it's not enough for requesters to be able to come talk to me at DOJ. I want every group of requesters who typically makes requests to a certain agency to have the opportunity to talk with those agency FOIA professionals so that they can work together to see what are some things, documents, for example, that might be good candidates for proactive disclosure. How can we make requests be less necessary? That type of thing. Now, in addition to working with requesters, so sort of another big thematic area that we've been trying to improve is internal processes within agencies. As you can imagine, behind the scenes, when you make FOIA requests, there's a whole world back here, which I'm trying to give you the face of the world behind the scenes. FOIA professionals who take your request have to interpret what you're asking for, and if hopefully they're reaching out to you, talking to you about what your request is. But then they have to go on a massive search for records, to find records. And one of the key things we oftentimes, with those of us who are, the few people here who are in the government, we use it typically as an example. People sometimes will think, oh, I made a request on this topic. Surely the agency just goes and types it into a database and out pop the records. And of course, I realize you all know, that is not true. So searching for records can be a huge undertaking within the agency. And certainly with the immense explosion of the volume of records that we've seen since FOIA was passed, where we're talking about, and I saw Tom Sussman's carbon copies while he was sitting at the table. We now have many, many, many emails, and we all know how email chains get passed on from one person to the next and built on to the next. Just imagine when those are caught as part of a FOIA request, just the burden of going through all that, the scope of what needs to be done, is a big area in FOIA that is totally different than was contemplated back in the 60s or the 70s, and even in the 90s when the Electronic Freedom of Information Act amendments were passed. We didn't have the explosion of records that we do now. So that's a huge challenge that agencies face. So one of the things, a big part of what we do is try to help improve the inside, the process of responding to requests. So the first thing that I think one of the most important things we did, and there had been a long time effort to professionalize the FOIA workforce. And you notice that I use the term FOIA professionals. Before we had this as an ingrained concept, too often in agencies, the job of responding to FOIA requests was just an ancillary duty given to somebody. And it was too easy then for it to be passed on to someone else. And it was very important to those of us who worked in the area that there be a recognition that this is an important job that's applying the law, applying case law, applying executive orders. It is a professional job, and it deserves a job classification. And so we were really very pleased that in 2012, OPM created what's called the Government Information Specialist job that recognizes the role of the FOIA professional and actually has a job series, a promotion potential. It's a true professionalization of the position. So that was the foundation. But then, of course, once you have these people in these jobs, they absolutely need to be trained so that they understand the FOIA's requirements. We're never going to have FOIA work well unless people understand exactly what the law requires them to do. So one of the big functions of my office is to train agency personnel, and we train about 2,000 people a year in a whole variety of training courses. So we can never get enough training in to make sure that people understand what their obligations are under the FOIA. Now, a couple things we did to try to help make training even more accessible is that we launched some electronic training resources. I'll just quickly show you. We created this little infographic, and the idea here is that this is something that gives you the basics about what FOIA is and what it does. And it is designed to be put inside of an orientation handbook so that as a brand new employee comes in the door of an agency, they understand they're coming in as an engineer or as an agent, but they need to know about the FOIA because in the Attorney General FOIA guidelines, there's a wonderful line that FOIA is everyone's responsibility. And it's absolutely true. The FOIA professionals are the ones that handle the requests, but anybody in an agency can have their records subject to a request. And anyone in an agency could have to search for records or help a FOIA office. So it's really important that those people understand what the FOIA requires. We also then did some e-learning modules so that these are available on agency e-learning platforms, and this also makes it easier for us to ask agencies to give us numbers every year. How many of your FOIA professionals have taken training? It's now widely available electronically. We wanted to also share best practices across the government. There are different agencies. As I said, there's 100 agencies subject to the FOIA. Different agencies have had successes in distinct areas, and we would want to have a way to leverage the successes of some agencies more broadly across the government. So we've created what we call our best practices workshop series. And what we do is we identify a topic. You'll see one of the topics was proactive disclosures. We've talked a lot in the conference about the importance of proactive disclosures. It's been a big focus of ours. We had a best practices workshop specifically on ways to identify proactive disclosures, how to facilitate identifying them. Using technology in FOIA, reducing backlogs, improving timeliness. These have all been topics that we've made the subject of workshops so that agencies can learn from one another. Another area that is, I think, really important in improving Freedom of Information Act, and that's been my own sort of popular and particular area of focus, is promoting the use of technology. Because I've been in FOIA so long, I don't quite remember the carbon paper in FOIA, but I certainly remember a time when all we had was paper copies and processed start to finish a FOIA request in paper so that emails were printed out and then spread out sometimes over a conference room table so that they could be deduplicated once we got email, manually deduplicating emails so that you're not processing the same thing over and over again. And then agencies pretty early on adopted like Adobe or different forms of different ways to redact documents electronically, but then they had to then scan them back in to send them off. We had a lot of paper, a lot of going back and forth between paper and electronic. Technology, of course, is hugely important for giving us efficiencies in FOIA, and especially the use of e-discovery tools. I can tell you when we first saw the e-discovery command center set up in one of the litigating divisions, somebody in my office, and we saw that how you could scan all these emails in and then the software electronically deduplicates it. someone in my office remarked, "Oh, it's like going to Santa's workshop." We were just thrilled at the thought of the technology being so helpful. So the enhanced ability to conduct searches and review the records is huge. So one of the things we wanted to do to help make the case for wider use of those e-discovery tools, because of course they cost money, we wanted to we did a pilot study to sort of build the case for the advantages of the technology tools. And this slide gives you a little snapshot. In one of our test cases, we had over $4 million documents that were initially collected. When we ran them through automatic deduplication, we got it down by 1 million. That would have had to be done manually in the absence of these technology softwares. And then we were able to apply filters and search terms and keep winnowing out the universe until we got to 3,000 documents. So, and this process took literally maybe 4 hours. So versus what would have been weeks of manual time. So it was easy to make the case for the improved efficiency, but this has just definitely been an area where I think we'll continue to see improvements to FOIA if we can use technology more efficiently. Now, of course, another thing, a huge part of what we do is give guidance to agencies on the substance of FOIA. So we've been talking about interacting with requesters and processes, but then at the end of the day, too, it's very important that agencies understand the legal requirements of the law. So when there are big decisions like the Milner decision that was mentioned last night, that big, huge sea change in Exemption 2, we did a huge guidance article on that. We've also done guidance on things that we hear from requesters are challenging areas. We had a lot of requesters, it kept coming up in different contexts, were having difficulty getting status information on their request. Something that to me should be very basic. You should be able to get status information about your request, find out how long it's going to take, where is it in the queue. Agencies were having trouble implementing this, and it's part of the law. So we did actually 2 guidance articles on that to help agencies understand how to do it. We have guidance on proactive disclosures. We keep coming back to that, among other things. Another thing that we did, and this was part of our National Action Plan, we mentioned last night, we talked a little bit last night about the Open Government Partnership. And the U.S. as a member of the Open Government Partnership, we've had 3 national action plans, and they've all included FOIA initiatives. So I've been really, really proud to lead several of the FOIA initiatives in the National Action Plan, and one of them was connected with creating a uniformity in the area of agency FOIA regulations. So we issued guidance and a template and sample language on FOIA regulations with the idea that if we could standardize them as much as we could across governments, the agencies, it would make it easier for requesters. And then at the same time, allow the individuality that different agencies needed for their own particular records needs. So that was something that we just published in March of this year, so we were really proud of that. We've also just in the coming weeks, we're going to be releasing a self-assessment toolkit, because one of the things that we've found is that it's important for agencies to continually look inward and see where are their problem areas with FOIA, where are the roadblocks, what are the areas that could be improved. And to help agencies do that, we're developing what we're calling a toolkit that allows agencies to kind of walk through a set of questions and see how they can assess themselves to identify places where they can improve. Our last thematic area is achieving greater accountability. And of course, in the Department of Justice FOIA guidelines, the guidelines talked about the importance of agencies being accountable and how important that chief FOIA officer is in each agency. So one of the innovations that we've had since 2010 was the creation of a new report that's called a Chief FOIA Officer Report. And every year, agency chief FOIA officers have to report to the Department of Justice on the steps they've taken in these 5 areas. And these are areas that we created, but they're based on the principles that are in the Department of Justice FOIA guidelines. So applying the presumption of openness, ensuring that the systems that the agency has are effective, increasing proactive disclosures, utilizing technology, and then improving timeliness and reducing backlogs. So every year what we do is we issue guidelines on what needs to be put in the Chief FOIA Officer report, and we've changed the questions every year. So as agencies have matured in their implementation of the AG guidelines and the President's FOIA memorandum, we take away questions and we put new questions on. So partly what we're doing with this is reinforcing behavior, but also then pushing agencies, because with each new question, we've got a new goal for agencies to work with the idea that they want to get that done so that they can positively report it in their report. Now, to make that even more concrete, we have created what we call an assessment, where we actually score agencies with the kind of the familiar red, yellow, and green stoplight system, but then actually in response to feedback that we got from civil society or requester organization, we've got more granular and created light green and dark green and orange as well as red. So we've got feedback that we needed to be have more gradations, so now we're up to 5. So that's why you see a couple of shades of different shadings there. This is just one page. Our assessment scores agencies on usually around 20 different milestones, so that we really try to capture a full range of activities connected with FOIA. I was delighted last night when FOIA.gov got mentioned and shown on the screen. We were very proud of launching this. This is really our way to have accountability of FOIA itself. FOIA.gov has all the FOIA data in it in an open format so that everybody can look at those metrics and compare agencies across the government and over time. Just some screenshots from FOIA.gov. We now instituted a new requirement that agencies report quarterly to the Department of Justice and put the quarterly data on FOIA.gov so that we can have a little bit more granularity in the reporting metrics. And just as a highlight on the right side, you'll see that we have the 10 oldest requests. One of the things that we've been focusing on asking agencies every year to do is to close their 10 oldest requests, because the only way to improve the age of the requests that are pending across the government is to sort of systematically work on those oldest requests. So we've set that up as a distinct goal for agencies to meet every year, and you can see we have an example there where all 10 are closed, and we have agencies report that as the year goes on. So what has all this brought since 2009? Well, we have received since 2009 4.5 million requests and have actually processed 4.6 million requests. So yesterday the term, David I think used the term that the FOIA is thriving, and when you said that, it made me think exactly of 4.5 million requests. In that sense, our statute in the US is used obviously tremendously. It's very popular. When I go to other countries and talk with people about in other countries where they're starting to discuss an access to information law, or maybe they just have a new one, oftentimes the concern is public doesn't use it. People are skeptical or hesitant to use the law. We definitely don't have that problem in the US. Of course, our problem is the opposite. We have such high demand that keeping up with the demand is what the challenge is in the US. But we do have a really high release rate of 91%, and the two most frequently cited exemptions are the privacy exemptions. And we've talked a little bit so far about privacy, but I haven't heard anyone really saying, oh, they think private information about individuals should be disclosed, that it's wrong somehow to protect personal privacy. And year after year, the most frequently cited exemptions are the privacy exemptions. And Exemption 5, the exemption that we have talked a lot about that protects privileged information, that gets cited only 13% of the time. So despite the focus on deliberative process privilege as a practical matter, it's actually used quite a small amount of time. We've certainly also had a focus on increasing time to respond to requests, and where we've seen strides is in processing simple track requests. One thing that I thought was important in our dialogue about Freedom of Information Act is not to think of all requests as sort of just fungible, because certainly a request for a report or a discrete universe of documents is very different from a request where somebody says, I want 10 years worth of documents on everything connected with some huge topic, the Hurricane Katrina. Those two requests aren't remotely similar. And we shouldn't think that they are remotely going to be answered in the same amount of time. And the FOIA has built in a way to distinguish between what we call simple track requests, or more easily answered requests, and more complex requests. And so one of the things that we've done at DOJ is encourage agencies to make sure that they're really focusing, that they have different tracks for requests depending on their complexity, and that they then focus their resources on closing those simple track requests in an average of 20 working days, so that we can offer requesters a real alternative, so that when a request comes in and it is really broad, we as agencies can say to the requester, if you can narrow this down to something that's more reasonably sized, we can put you in the simple track. And you can see from our annual report, it's all public data, that we can do that, we can process that request much closer to 20 working days. You might want to wait, you might be, not that you want to wait, but you might be willing to wait because you want everything else. That's fine, but at least we can give you a real option. And we have seen a decrease in the amount of time to process simple track requests, so that's been a nice improvement. We certainly have a lot of discretionary disclosures of information, increased proactive disclosures, and increased usefulness of what's being disclosed. We're using technology, and we're certainly doing a lot of work around the globe to promote transparency. Now, what do I think the future holds? I would really like to see a reduction in the need to make requests. I have been telling agencies since 2009, when the President's memo and the Attorney General guidelines came out, please, we've got to really work on proactive disclosures, because you know what, guys, it's going to be great. We're going to see a reduction in incoming FOIA requests. So that was my pitch to the agencies early on, and the graph for receipts of FOIA requests kept going up. So I had to just change my line of my approach with agencies and say, okay, it doesn't look like we're going to see a reduction in the amount of requests by making proactive disclosures, but you will be achieving transparency for transparency's sake by doing it. So that's the way I actually view it. But what I would like to see, though, is a reduction in the need to make requests. And I think that maybe we just haven't gotten to that tipping point yet, where there is enough proactive disclosure that there's alternatives to making requests. But that's where I would like to see us go. And I think there are probably lots of areas that could be pulled out of FOIA and have separate access regimes, so that things don't clog up FOIA that really shouldn't be in the FOIA track. But even as a goal that I would love to see, I know that no matter what, we're always going to have records that people are going to ask for. And so there, I really would like to see us maximize the use of technology from the very beginning. So from the very beginning of a document's creation or acquisition into an agency, having the concept of disclosure baked in to make it easier, so that it's not a huge burden to search, it's not a huge burden to segregate, it's not a huge burden to review it, so that we can make the whole process work more efficiently. There, I tried to really talk fast so that I could leave you all lots of time for questions. So I'm ready for questions now. Yes.
So, FOIA.gov is really a wonderful source. And as I tried to show last night, it reveals a picture somewhat less optimistic than the one you've given us. More than 2.5 times the number of exemption invocations today than there were at the end of the Bush administration. Your 91% figure for releases is accurate, but because it includes partial releases.
Right.
And it appears, at least from the numbers, that some agencies are, as it were, cooking the books by releasing a bit of stuff. I think, as I remember from the Department of Homeland Security, their total denials are less than 10%.
Right.
Their partial releases are 80%. So
Right.
I wonder if you can address this kind of issue.
So I've heard that before. So for the first point, in terms of the number of exemptions, probably the most obvious reason why we would have more exemptions being cited is because we've processed so many more requests. Every year we've processed more requests than before.
They're in imbalance. The number of requests has gone up by about half of the rate at which the number of exemptions has gone up.
So, okay, I'm not sure. Okay, I'm not sure if I understand that, but I can give you more answers to that question. The other thing you have to remember is that there is no correlation between the number of exemptions that you use and the volume of material that's withheld. And we've been really focusing on partial releases of information, which oftentimes can mean multiple exemptions being cited. Whereas something could have been withheld in full under one exemption, it might be released in part, but 3 exemptions are cited. So if you're just looking at the number of exemptions, you're going to say, well, oh my God, 3 exemptions, that's worse. But in fact, over here with 1 exemption, if you withheld the whole document, that's more withholding. So there really isn't a correlation between number of exemptions being asserted and the volume of them. There's no correlation at all between the volume. And when I looked at your chart last night with the uses of exemptions, if you saw, I wish we had it here, by far the biggest increase in exemptions was privacy exemptions. If you by far, I was interested in it, of course, when you had the chart. Privacy exemptions were a huge part of the increase in exemptions.
And if you looked at that House report, they give all kinds of examples of the use of privacy exemptions that are less than personal privacy.
It's important to protect personal privacy. We have a Privacy Act designed specifically for that purpose. I don't...
The chairman of the FCC invoking the personal privacy exemption because his initials were on a memo of press release.
Right. I won't answer that one in particular. Yes.
Yeah. So I have questions about why it is there are 2 ways in which you could use technology quite effectively, and they're not really being used. So one is technology to assist in identifying sensitive information, and that would include national security information. So 4 years ago, the Public Interest Declassification Board, called for use of technology as the only hope, when we're dealing with 1 billion email a year from the State Department, for instance. And in that whole time, over these 4 years, so 2 things happened. DARPA put out a request for proposals, and then they didn't fund anyone. The CIA started a very small project at the University of Texas, which they've since decided to scale back and eventually shut down. So it's really puzzling for many of us, including me and others who worked on this, using declassified documents, trying to understand why it is, on the one hand, you have different parts of government talking about the imperative, to use technology for dealing with declassification, to meet legal mandates, to release national security information. Why it is there's $0, going into supporting research in that field. And then the other question is, everyone has been talking about FOIA.gov. What about FOIA Online? FOIA Online is this EPA-led effort where you have not only the requests that people have made through FOIA, but also the results, where they release to one, they release to all, and they put them on their website. Right. And I talked with the people at the EPA, and they're puzzled, as to why it is that it's been so difficult to get funds to support that program and expand it to the rest of the government.
Okay, so I'll start with FOIA Online. We're actually, my office is now on FOIA Online, and we're on the governing body of it. So FOIA Online is a very completely different thing than FOIA.gov. FOIA.gov is a website to show the public data about FOIA, to bring transparency to FOIA data itself. FOIA Online is a tracking mechanism. So it's used to make requests and for agencies to track the progress of requests for purposes of creating their annual FOIA report. So they're 2 different things. But we have slowly but surely agencies, my office actually put quite a bit of resources into FOIA Online and made a huge amount of improvements to it, and we were just able to join FOIA Online as a result of that. and is slowly but surely getting more and more agencies on board. But they're two different things.
Why is it so slow?
They're two different things.
Oh, I know they're
Okay.
totally different, and they're both important, but why
Right.
is it so difficult to get agencies and departments to participate in FOIA online?
Well, there's no a mandate to participate in FOIA online. Every agency has to use a tracking. It's a tracking system. Every agency has to decide what's the best tracking system for them. Many agencies have tracking systems that they developed for their records that are integrated with their records that can handle classified documents, for example. One of the big limitations on FOIA Online is that you can't put classified records into it. So that removes it from even being an option for many agencies. So those are all different. There are lots of different considerations that go into what kind of tracking system someone uses. How I look at it is, I want agencies to use the tracking system that works best for them and that's most efficient for them.
I would just point out it's massively inefficient for the government to spend $500 million on FOIA, but not to allow people to view the documents released through FOIA through the internet. It's massively inefficient because it leads to huge duplication of FOIAs, and it's the reason why it is, that these FOIA offices are completely overwhelmed because information brokers are asking for the same information over and over again.
Yeah. There is a requirement in the FOIA. I disagree with that, with the premise of your statement, in the sense that agencies are already required to post documents when they are the subject of frequent requests. And that was the subject of a big focus of our guidance on proactive disclosures. What agencies face over and over again is not duplicative requests. Duplicative requests are great. If you've already processed the records, believe me, the FOIA office is delighted to be able to say, here, we've already posted them, or here they are on the website. We want more and more of that to happen, but oftentimes, overwhelmingly, agencies don't get requests for the same material. And so they have to process again. But let me just tell you, though, one thing that we are working on, we're just in the process of finishing up the results. We launched a pilot called the Proactive Disclosure Pilot, or Release to One, Release to All pilot, to test the feasibility more broadly of all agencies posting FOIA processed records online. Because it's in keeping with, I think, the spirit of the FOIA. Legally, once you make a release to one person, it's legally available to anyone else. So why not look to see how feasible it is to post every FOIA release online? So it would get to your point. We just did a study, a 6-month study, where we had agencies volunteer to be part of the pilot. I'll tell you the reason why we had to study and collect metrics and why we're working on a report is that there are costs associated with posting material. So unfortunately, it's just not as easy as you would think. There are costs associated with coding material to get it ready for posting so that it's accessible to people with disabilities and in compliance with Section 508 of the Rehabilitation Act. So that's one of the big challenges that many agencies face with more broadly posting it. So which is why we're doing a study, because we are definitely supportive of the concept of posting information once it's released.
Okay.
Yes. Yes.
Just an informational question.
Yeah,
what
sure.
are you guys doing about non-email electronic communication, texting, social networking, messaging?
Right.
What's going on with all
Right. Well, so records management, of course, is the responsibility of NARA, not DOJ. But what I can tell you is that, like texts, for example, are considered agency records, just like emails are considered agency records. So agencies would search for those and capture those in response to a FOIA request, just like they would anything else. But all the rules about the social media are really governed by NARA. So I don't, it's not in my area of responsibility directly. Yeah, Tom.
One of the things you didn't mention is encouraging agencies not only for proactive release, but for discretionary release. And so, I mean, as you know, the White House has suggested that
right there, second bullet.
All right. Well,
I have it.
So how often? I mean, how often does this actually work? Because as you know as well, that's part of the legislative battle that's been going on, is Congress wanting the government to have to show some harm before they rely on certain exemptions, and not automatically presume that disclosure will cause harm. And this is something that, do you ever tell agency, yeah, this could be covered by exemption 2 or 5, but you ought to release it anyway?
Right. Absolutely. So that's part of our guidance on the President's FOIA memorandum and the AG FOIA guidelines. And then it's part of our training to agencies. But more than that, we've been asking agencies every year for the past 4 years now to include in their chief FOIA officer reports examples of documents or records that they've released as a matter of discretion, because we wanted to bring greater accountability to that topic. And so we see a whole wide range of documents and information that's released as a matter of discretion. And then we've asked the agencies to tell us the exemptions that would have applied. So what's been interesting is that in addition to exemption 5, which of course is the easiest area to locate opportunities for discretionary release, we've had a few of 2. It's just that exemption 2 is used so barely even used, so you don't get to the point. But we've seen some law enforcement information. Some of the exemption 7 law enforcement information, source information, and investigative material on older investigations has been released as a matter of discretion. So I've been real happy to see that it's all in our chief FOIA officer reports. Yeah, David.
I'm next. Thank you, Melanie, for this presentation and for the important work you do, and Miriam before you. Like a lot of people in this room, I imagine, I see the creation of OGIS as a very promising development, but also worry that the office may be embattled within the executive branch. It's small, fighting against a lot of vested interests and practices that have accreted over a long time. And so Tom, on his panel, urged the journalists in the room to start editorializing more about legislative reforms that would push FOIA forward. I was wondering if you could get the dream bill from Congress next year, you could imagine. What would OGIS most need to be more effective? Is it just money and many more personnel, therefore? Do you need coercive authority to not just have this, there's a lot of hortatory directives, I gather, we give to agencies to urge them to best practices, but do you need tougher sanctioning mechanisms that you could implement? I mean, so what would OGS need in your dream world to be even more powerful?
So, I mean, I'm not in, I mean, my office is different from Office of Government Information Services, so it's hard for me to say what would be best for them. What I would say,
you can say money and staff.
well, everybody would want money and staff all the way. How I would answer your question is what would my dream bill to strengthen FOIA itself, the whole enterprise, and that's where I would say, of course, I would love to see a more realistic expectation of funding and staffing for the job. I think, though, we had really interesting comments last night. If you're OSHA and you have so much budget, do you really want? Is it an OSHA inspector or is it another FOIA professional? I mean, these are hard things. We all, of course, want more money and more staff. I would really like to see more technology, you could hear from my remarks, to help agencies be able to respond to requests. I'd like to see less need to make requests, which is why I guess that's what, going back to my, my last slide. Whoops, now I messed it up. Sorry, I messed it up. But I would like to see certain things pulled out of FOIA. A lot of areas, like for the Department of Homeland Security, for example, gets the most requests of anyone in the whole government. But overwhelmingly, the requests they get are from individuals asking for their own immigration records. So that is taking up an enormous amount of time and resources of the FOIA staff. It's important to get that information out, but that means that journalists and students are waiting. And so that's an example of an area to me that would be, I think, could be better served by being pulled out of FOIA and have a separate disclosure mechanism for it. Those are sort of the big picture things that that make sense to me. Yes, Heather?
Hi, I wanted to ask a bit more about your best practice center or whatever you call it. One of the things that's been used for in Britain was, it's called a clearinghouse, the central government clearinghouse, and there's also one in local government. And the rhetoric of it is about making best practice and giving out advice to different FOI officers. But what it's actually turned into is a way to control the message that goes out and to centralize, and basically to become a kind of PR operation. A way to make sure that any requester can't sort of do an information arbitrage across different agencies, so they can't leverage out. They get one thing from one police department, and then they can go to a different police department and say, well, those guys gave it to me, why can't you? And so there's been this movement to have these clearinghouses in effect to really kind of shut down disclosure. And I just wondered how yours works, if it's presumably not like that, but just checking.
Yeah. No, oh yeah, it's not at all like that. So the best practices workshops are, what we do is identify agencies that have shown real success in a given topic area, and we just pick different topic areas. So proactive disclosures, for example, we look in my office at their chief FOIA officer reports, at their annual FOIA reports, and we identify agencies that have done really a great job with a particular topic. So we would identify agencies that have done really well with proactive disclosures. We assemble a panel and then have that open to all agency personnel to come and hear from their fellow FOIA professionals at agencies. How did they increase their proactive disclosures? How did they work with their program officers? How did they identify things to proactively disclose, which maybe reduces the need to make a FOIA request? So the idea is to spread a wealth of knowledge that exists across the government, spread it more broadly.
Melanie,
yes.
There are more questions, I know, but I'm going to call this to a halt.
Yeah.
Thank you very much. We have to move on to the next part of the program, but I appreciate this very much. Thanks.
Certainly. Thanks, everyone.
And we have now Matt Connolly from the Department of History at Columbia, and Ann Thornton, the Columbia University librarian and associate provost, to talk about the Freedom of Information Archive that they have created, are creating, have created. Okay.
Today.
All right. Great. Thanks.
I'm going to say something first.
Once we want to do it, is it?
What do we?
Yeah.
Is it that? Yes, it is. This one. Awesome. Okay, great. Thank you so much. Since 1882, Columbia University has been a federal depository library with the responsibility for providing public access to government information. It's not only for the Columbia community, but something for the public. And the things that we did in libraries for many years, over decades, to make this information accessible, those sort of traditional things that we did, from cataloging to checking in things, to putting them on shelves, to ensuring that they were preserved and accessible, we can't do anymore. Because of the way that these things are coming, those traditional ways. And so to a considerable degree, we've become removed from this particular role that we've been entrusted with in libraries to help ensure access to government information. And the project that Matt and I are going to talk to you about today, which launches today, the Freedom of Information Archive, is one of the ways that libraries, including the libraries of Columbia University, can re-engage with that role of providing access and ensuring preservation. And this project, and why we're so interested in it in the libraries, is really important because it sits at the nexus of a number of issues that major research libraries are grappling with today. Everything from how to preserve and maintain access to the very best of multidisciplinary, even interinstitutional kinds of repositories of research data where scholars are really actively working together. How do libraries help ensure that those things survive? And, like I mentioned, our role in preserving and ensuring enduring access to government information, which is increasingly hard to do. And it also grapples with the issues of born digital information, which we're collecting all the time in major research libraries. And so this project actually explores a lot of those really great ideas. And in our expansive view about what a research library is and what it means to a university, this project also gives us a really special opportunity to engage very deeply with research, teaching, and learning, which is really the point of a major research library today. So we're going to show you the video now, and then we'll be right back.
Every 3 seconds, some government official creates a...
Stop. Yeah. Okay. I'll let you, actually.
new official secret. But it takes decades before... Every 3 seconds, some government official creates a new official secret. But it takes decades before some other official decides whether we get to see it. There are now over 28 million cubic feet of secret papers, equivalent in volume to 26 Washington monuments. That's more than 5 times more paper than has been archived from the entire history of the Republic. The production of classified electronic records is orders of magnitude greater. The digital equivalent of 1 trillion pages of classified documents every single year. If these were paper records and lined up in file cabinets, this row of secret dossiers would circle the world. So what are we, the people, supposed to make of all of this? I'm Sam Waterston, and I'm here at Columbia University to tell you about the Freedom of Information Archive.
I began to realize as an historian that not only was there more and more being produced in the way of declassified documents, like 1.4 billion that have been declassified just in the last 25 years, but that in fact more and more was being withheld, and that we're only getting a tiny piece of it. So it's estimated that, and when I say we, I mean not just historians, but as citizens, as journalists, we're only seeing about 1 to 3% of the documentary record that's produced by government.
I've spent my life chasing classified information and finding it to be not only an outrageously haphazard and crazy system, but serving a selfish political interests of bureaucrats who are, for the most part, not guarding national secrets.
Max Frankl should know. He was the one who got the Supreme Court to agree the government had to stop covering up how it blundered and lied its way into the killing fields of Vietnam and Cambodia. More and more of this history consists not of documents like the Pentagon Papers, but encrypted emails and text messages, remote sensing data, and surveillance footage.
When I talk to people in government about this, they would say that it's not just about the State Department cables or even about Hillary Clinton's emails. The whole system for how the government reviews documents to decide what can be released is beginning to break down.
But what if, right now, a team of historians, computer scientists, and mathematicians began to assemble the millions of documents that have been declassified in a single database and began to train algorithms and high-performance computers to discover what is missing? In fact, a team of researchers at Columbia has been conducting just such experiments. This project is called History Lab. And the experiments happening there show how data mining is no longer just a technique for state or corporate surveillance. Instead, citizens can use it to turn the tables, reveal what the government did not want us to see, and in that way restore both basic sanity and democratic accountability to our national security state. History Lab has already created the world's largest database of declassified documents, the Freedom of Information Archive. It is a model archive for the age of electronic records, one that will scale with the projected growth and diversification of digital media, whether audio, video, or imagery. Users can explore it with a set of cutting-edge machine learning tools, create research communities, and ultimately upload their own declassified records. Already, the Freedom of Information Archive is becoming a platform for new kinds of teaching and research, as students begin to realize that they too can make history.
What I see happening is that our students are no longer just thinking of history as something that they read about. Instead, they're beginning to think of it as a kind of data science. They're thinking of it as something that they themselves can create through the experiments that they run and through the tools that they build.
Ironically, the tools that are being built at History Lab are precisely the kind of tools that can help the government identify information that really does require safekeeping. That's why History Lab researchers have been invited to brief the State Department, the CIA, and the National Declassification Center. The ultimate goal is to build a declassification engine which will automatically identify documents requiring close scrutiny and accelerate the release of everything else. Over time, the Freedom of Information Archive could grow to become truly global, a shelter for vulnerable and vital data from around the world, safe from those who would seek to restrict our knowledge, violate our privacy, or obscure our past. How our information is preserved and protected is a core issue in the age of big data. And what's happening at History Lab is at the center of the struggle. Because if even historians can't know what government does in our name, decades after the fact, what future is there for basic democratic accountability? But if we can build that Freedom of Information Archive and keep it free for the entire world, we can not only save history, we can lay a new foundation for a more democratic society. To learn more about the Freedom of Information Archive, go to the History Lab website, history-lab.org.
Okay, thank you. Let me just first, before I say anything else, acknowledge Peter Kaufman, an incredibly talented producer and director who did this on a pro bono basis. And you probably already know that we didn't pay Sam Waterston to do it either. So I've been really happy, gratified, to find that people like Peter, Sam, others, seeing the potential, to begin to gather all the documents that have been declassified and to begin to use data science tools to explore them, that a lot of people get excited about that idea and they want to help. And so that's why we're telling you about this project, because we're hoping that you too will see the potential and might even see ways in which you could contribute. So there are various ways to do that. But before I tell you anything about that, because I only have about 8 minutes, let me just tell you in a few minutes what it is. So the idea here is that the Freedom of Information Act would be futile, right, if the information came to us in the form of massive data dumps, where it was almost impossible to know what to look for. There's lots of research from the e-discovery field about how a search engine is of little use when you are facing a corpus of 1 million or 10 million or more documents. So what we're trying to do with help from colleagues in the computer science department and mathematics and statistics is to try to leverage the work that's already been done in data mining, typically a tool of surveillance, and instead to use those kinds of tools to see what we can discover about the nature of official secrecy, among other things. The other idea is that the Freedom of Information Act is of little use if the government itself can't find the records responsive to your requests. And more that's the case. So if you look at the Office of the Inspector General report from the State Department, everybody, I think, just read the part about Hillary Clinton's emails.
But there are actually several pages where they describe how even after months, they were not able, to recover the files of the State Department from just a few years ago. They had forgotten the passwords. They tried to open these files and there was nothing there. So we're not even, in this case, talking about history. We're talking about, records of just a few years ago, and this is becoming an increasingly common story. And it's one that is not even just about, kind of the things, that we care about, transparency, accountability. It's a matter of national security. If the government itself can't reconstruct the record of international negotiations and agreements, then our government is vulnerable to manipulation of foreign powers. So we're trying to do what we can with what records do come to us, to aggregate them, to make them accessible, and to help people to explore them. Because one thing you can begin to do when you get that many records together is you can begin to tell what's missing. So let me just, in the last minutes that remain, just show you a few things about the site, and then I just encourage everybody to check it out. So on the left-hand side, it's some of the projects that we've done, some of the research we've done. And that would include, for instance, if you could match up the many thousands of documents where we have both redacted and unredacted versions, you can begin to tell, who is it that's particularly likely to have their names redacted out of the public record. And for us, this was great proof of concept because, well, in some ways it's kind of like what you knew already, or if you knew about Mohammad Mossadegh, the prime minister of Iran that the U.S. helped to overthrow back in 1953. It's why they're still just a little bit cranky in Iran about relations with the United States. But then there are other people like William Pauly and people you might not have heard of. But what we're trying to do is show why it is you may not have heard of these people. And then there's the part of it where we begin to make it possible for anyone, to do that kind of research and try to reconstruct what it is we know and what it is we don't know. So there are multiple collections here. The ones that most people are probably going to be most interested in would be, for instance, the Clinton email. So on the same site, you'll be able to tell, for instance, when it is. Secretary Clinton was very busy. What parts of the world she worried about and worked on. And this is simply a matter of just counting the countries that you find in the collection and mentioned in the collection. There's also the most frequently mentioned people in the collection. So you can get some sense, about what Sidney Blumenthal was up to. So that most of the collection, is from the era of 1945 to 1980 approximately. But what we're trying to do by including some more recent materials like the Clinton email is just to show what's possible, when you begin to aggregate and search more recent records. I'll just show you a couple more things since some of you might actually find them fun. So that would include, for instance, an n-gram viewer. N-grams are just ways that data scientists talk about words. So an n-gram is one word. If it's a 1 gram, it's a 2 gram if it's 2 words, like human rights. Some of you may have heard of a former colleague of mine, Sam Moyne, who made an argument about how nobody really talked about human rights back in the 40s. It was really about the 70s. Well, we can now begin to test those kinds of claims by looking at a database, in this case, that amounts to almost 580 million words, that represents a large part of the documents that were released by the U.S. government over the last half century. I'll just do one little thing that some of you might find interesting. I'm going to look for Moyers, and I'm going to look for, why not, Halperin. And if I do it, it's not about ego, right? I'm just interested in kind of the rise and fall. And so you could do these things. And there's lots more you could do. So I would invite you just to have some fun with this. There are, different kinds of tools. There's a whole range of them. And, what I'd like for you to do especially is if you find this worthwhile, if you think that others might be interested in it and might even like to get involved in it in some way, then please reach out to us. And when I say us, I'm talking about the whole team. So let me just finally give a shout out to Rohan Shah, who's a project manager. And it's a big group. There's Samir, there's Cheryl. And we also have folks, Sipand Ansari and Mohammed Smawi, who aren't with us today, but who did a tremendous amount of work to create the archive and make it accessible to all of you.
So thanks for your attention.
Thanks, Matt and Ann. We'll move straight on to the next panel.
Get comfortable.
Thank you. Okay, should we start? It looks like, well, first of all, I'm Nick Lemon, the moderator, and you can see, these are Robert Freeman, William Hoserland, Miriam Nisbet, Frederick Sadler. You see their name tags. You read about them here. I don't want to give lengthy introductions. Although it looks like this panel will last 2 hours, it actually won't last 2 hours because we have what they call in television journalism a hard out at 4 p.m. so that people can go to the next thing, which isn't here. So we'll move it, and I think Michael would be happier if we even didn't go that long. So we'll move at a fairly brisk pace. I want to start this is somewhat unrelated to what we're talking about, but just to use a moderator's prerogative to respond to something that Tom Sussman said at the end of the panel. You think I'm going to defend my profession? I'm actually going to say, amen, brother, and you don't know the half of it. This is not a room full of journalists. This is a room full of non-journalists with a few journalists. I haven't done an exact head count, but it's way under 50% journalists, even though we're in Columbia Journalism School. Fall of 2003, when I was starting as dean here, I was sitting at my desk one day, and the phone rang, and it was a young woman who was a senior at Harvard College, and she was writing a senior thesis on the media reform movement. And she said, like on the old TV show Columbo that some of you may remember, she said, there's just one thing I don't understand. Why is it that in all the discussion, all the archival material on media reform, there's never any journalists present? And I said to her, that's a great question, and I don't know. And I started thinking about it more and more. And my best answer to it is that journalists are subtly and overtly brainwashed to think that we're kind of like the cowboy riding across the range, the great man or great woman theory of history. We're the heroes of the drama of public information and accountability. And so we're trained not to pay attention to the contexts, legal, regulatory, and economic, in which we exist. And this is unbelievably seductive to journalists, this view of ourselves for all the obvious reasons. So, any room like this, whether it's a conversation about media regulation, whether it's a conversation about nonprofit laws and how they can and can't apply to journalism, whether it's the conversation the FTC has started on so-called native advertising and whether it's deceptive. You can almost guarantee journalists aren't going to be there. And so I think it's really important for this school to be as involved as possible in hosting these conversations as we're doing now, and to trying to create, bring journalists into this conversation that we really need to be in. One of our panelists told me, which I hadn't known, that back in the 70s, our dean at the time, Ellie Abel, who I think later went on to head your program, right, Jay? Was very active and essential part of these conversations. And through Michael and others, we're still an active part of the conversation. We heard earlier today and throughout, the Freedom of Information Act was a near thing. It wasn't a response to overwhelming, popular and political demand, and it could easily have gone the other way. So it's as big as it's become and as honorable as the work that all our panelists do. It needs constant attention, nurturing, and protection. And there aren't a lot of institutions out there on the freedom of information side that stand ready to do that. So I think that the participation of institutions like this is essential. And thanks to Michael and his colleagues for doing this. I only wish there were more journalists in the room than the few that are in the room. If I can just end this little speech with a corny analogy. Some of you may be following this less attentively than I am, but there's a big basketball championship series coming up, featuring, by common assent, two of the greatest professional basketball players ever, LeBron James of the Cleveland Cavaliers and Steph Curry of the Golden State Warriors. Now, if you're as old as I am, you remember that a certain amount of years ago when they were drafting the Freedom of Information Act, in basketball you weren't allowed to dunk, and all shots were 2-point shots, not 3-point shots. So those two rule changes apply especially respectively to LeBron and Steph Curry. So yes, they're two of the greatest basketball players of all time, but that's partly because contexts change and rules change. So even if you're one of the greatest journalists of all time, what makes your work possible is things like FOIA and various other things in the sort of regulatory, legal, economic realm. And I wish more of us would participate in that realm. But I'm really happy that the school, at least institutionally, is deeply involved here, and I hope that continues. Okay, end of sermonette. If you can think of FOIA as as they say in economics, supply side and demand side. My panelists are the supply side. Probably the majority of the people in the room are on the demand side. So they're here to tell us what life is like in the real world of, I assume it's real, right, of responding to FOIA requests, both in the sort of day-to-day sense and in the larger sense. In the interest of keeping things moving, we're going to dispense with formal opening statements, and I'll ask a series of questions to each panelist serially, and then we'll sort of get things going with follow-up questions and comments, and then we'll go to the audience at a certain point. We've sort of agreed that in the part of the session involving myself and the panelists, there's one topic we're not going to discuss, and that's Hillary Clinton's emails. So just in case, and the reason for that is that it's sort of like Pandora's box. We don't want the whole panel to be about that because there's a lot to talk about. So I don't want you to think, I've lost my reporter's nose for news, and if you want to ask about it during the question period, please do. But that's why I'm not. I want to start by asking, a series of questions about kind of the real world of FOIA. There's a tendency to think FOIA demand side is primarily journalists, scholars, and kind of engaged, what Michael calls informed citizens. Who else is at the party? Who wants to answer that?
What the hell? I'll start.
Okay.
Because as a recent retiree from the federal government, no one had to review my remarks in advance, so
Right.
I can pretty much come up with anything that I want to, unlike Bill. But like Mary, by the way, we've all known each other for years, so if I put them on the spot, they'll kick me later, and I apologize in advance. Who else is at the party? Unlike many of the other agencies whose requests have been discussed, 85% of my users were commercial. And this was primarily what we would, and this is a loose interpretation, it's industrial espionage. It's information on your competitors. It's what's in the pipeline that would become something that is in contact or would be a competition with my kind of information. It's students who want us to do their term papers. Less than 6% of our requests were ever media, and I would say, I don't think Sarah Cohen's here, but she was remarkable to work with. I love working with the New York Times. It's the trade press that's some of the most difficult. But the overwhelming majority of my requesters were looking for information that was arguably worth millions and millions of dollars.
So then just to follow on that, and then I know you want to add, what are they looking for? How do their requests fare? And then what do they do with the information once they have it?
If I can
go
weigh in
ahead,
on
Bill.
this here. So thinking back to what I thought was a very interesting construct that Cass Sunstein put forward last night. If you're talking about putting records into the two buckets of, let's say, input and output, at the FDA, the users are primarily focused on the output of what we're doing, the final decision on let's say, an application to market a medical device. Previously, in other agencies that I've worked at, folks have been more interested in the sausage making. They want the input sort of data about how decisions were arrived at. Here, our user base is a little bit different in the sense that their goals are different.
If I may, I'm from a different world. I work for the state of New York for a little agency called the Committee on Open Government. Our first chair was, in fact, Dean Ellie Abel. And I've had the same phone number since 1974, which means either it's a pretty good job or I'm in the biggest rut ever created. I'd like to think that it's the former. And our function is really somewhat unique. We offer advice, guidance, opinions, either verbally or in writing, to anybody who has a question about public access to government information in New York, not under FOIA, but under FOIL, Freedom of Information Law, as well as our open meetings law. And going back to your percentages, we hear from everybody. We receive about a third of the inquiries from local government officials, a third from the public, about 15 or 20% from members of the news media, others from state agencies and the state legislature. Our only goal is to give what we believe to be the right answer under the law. Doesn't matter who asks the question. I don't need permission either, which makes the function somewhat unique and pleasurable. And I've said this so many times, if I don't upset somebody in government every day of my life, it's because I didn't go to work. And I get pleasure out of it, and amazingly, the government lets me do it.
So I've had the pleasure of being in several different places in the federal government, and I have been a FOIA officer at the Department of Justice, and more recently heading the Office of Government Information Services, so providing mediation services, among other things, to a customer base that was all 100 departments and agencies, as Melanie mentioned in her talk. and the public. So pretty big base of customers. And I have to tell you, people coming to the Office of Government Information Services, OGIS, for assistance, whether it was at the beginning or at the end of their rope with a request, was incredibly diverse. And I would say it represented, our customer base represented a really nice sampling, including, I would like to say, a fair number of media people. I would like to take this opportunity to just add into the discussion, because it's come up so often, the whole idea of the corporate requesters or the business requesters. I think, and Fred and Bill are going to have a different viewpoint on that from the FDA. But one change that I have seen in the last, say, 5 years that I think is a really interesting development is a large increase in businesses asking for data that they're then going to turn around and use to do all sorts of incredibly innovative things with health data, with transportation, with financial data. They're building things. So there are a lot of requesters out there that are asking on behalf of businesses, but it's a really different it's a different way of asking for and a different way of using information that I think is really laudable.
Well, so the use by businesses, I think it's probably fair to say it's an unintended consequence. Is it? I'm hearing a couple of you say it's an unintended consequence, but that's great. Businesses are citizens too. Fred, you were putting a little more negative spin on it.
Well,
how do we to think about this?
I was going to bring up an interesting topic because I was having a conversation with this delightful lady here from the UK about how the ability to withhold documents or deny requests is different between the US and the UK, and the UK has some elbow room that we don't have in the United States. So we need to differentiate between easy and complex, and then we're going to have to go first in, first out. So when I walked in the office to become after working up the ladder within the agency and serving in several management positions, I became the FOIA and privacy officer for the commissioner. My backlog was 21,000 at that point, and it was rapidly climbing. So when I realized that one requester had put in 9,000 requests, we set up a meeting, and it turned out that they were putting in requests asking for information to resell because they might find a client and it might be useful, and they wanted us to reorder our priorities and move the request ahead for whom they had paying clients that wanted access to the record immediately. I went to great lengths to explain why this is not worth it, why it, from a legal standpoint, and how this is contrary to policy and Department of Justice and what the courts would do with this. And they, that day, withdrew 7,500 requests. So I had this stellar reduction and nearly got an award from Melanie, which you still owe me. But there are these instances in which individual requesters are clogging the system, and I see I could talk on this forever, but there's an interesting publication called Fierce Government IT that quotes Steve Aftergood, who is a well-known scientist with the American Federation of Scientists, frequent testifier before Congress, talking about how this is happening now in the Defense Department, that a single individual is accounting for, 25% of the total requests in that department, and clogging the system and preventing things from coming out. The UK has the ability to restrict the number of requests or the volume of material. We don't have that. So if I've got 3,000 requests from somebody who wants information that would be nice to know, and my typical request is 50 to 250 pages of hard medicine and science, pharmacokinetics, biostatistics, pharmacology, chemistry, not only is this going to be very time-consuming, but I can't just put anybody on this. Now I need a FOIA officer who is not only just generally trained, but probably a subject matter expert, because we have personal liability under the law, and no agency is paying for us to have liability insurance. So if you want it, it's coming out of your own pocket. But if you make a mistake and post something online, you are subject to litigation, you've embarrassed the agency and so forth. So that's moving along in a, I just bifurcated your road there, but.
No, that's, but let me ask about two other categories that are maybe related to each other of requesters, just to get your take on it. And those are people sort of in the political world. Category one would be a campaign or a politician often doing opposition research on an opponent. And the related category two would be a kind of watchdog group or advocacy group that's trying to, well, get information. How big are those kinds of actors in the system these days? And I know it must vary from agency to agency tremendously.
I can offer something. In New York, you have 100 federal agencies. We have 10,000 agencies in New York State. Cities, counties, towns, villages, school districts, public authorities, and they all have the same kinds of issues that you just raised. People running for office, requests made for political purposes, requests made by interest groups. And there are interest groups all over the place, and they spring up based upon what happens to be current within a community. When hydrofracking was an issue in the southern tier of New York, there were lots of citizens groups that came up pro and con and used the Freedom of Information law constantly. Windmills, a big issue. You don't deal with them so much in Washington, I suppose. Maybe you do, maybe you don't.
No.
But we deal...
Not on the Potomac yet.
Not on the Potomac. We deal with real life. You know, is the math teacher really certified to teach math? What does the superintendent's contract look like? Is he or she getting too much money? These are issues that hit people so often in their families. They hit people in their pocketbooks. That's where the request, that's where the interest really comes up. And my belief is, in general, that FOIL works better as the unit of government diminishes in size. You make a request to a New York City agency, they really don't give a damn. You know, if they're sued, they have the Corporation Counsel's Office to defend them. State agency, same thing. The Attorney General defends them. They don't care. But you know, I live in a place called the town of Bethlehem. It's not a tiny town. It's about 35,000. If it is sued under FOIL, gee, the public's going to know about it, and they're going to be upset, and they're going to ask why. They're going to ask why. There is simply much better and direct accountability as the unit of government decreases in size than what we've been hearing today. I don't think that the federal government cares very much. Melanie, I apologize to you, but I think that in Washington, maybe too many people have just lost track of where we ought to be. What is the law about? What is the law about? It's about everything being available unless disclosure would hurt. Come on, you classify millions of documents. Most of them are garbage. Most of them are garbage. WikiLeaks, 400,000 documents. How many? We really did know that Iran was developing a nuclear weapon. Why would that have been classified? I think we have to look at institutional policies. Privacy, the phrase in the law, is unwarranted invasion of privacy, not just anything that identifies somebody. You know, and I think our courts in New York have been a little bit more serious about the obligation of an agency to meet the burden of proof than they have been in Washington, where, from my perspective, the courts have just rolled over for federal agencies. Fortunately, that happens sometimes in New York, but certainly not all the time.
Let me, go ahead, Miriam.
Nick, let me, I disagree with you, Bob, completely about people not caring. From my experience, which is about 25 years in the federal government, and also I was outside the government as well, people who hold these jobs really do care. And in some instances, you may have leadership in the agencies that consider this to be a very much a, you know, do it as you can, we'll put whatever money we can find, and that's not going to be very much. But in many agencies, particularly the smaller agencies, the people at the top do care about this. They take their FOIA responsibility very seriously. And I think that's been all the more so in the last, you know, in the last 7 or 8 years, particularly with open government, because there is now a spotlight on disclosure, on transparency, on openness. Everybody's talking about openness. People are no longer saying, what is FOIA? People are no longer saying, why is it important? And the people in the agencies who are entrusted with this responsibility, for the most part, not completely, but for the most part, really are trying to do a good job. They're frustrated.
You damn right they're
They're
frustrated.
very
Yeah.
frustrated.
Yeah,
and,
very much.
And the requesters are frustrated.
Well-
There's hostility on both sides as well, but that's where trying to change the mode of operation, trying to have conversations, focusing on dispute resolution, all of those are ways, hopefully, that that's going to change.
Well, let me interrupt for a second. Go ahead, and then I'll
Speaking
interrupt.
from New York, it seems to me, yes, I would agree that many people in government are serious about their capacity to comply, but what we see is a great deal of control maintained by executives. Executives at the top, the mayor, the governor, and in so many instances, people at the agency level can't do what they're supposed to do until they get the okay from whomever. And sometimes it's too late, sometimes it's wrong, and sometimes it is for political reasons. You know, we heard before about public relations people. We call them flacks. Why do we call them flacks? Because they're there to protect the boss, and that's what they do. And it seems to me that back in the olden days, 30, 40 years ago, the PR person in an agency would actually talk to reporters and help them out. In so many instances, from what I see, that just doesn't happen anymore.
That is a
Well,
problem.
okay.
Yeah, both of us.
you
Go ahead,
both-
Bill.
Go ahead, and then I want to pivot a little.
Yeah, I was hoping to pivot back to what I think your original question was that begat this exchange regarding the use of FOIA by watchdog organizations or other entities for research purposes, political or otherwise. I think, was that sort of the gist of your...
Yeah.
What ends up happening for somebody like me, I'm speaking only for myself, and it's in my, personal capacity. My undergraduate degree is in journalism. I went to the dark side and became an attorney, but I'm a journalist who happens to be an attorney, and not the other way around. So that's sort of the starting point for how I approach my job. But with that said, I'm sort of caught on occasion in a weird spot where you have to be blind to who the requester is and what their intended purpose of the use of the records is. For example, for release purposes, when I'm doing my release analysis, I don't care whether you are a senatorial committee doing opposition research on a candidate for office, or whether you're an individual who wants to wallpaper their bedroom with these records, or whether you're writing an article. It doesn't matter when doing the release analysis. However, there are interests from other entities that have to be weighed in. Sometimes they're commercial in nature from a third party who's submitted information to the government. Sometimes it's executives or other stakeholders who may have an interest in the release, shall we say. So it's really an interesting position to be caught in.
Right. Fred?
Melanie mentioned that there's 100 different federal agencies, and that means that you're going to deal with 100 different public affairs offices. I found that if I spent some time with these folks and provided FOIA training, they were very willing to participate with us. So I had the opposite reaction, I think, in many cases. Working with public affairs means that we can initiate proactive release by creating something. Now, I'm in public health, so there's more of an immediacy to release information about a product that could result in E. coli or listeria or whatever bug happens to be out there. But we've been able to disseminate information fairly easily and quickly on a proactive basis for most of our major food recalls. And the idea is to be proactive and let the consumer or the individual have enough information to protect themselves. So these pages for us are divided into consumers, regulated industry, medical practitioners, and symptoms and emergency use, and not as much in your area. This is the bigger issue with food. I just came back from a series of meetings with Chinese officials, and this was the big issue in China, is what should we be telling people? So I think a lot of it is local culture and receptivity.
Let me ask, this is related but not exactly the same line. It's been used once on this panel, this sort of plumbing type word, clogged, is often applied to the system. And there's several pieces of pending FOIA reform legislation. And I wonder if one of you would address, you don't have to say you're for it or against it, but just brief us a little bit on what might happen in the near to medium term legislatively, and does that sort of have to do with unclogging what's clogged?
That's a wow. You know, I think that the difficulty, and Melanie mentioned it to some extent, involves the development of information technology. In the olden days of paper, gee, if we couldn't find it, that was the end of it. The request did not, in the words of the law, reasonably describe the records. Today, you know, we go to what's stored on our computers, we type in your name or my name, and all of a sudden we have 9,000 documents that we have to review to figure out what's public and what's not. And I suppose the question is whether a request of that nature is reasonable, and based upon standards offered by the courts, for the time being, it seems to be. The question that I have is, what do we do about that? Is it really reasonable? Should government be put in the position of having to deal with a request that might involve hundreds or thousands or even millions of records, which in many instances have to be read in order to determine what's public and what's not?
Well, you're opening up a number of things I want to pursue. Let's start at the basic level. I believe there's 3 pending pieces, federal bills. What do they say?
3?
More than 3? I have
there's
S-337, H.R. 4922, and H.R. 653, but I may have gotten that wrong.
There's a House version and there's a Senate version, and this is either the 3rd or 4th consecutive year that these have been implemented. Miriam and I was privileged to sit on the panel before the House of Representatives a year ago with Miriam, and we talked about ways in which some of the implementation issues that were included in these bills are not really being addressed. And I remain convinced that we're asking the wrong questions.
Just to go back, just for people like Tom and I who are from Louisiana, what do the bills say? What would they do? And I point out that Tom's from rural Louisiana, so he needs even more help.
Audit agencies' compliance with and implementation of the FOIA requirements, catalog the number of exemptions. It would expand the foreseeable harm test and codify it, which I think is a reasonable test that dates back to what maybe Clinton 1 as opposed to Bush 1 and Bush 2. I'm not going there. It does not address an awful lot of the issues other than to say enhanced technology and enhanced posting. There are no resources. There are no requirements for filling a FOIA job. It doesn't measure anything under a grade 9, so it doesn't pick up the lower levels. What am I missing? It's basically a codification, I think, of the Obama and Holder memorandum.
Basically, but let me also just say, to clarify, there is a House reform bill, there's a Senate reform bill. Both of them have been passed unanimously by each House. They are a little bit different. There's a really good analysis out there by the Congressional Research Service that's a side-by-side comparison.
And that's a public document, by the way.
Yes.
It's on the net.
It is. Steve Aftergood made that available.
It's not a public document.
No, but by Steve Aftergood.
Okay, I
yes.
stand corrected.
It's available. Any of us can look at it.
Well, it's on the crs.gov website now.
And, you know, again, as happens, it seems, every 10 years, there's an effort to enforce the deadlines, to really put some teeth into enforcement if those deadlines are missed, including agencies not being able to charge fees if they have gone beyond the deadline. There's also a provision about having an online portal that agencies still would be able to choose whether or not they want to do that. But again, as Fred said, the bottom line in both bills is there's no additional money. So we're back to the resource issue, which is, again, a huge frustration for requesters and for agency people alike.
For those who are free to discuss it, which I know Bill is not, would any kind of prioritization or limitation on the size or number of requests help with the system?
personal opinion, since I'm in the seat that Bill can't speak to and Miriam can, because you've seen Miriam's function has been a godsend, and we need to go more towards mediation than litigation. But I'd be very surprised if the media did not rise up in arms about this to limit the number of requests. But I have been sued repeatedly and named as a personal respondent on the part of the agency when more than 1 million records were at issue. We had 20 working days, and on day 21, I was sued. And this has happened over and over and over again, and Bill is reaping the rewards of one that I left behind. It took them 6 months to get my name. Hey, no problem, but it took him 6 months to get my name off as an inappropriate respondent, and that was after I left the agency. So things are not moving quickly, but there needs to be something in there. We had a request for 1.4 million records that dealt with the potential link between autism and pediatric vaccines. The requester was not willing to modify this at all. They took the agency to court. The agency laid it all out, desk-to-desk search, massive amounts of duplication, heavy medical and scientific issues, a lot of scientific jargon that is completely beyond me. And the court made the requester go back and refine it, and they came back by cutting it almost 3/4. And then it took months to go through this because it's heavy-duty chemistry and a huge amount of patient privacy data. So these aren't necessarily the simplest things in the world. I'll throw out another one. We got sued 3 times for a cardiac pacemaker lead that failed. The lead connects to the ventricle. It connects the ventricle with the pacer. It's a demand pacer so that if the ventricle fails to fire, this would go. The lead disintegrated in place, and we had several deaths. 3 people, unrelated, asked for it all. All 3 sued on day 21. We had 21,000 pages at issue. Now that I've got 3 or more requests, I can go back and do a proactive release. But to get back to this gentleman's question, we really don't want to lose sight of some of the problems. And now I'm moving on beyond, and I apologize to my esteemed moderator and host. It is against the law to put anything on a government website that cannot be read by a voice synthesizer under Section 508 of the Americans with Disabilities Act. So how many databases or software options are there in the world? And I'm getting stuff internationally. I've got photographs and diagrams and pictures and chemical formulas and, God help us, foreign languages. All this has got to be remediated. So I can't put stuff up and save time and make multiple releases. I'm off subject now, I know.
No, you're on. I mean, what I want to press you on is if we could sort of have the best of both worlds where you get to be retired but also emperor of the world. What would you actually change FOIA along the lines of some of the things you're
completing? I would limit the
completing?
number of requests that could be submitted and the volume of requests that be submitted. I would require a meeting, could be Skyped, where you talk about what's available and require the requester to make selections and close the request out. They want to come back in, that is their right. You're not cutting them off. You're simply saying 1.2 million pages can't be done in a 30-day or 20 working days.
Sometimes I have to remind people of the Rolling Stones principle of law. You know that one? You can't always get what you want. But if you try sometimes, you just might find you get what you need. And I think that your suggestion is a good one. It's the human touch. You talk to people, and sometimes you say, you know, your request involves 1 million documents, and they have to be read and reviewed and redacted, and it's going to take a hell of a long time. Are you interested in narrowing the scope of your request? Now, for what it's worth, in New York, we have a 20 business day requirement after acknowledging the receipt of a request, but we have one more possible extension. The law says that if you need more than 20 business days, you explain why, and you offer a date certain, a self-imposed deadline. If that is reasonable based upon attendant facts and circumstances, you're complying with law. And you might say to the applicant, yep, we promise, we swear, we will make the records available in whole or in part by, October the 17th, 2017. If that's reasonable, you're complying with law. But in most instances, people don't want to wait that long, so they will narrow the scope of their request. They will make it more reasonable and rational. I think that in so many instances that if we can't reduce the number of requests, if we can't by statute reduce the volume of a request, That's something that tends to work in some instances, not all, but some.
That's, I think the human touch is what it makes a big difference. So one thing that both of these federal bills would do is to give more robustness to and encouragement for requesters to use the FOIA public liaisons at the agencies as well as OGIS. So expanding dispute resolution, expanding that ability on both sides, and the willingness on both sides for there to be conversations. Does it always help? Absolutely not. You're going to run into the person who says, I want it, I don't care, I'm not going to narrow my scope. But you know, that is really not the outcome in most cases. People, if they are approached and if you can have a real conversation with them, they really are willing to work with you.
Aren't both bills set up to insert your office into the process to an even greater extent? I mean, there were a lot of additional OGIS responsibilities added with no resources.
That's true, but the one that I'm really referring to is that when there is an agency denial, that a requester would not only be told of his or her right to appeal, but also the right to seek mediation services with the public liaison or with OGIS. But I think really what we're also talking about is before it gets to the point of there being a denial, that's really the best time to have the conversation. Is not, we've sent you a letter that says no, and now it's up to you to request mediation. It's really reaching out before that ever happens.
Good.
I can't stress enough how important that low-tech sort of solution is in terms of communicating, picking up the phone, or having a face-to-face meeting to say, okay, here's what we're dealing with, let's figure out what we can do. How important that is to resolving problems. However, having worked at, well, I won't comment on the legislation, having worked at an agency where we did have e-discovery, an e-discovery tool, I can tell you that did make life a little bit easier, where if, for example, there was a hot item of significant public interest and a journalist, for example, had requested the records, I might be able to obtain the records, or at least a subset of them, rather quickly, and then still pick up the phone and say, I understand this is hot for you, and you're ready, you know, you want this now. Here's what I'm dealing with. Let's figure out what you want and how quickly I can get it to you. So, you know, the combination of those sort of solutions is very, very helpful in problem resolution. I don't think either one is the panacea for all that ails us to the extent that we are.
Since we're right at the edge of this, I just want to go over the edge and do it directly. For requesters, the small number of journalists in the room, their larger number of students, what are your sort of tips for requesters on how to request successfully? You sort of said it, but I just want to kind of get you to repeat it.
Well,
Anybody.
Well, I can say, I always encourage folks to call us before a request is submitted, if you can, and say, this is the general, I don't think it's reasonable for an agency to expect a requester to have a deep level of knowledge about the agency's systems of, file systems and that sort of thing. But to the extent you can contact us, say, this is where I'm headed, these are the types of records I'm looking for, what should I put in my request? That makes life, it scratches my back as well as the requesters, I believe. So that way we spend less time parrying and jousting over the scope of the request, instead we just get to the point.
I too suggest that applicants find out how an agency maintains its records so that an appropriate request can be made. But aside from that, we've written just short of 25,000 advisory opinions over the course of years. Thousands of them are available in full text online. I suggest that people go to the website. If they're making a request for something that is covered in an opinion, attach the opinion to the request. Say, here's the opinion from the Committee on Open Government, which, of course, anybody can reject, but often they help. The other suggestion, if it's a member of the news media, call me. call me, and I'm always on the record. I said before, I don't care who I upset. Sometimes, not always, sometimes the informal opinion, even at the request of a reporter who knows the answer. Reporters can't print their own opinions. They call me for the quote, and I'm just not hesitant about giving it. Sometimes that encourages compliance with law.
Yeah, I have to agree with everything you just said, and well, all three of you, but stay in contact with the requester, get familiar with what's on the website. My agency, or former agency, went whole hog into this. We have 3.2 million records online, not documents, or I mean, not pages, but documents. So, and 66 databases. So the more that an agency gets up there, the better. When I came in, we dropped from 52,000 requests a year to 11,000 requests a year because of that over a 2-year period. So the more that you have up, maybe the harder it is to find what you want. A lot depends on how the metadata has been put in there, and maybe you want to connect with your in-house people to look at that. But I think that that's a legitimate option. You need to go both ways.
I mean, I think one reason reporters don't call you more often is that we tend to assume, and I'm saying this so you'll correct our impression, that the FOIA request, lands right on Dick Cheney's desk, or whoever it is, and that there's no airspace between people who do what you do and the policymaker you're trying to get to give up secrets. So if you call them, they're part of the dark side, and they're just going to try to deny you information. But we shouldn't think that way, to the extent that we do think that way.
Yeah. Well, I think that's one of the that's been one of the goals for having the Office of Government Information Services. And yes, there are a lot of things that could be improved about the office. This is the office that was created in the 2007 amendments. It wasn't set up until the end of 2009, so it hasn't been around that long, and it's got a pretty small staff. However, because it is a place to go to that is not, that is outside the agency, that is perceived as being a fair and neutral party, even though part of the government, I think that has helped, in fact, encourage people to continue to use the services.
Go ahead, Fred.
Just one last thought on that. I said this in my testimony in Congress last year, but I really think if Congress would address the 508 issue, that federal agencies could put up anywhere from 20 to 50% more documents almost immediately.
Tell us, people from Louisiana, what's the 508 issue?
The Americans with Disabilities Act has a section called 508, or numbered 508, which says you may not have documents on a federal website which cannot be read back to the visually impaired.
Right.
You must convert a document from whatever software form it is to the software form that will allow it to be read back. To put it into perspective, we had an application to, I say we, they, you.
I'm one of them now.
You're one of them, yeah. We had a 248,000-page document to put new additives into tobacco products. The law requires that to go online. We were staffing up at that point because it was a new organizational requirement, new statutory mandate, and we did not have staff on hand to convert it. We sent it out for contract bids, and the cheapest bid for the single document was $90,000. You can't put a large number of these documents online, even though the statute requires it, because you can't afford it. So, and this goes back to my cardiac thing. We posted it, but what happens is you've got to go from your agency to your department, get a waiver for 508 posting. You may post it for 20 days. On day 21, they will remove it unless you have remediated the document and put it into this new software. This can be extremely expensive and time-consuming, and I brought it up. And I don't think anybody wants to touch it. I realize it's not a popular thing to say when we're excluding a component of the population who are physically impaired. But, and then we get into the software issue, which I will not go down unless you want to hear that.
Well, I want to go to audience participation soon. There's one other thing that's come up implicitly several times I just want to spend another minute on. A lot of, it's sort of the human touch. A lot of uninitiated folks out there would say, wait a minute, why can't all this be automated in the digital age? So could you all address a little bit, why can't it, what can, what can't? Are we likely to see things that are done by hand now not being done by hand in a few years?
Well, what do you mean by it?
It, somewhat what Matt was talking about in his presentation. In other words, can you get a request and imagine an algorithmic way of making judgments, or most of the judgments you need to make about the request, which would speed things up?
The software doesn't exist. And I have had government officials say to me, why didn't you just run it through the software, redact it, and then post it online? Not even aware of the 508 issue, but when we talk about electronic redaction, what we're saying is, I've got a 10,000-page document, I'm taking out a software vendor or a raw material supplier or the customer list 13 times, I get to page 793 and I realize the firm gave it out. I need to go back and restore that. The electronic way to do that is best. I can hit that line, but I can't use judgment. Robert and I were talking about this on our last conference call about the privacy issue, which, as Melanie described, is our single biggest area. I can set it to take out Fred's name, but if you say, I've got a Euro-American male in suburban Maryland who is retired from the federal government, was the head of FOIA and privacy at this particular agency, and has now suffered cancer and went through the... 300 people will know it was me. So the software will not pick that up. It's contextual, and you've got to sit there line by line, word by word, and make a review in order to make the determination and then remove it electronically.
It's also interesting, if you followed the recent Facebook issue with their news feed, that in the private sector, folks who claim they don't have the human touch at all and are doing everything algorithmically are secretly using humans to make these kinds of judgments.
Not to mention facial recognition now.
Yeah.
So, yeah, you were going to say...
Well, I just, there are several aspects of using technology that, I mean, we have many different baskets here that we can put things in. There's the technology that is increasingly being used to take requests in and to track them and to eventually make the records available online. So there are several different ways of doing that, one of which was mentioned earlier is FOIA Online, and more agencies are using that. But there's probably not yet the ability, federal government does not yet probably have the ability to have one portal that fits all needs, but we're moving that way. There's the technology to review the documents, the e-discovery kinds of tools that can certainly help, the artificial intelligence that Matt was referring to. Those are all becoming increasingly available. But again, you've got to remember there's a difference between documents that are born digitally and the older documents, and that makes a big difference in terms of what can be done with them and how you can use technology, at least for a while. One aspect of technology that I think we're beginning to see more of, Sarah Cohen talked about it this morning, and that is the whole idea of encouraging agencies, encouraging the collection, the maintenance, and the disclosure of information in formats that are more standard, that are across the board, and also building in accessibility when they create documents. We're seeing more of that, but I think most people would say, great, we'd love to see more of it, but it's, it takes time and it takes money.
And even when you have a requirement like that, agencies don't in every instance abide by it. In New York, there's a section of our law which specifies that when an agency is developing a new electronic information system, it has to think about FOIL. It is supposed to design the system in a way in which it can readily segregate those elements that are public from those that can justifiably be withheld. And sometimes that works, and when it does, it works well. You automatically maximize disclosure. Concurrently, you automatically, in most instances, protect personal privacy.
Right, you're building a system that can be used for records management, for FOIA, for a number of needs.
So let me bring in all of you now with comments, questions, suggestions, et cetera.
Great panel. Thanks very much for your input, and great moderation at that as well, because we really teased out some of the key issues here. It's funny that, first of all, Greg Mitra from FGV in Brazil, and studying Latin America, being apprised of the way that identity and geography works into freedom of information compliance. It's really interesting that we have an inverse relationship in Latin America. The local works miserably, and the federal works outstandingly, because there's a reactivity at the federal level, the Hawthorne effect, that you're being watched.
Right.
And so, the federal governments work marvelously, and then the local levels are very difficult, which is the case in Rio de Janeiro. Second of all, the question of identity, and this is where the question lies, in Brazil and in other countries around the world. In fact, if you look on Wikipedia, India has a very extensive Wikipedia list of people who have either been killed or assaulted because of the right to information. This is very common in Latin America as well, to be intimidated because they know who is requesting, and especially at the local level, you can imagine it's not hard to identify who is requesting what information. You have intimidation, you have aggression, so forth and so on. And so one thing that we are working on in Brazil is identity protection, because if it's a fundamental right, then why should you have to identify yourself to request information, which is part of the law in Brazil and part of the law in about half of the countries in the world. So my question to you is, what is your take on identity requirements in general? And second of all, does it affect the quality of response? Okay.
If you want to identify yourself as Mickey Mouse, that's okay. And in fact, several of you have mentioned Mexico. When people ask me which state has the best freedom of information law, my answer is Mexico. And one of the reasons was I was stunned to find out that during the first year of implementation, 40,000 requests were made, 36,000 were made and answered via email. We know that many Mexican families don't have PCs in their dens. They don't have either PCs or dens, but the government was pretty serious about ensuring that the law be pro-poor. Well, we passed in New York, I think it was the first of its kind, a provision in our law that says that anybody can make a request made via email, assuming that the government agency has the ability to accept it. Why did we put that in? Because in 2005, there were many units of local government that did not yet use email. But if I submit a FOIA request using my personal private email address, you won't know who I am. You won't know who I am because I don't have to identify myself as Robert Freeman. It can be, again, Mickey Mouse. So the identity, the any person concept, it really extends to the ability to make a request without necessarily identifying oneself.
Instructions to federal agencies in Brazil, I know for a fact, because I know government people, are to not get in touch with the requesters, are to avoid personal contact with the requesters because of fears of intimidation, et cetera, honestly. And so what you're saying is to give a call first, give us a personal touch. And this is absolutely at odds with what's happened in Latin America. That's why everything is being automated and everything is on a platform, requests, appeals, responses, exceptions, et cetera.
I think you were next. This gentleman here.
So Roy Pellet, I'm a law professor from Israel. Two comments. First is on the technology, and I'm saying this as somewhat a technophile, and I want to be more optimistic and more pessimistic regarding technology than what mostly Fred said, because I think, unlike Fred, that technology is going to do much more than we think, and we've seen it, do remarkable things, and it's easily going to be able, not far down the road, to prevent, for instance, the issues that you mentioned about not only handling the name, but also other identifying characteristics of an individual and other stuff and algorithms and artificial intelligence and all that can do that. The more pessimistic side is that, and this is not just FOIA related, but I think it needs to be acknowledged in this context too, If we think of like that one day the FOIA officer will come into the office and just watch all his robots and computers handle everything and sit back, that's not going to happen, mostly because as technology does more, our expectations change. So we're going to be facing the same debates and same problems and same issues because just our demands from the systems are going to be different. So therefore, I mean, it's not going to make happier FOIA officers or happier requesters. It probably is going to make more information out there, which is also good. The second comment I wanted to make is about the exchange between Bob and Miriam, because Miriam answered Bob saying, you know, a lot of FOIA officers really care about what they do. And I work with government in Israel a lot, and I have the same sentiment, but I didn't hear Bob, and you know, correct me if I'm wrong, saying they don't, but what he said was that a lot of people in government are losing sight of what the law is about. And that's something else. I think people really care, but I think, you know, being inside the institution and sort of having the state of mind of what the requester wants to achieve and holding you accountable, et cetera, et cetera. And this goes back to a lot of what Cass Sunstein said, because I think he too really cares for a lot of things he said, but has a certain state of mind, which is very institutional and elitist. And so that's, you know, working on the state of mind of the FOIA officer is still a big challenge.
Any responses from Kilroy?
Well, a couple, because we heard a couple things. I would never send an individual's records to them unencrypted over email, because I cannot confirm that that server cannot be compromised. So if you want your records electronically, you're going to have to give me a written release with an original signature, not a fax, in order for me to release your records that way. I cannot guarantee your privacy or the protection of your healthcare data is one. Two, nobody ever wrote me because they had a good outcome. So on a busy month, we would get in excess of 100,000 adverse event reports a month from patients. And this would be internationally, but I would have the patient's name, frequently social security number, all of their identifying characteristics, height, weight, physician, hospital of administration. All of this can take you back through the system to identify the individual. And then the other point, before I climb off my soapbox, is the documents, when they're being released to someone other than the subject, in my world, require authentication. I don't want an insurance company calling me saying, your other guy hit my client, so I need the other guy's medical records. I'm dealing extensively with clinical data, healthcare information provision, Indian reservations, NIH Clinical Center, clinical studies on unapproved medical drug products, monoclonal antibodies, and that kind of thing, and healthcare delivery systems. So there's an inherent sensitivity that we would need to protect.
Well, I'm sort of struck by there's so many competing interests that we've discussed over the last day. And among those, I've heard several folks mention requesting FOIA logs, and that there's sort of this is a fundamental right, and there's an assumption, or there should be, that we should be able to find out who's asking for what from our government. And yet I'm sensitive to the types of concerns that we heard about that may exist in other countries. And if there was an American value that I would advocate exporting, it would be that this should be a fundamental sort of right that folks can enjoy without intimidation. But there's also some other aspects for which we have to consider. We might want your contact information, let's say, and I am being semi-facetious when I say that some agencies are not only old school, they're Old Testament. They might be dealing with significant amounts of paper records, and in order to get them to you, we might have to drop them in the mail. Now that's not my agency, but it could be some. So we might need to know who you are in order to get them to you. Or we might have a request from somebody without computer access. Let's say somebody who's a guest of the state. Somebody in jail.
I think
Don't put it on a
next,
CD-ROM. Do not put it on a CD-ROM. It comes back, it could be turned to a shiv.
Gosh.
I have had several of those returns.
It's pretty dark, Fred, but
Yeah.
I was also going to mention there's sort of a procedural consideration here that we have to contend with related to fees, which I know is probably a favorite topic amongst folks. But while I said earlier I don't care who the requester is for purposes of making a release determination in terms of are they exempt or not, for purposes of assessing fees, that type of who the requester is and what purpose they're seeking them for does matter. There's also a DHS Appropriations Act from, I believe, 2010 that prohibits intelligence agencies in the U.S. from releasing certain records to representatives of foreign governments. So there are these sorts of competing patchwork of interests that we have to contend with when we're dealing with requests.
Sometimes yes, sometimes you have to, sometimes you can't, sometimes you don't want to.
Bunch of hands are up, but you seem to have the mic, so you win the race.
My question kind of follows up on what was just said, actually. I have a question about the interaction between the professional FOIA staff at an agency and the political leadership. There was a very interesting article in the New York Times a little while ago about a FOIA request to the Army about head injuries, where the request was delayed because the Army said, let's see if we can get this information out to a different publication in a better way before we respond to the FOIA request. How do these generals come to learn that there is a FOIA request about a particular topic? What is the mechanism by which entities or equities of various types or interests of various types filtered their way up through the levels of government?
I can tell you, I mean, there was an AP article about it in New York City. When a request comes into a New York City agency, if there is anything that might be characterized as sensitive or might have a bearing upon the mayor's office, it goes to the mayor's office first, and the mayor's office pretty much says okay or not. That's how it filters up. You know, embarrassment or the potential for embarrassment is a primary motivation. Of course, people in high places feel that they're going to be embarrassed by everything, which means that so many requests unnecessarily go to wherever. The mayor, the governor, the secretary of state, who knows? We become loony. Yes, it's a technical legal term, yeah.
Let me try and answer for the federal government, just two typical ways that a request would come to be known by people outside the FOIA office. One is if there is, in the search for records, the records that are being sought are in the offices of very high-level people. So that's one way the request becomes known. Another is that agencies do typically let their public affairs offices know, the head of the official that they report to, they let them know what requests they're responding to. Now, the way it's supposed to work is we're telling you what we are disclosing. We've had these requests, and here's what's going out. And there is not supposed to be interference from, particularly from political appointees. Does that happen sometimes? It does. I'm sure, of course it does. I mean, we're human. We've talked a lot about the human touch here. That happens. But I think the more typical way that the requests become known has simply been through searching for and trying to find the responsive records. And so it gets to be known. And sometimes that can be in every corner of the agency.
I think you were next.
I just want to throw one more point in that will probably slow down the processing, and we touched on it. Miriam is absolutely right about the way that she described how these things become known internally. But if the document was an exchange between, say, my agency and another agency, case law and DOJ policy indicates that I will share the record with that other agency to confirm that I would not inadvertently compromise any of the material that they would consider confidential or proprietary in any way, shape, or form. So during Desert Storm 1, we were going back and forth between me and the Assistant Secretary of the Army. The question was whether or not anthrax vaccine would work on soldiers in the field. It was developed for cutaneous exposure for like veterinarians. And the question was, if Saddam Hussein had detonated a dirty bomb over a troop deployment and it was inhaled, would the vaccine work? So we went back, and I had an extensive amount of material on this. It took forever and a day to get it all resolved, but I needed to go back to the Defense Department, the Secretary of Defense, Secretary of the Army, in order to make sure that their information about possible locations where this could occur, you know, what the enemy factors were that would potentially result in that kind of a deployment, would, you know, result in exposure of American troops. And at that point, it's national security. So that slows the process, but it also notifies all of the top people.
I wonder if you all could talk about the relative status of FOIA officers within agencies. I'm sure you all have very high statuses or had very high statuses in your agencies. But the idea that Melanie talked about professionalization, creating a separate civil service track, suggests some degree of anxiety within an agency over what the FOIA officer is, whether they are somehow of a lower status than other folks, even beyond just the executive, but other civil servants, and whether that's an issue for FOIA professionals.
Well,
dive in.
Well, I can tell you the relative success of a FOIA office does, in large part, depend on the status afforded to the FOIA officer by the agency's management. So the more support the FOIA officer has from senior management, the better chance they're running a decent FOIA program, and vice versa.
Is there any way to develop that within an agency?
You have to.
One
absolutely have to.
Yeah, I mean,
Yeah.
personal relationships, but then, you know, you have theoretically folks who may come into a position and have their own biases and views, and you may have one status and, you know, with one set of leaders, and your status may change when the winds of change sweep in, and you don't know.
I have to look at this from a pragmatic standpoint. I mean, it was my job to administer the program. I had 134 people under me coast to coast. So I've got to deal with somebody in LA and then somebody up in Boston, and, you know, we also have foreign field offices at this time who are conducting inspections in India and China, because the overwhelming majority of generic human medications are coming in from those two countries. I have to have a senior, I can't have a generalist look at the documents. If you're going to look at a new molecular entity, which is what we would call a first-time drug, first of all, under the law Congress passed, I'm going to charge you $850,000 to review that application. So arguably, the material in there is going to be worth literally millions of dollars. I have to have a subject matter specialist, someone who understands biopharmaceuticals, biostatistics, pharmacokinetics. I cannot pick just somebody in, and they have to be developed. Our average mentoring time with someone who has got a bachelor's in the specialty area would be a minimum of a year, sometimes two, depending on the nature of the documents. Those individuals also have to have ready access to the subject matter expert. So if I'm looking at a cure for pediatric brain cancer, I've got to be able to talk to an oncologist on staff, because no matter what I know, science is advancing faster than my knowledge capability is going to allow me to understand. So I don't know if that answers your question. A typical FOIA officer in my agency would have been a grade 13, which is $80,000, maybe $90,000 a year. If they go outside, they could easily double it. A manager would be 100 to 100 and a quarter, would you say? At my level, and fees are charged, you know, I was only charging $90 an hour for my time, which was a fraction of what I was paid. And so now we're back to the fee schedule and whether or not that money can be repurposed to bring in subject matter experts. It's a circular argument, and that's not where you wanted to go. But
we have a bunch of other hands up and not much time, so I want to just keep going. Matt, I think you were next.
When panelists were referring to what algorithms can and cannot do, I think you're measuring it in terms of what you think reviewers can do when they look at the documents page by page. So have you, are you aware of any research as to the reliability of of individuals reviewing documents page by page for identifying private information, national security information, et cetera. Because to my knowledge, that study hasn't been run. We've not even seen that experiment. And so in the legal field, judges are now agreeing with the fact that, I think it's a fact, because when they do the research, they find that humans make mistakes. They miss things. And algorithms never tire. They don't get bored. And so I would just put the question to you: how confident can you be that your staff are outperforming what technology could do if you actually invested the money to find out?
Who wants to?
We've never found a software program that would do what you're suggesting. We've never found a software program that would do what you're suggesting.
Just research with the people you have already. To what extent do you have intercode reliability?
How much, yeah.
I will pose this question. Whether it would behoove us to spend the time responding to requests or to stop and sort of do what you're suggesting, which, in a perfect world, if we had unlimited funds and time, might be a great idea. But I could tell you this, too, about my agency. I'm sort of an anomaly at CDRH because I'm not a scientist. So, plus I'm a lifelong Buffalo Bills fan, so there's plenty of reason to question my judgment. And I'm grateful every day for the brilliant folks I have on my staff, who are engineers, nurses, microbiologists, people with different scientific backgrounds who can recognize the context that somebody who's not of the correct scientific discipline may not catch. So there's an element of art as well as science to the process. In terms of your question of is there any kind of study that we're aware of that has tested the reliability? I'm certainly not aware of one.
This is part of the reason if I had a backlog, which I left a backlog, but it was like 6% of it was when I walked in. If I find out that I've got a backlog that are looking at antibiotics and animal feed and genetically modified organisms, and the people who are slow right now are dealing with the infant vaccines and blood banking, I can't move that staff over because they don't have the medical and scientific background.
But he's asking a different question, I think,
But what we're looking at is can you set it up so electronically it'll flag?
No, I think Matt's asking something different, which is...
Then I apologize if
humans
I
are imperfect, so they're going to screw up X%. Computers are imperfect, so they're going to screw up X%. What makes you so sure, if I'm getting this right, Matt, that the human error rate is going to always be lower than the computer error rate? It's not just a matter of time and so on, it's just human imperfection.
Volume of litigation?
I don't know that anyone's done that study. Maybe the National Declassification Center is working on that. You mentioned yeah, but that would be a great place to be doing it.
Right, but just think of it. So the U.S. government has been creating official secrets since 1940, right? And all of you, you're overseeing collectively 2,000 people who every year are trying to identify, what it is that the government has to withhold. And yet nobody in that whole time has ever studied whether people are doing this in a reliable way.
We're identifying what we're required to release. That's the goal. That's the mindset we start with. But I don't know that what you're suggesting. I would have no basis to really give you a responsive answer.
22% of my requests come in from organizations who want copies of documents that are released to other requesters. And in many of those situations, not only are the documents going to be resold, but the client is the individual whose data was at stake, and they're using it as a way of double-checking what we're doing. If I'm not being sued, no news is good news.
Right, but you're still not really
but
engaging with what he's asking, except for Miriam, which is that it's a potentially studyable question, just how often humans make mistakes in reviewing documents.
I think it would be a fascinating study, and I would love to see the National Declassification Center. The PIDB has been making this recommendation. I'm aware of that, but I don't know of anybody who's done it.
Well, the question also sort of presumes that there's a definition of what constitutes a mistake.
Right.
Who's making
which
is what I'm getting at. Who's judging that? It depends on where you're sitting, I would think.
I think especially with redaction, I would guess. You know much more than I do about this. just an element of judgment here, as well as just strict,
Absolutely.
legal compliance. What do I redact and what do I not?
Absolutely.
Okay, sir.
Before we get to the issue of redaction, I'm curious about the issue of search and the fidelity and the faithfulness of the search to actually look for things. Of course, you guys are one of what I think of one of the stellar agencies as far as FOIA. After Bill reminded me that we'd done business together, I looked, and there were 45 emails that he and I exchanged on a single request. I can assure you I have 45 agencies that have never sent me an email. But here's the issue. The other day, we asked for a calendar of an agency head, now gone. We got 2 pages, which I found kind of curious that there were 2 pages of his calendar but no other pages of his calendar. So we appealed on the usual, are you serious? And got back, we didn't really search far enough, and that there's another, whatever that needs to be searched, another place. It didn't say whether it's a box or a computer or anything else. But that's really a black hole for us as requesters. We can look at the redaction and make some judgment about, that doesn't look so good, that looks okay. But we don't really know what happens in the search. And my question is, are there safeguards that you build in internally to make sure that all those people who are working for you have asked the right offices, that those offices have in fact responded in a way that would be appropriate, and that there's been some creativity in the search? I just am interested internally how search works.
You or me, or Miriam?
Yeah, sure.
Yeah, we'd love it.
We get the mic.
Melanie Pastegan. It's a perfect question for me because it's something that we focus on a lot in our training, because the standard, as you know, the reasonableness of an agency search can be challenged in litigation. And if a request goes to litigation, the agency has to set out with a sworn declaration all the steps they've taken to search for a particular request, and they have to be able to attest that they searched everywhere that the record reasonably could be located.
Okay.
So it's a detailed showing, and because of that, we use that as our standard in training FOIA professionals, because you never know which given request might possibly go to litigation. So our approach has always been to tell agencies, assume it will go to litigation, and you need to be able to document and show that you've looked everywhere that you reasonably could look for a record. So that's the standard that we would hold agencies to at the initial level. And then, of course, in terms of recourse, if a requester files an administrative appeal, the search will be looked at afresh by the agency internally.
I'm going to do one more question, then call time. Do you want to come in, David?
Could you say more about how exemptions are decided when they're going to be asserted, the role of the FOIA officer as against both political appointees and the lawyers who haven't come up yet in an agency? So, Miriam, you said on the former that political appointees should not be making calls here. But do you mean that just as a matter of custom and best practice, or as embodied in an authoritative legal directive? And then when exemptions arise, what happens to the lawyers? Because that's a legal question, I guess, at the end, whether B5 is triggered or not. And if lawyers come in at that point to supervene on the FOIA officer's judgments, does that potentially introduce politics through another channel, in as much as the general counsel's office is itself headed by a political appointee?
Well, that's a multiple question. So let me just try and quickly, certainly by custom and best practice, the decisions should be, and I would like to think always are, made by the FOIA officer. And that could be in conjunction with advice from the general counsel's office. It would be in conjunction with advice from people who have the substantive knowledge of the records and the subject matter. And it really is a matter of review and determining, in the first instance, the presumption should be we disclose everything unless it has to be withheld, and certainly depending upon whether the decisions about what exemptions apply and how the review is done is going to be vastly different if you're talking about the antitrust division than you are in the FDA or the VA as opposed to the State Department. So it's a matter of applying the understanding and the knowledge of the people who are familiar with the agency and familiar with the records. Sometimes legal counsel gets pulled in only when necessary, and sometimes that's something that's going to be involved every time. And certainly if you're dealing with an appeal, the legal office is going to be involved in that.
I think it also depends in part on the counsel's relationship relative to the FOIA office in a given agency. Now, I've
Right.
worked in agencies where counsel's office held a lot of sway, and if they said, the sky is purple, the sky was purple, and that was it. Versus I've worked at other agencies where they said, we don't want to be bothered, it's the FOIA officer's call. So it really depends on where you are.
Right. And just one other thing in terms of why it's hard sometimes for us to answer these questions is we've all talked about the 100 departments and agencies, but actually every department and agency practically is subdivided into multiple parts. The Department of Justice, I don't know, when I was there were at least 27 components. And so you're really talking more like 350. Not 10,000 units, but quite a few. So it does vary.
All right, I'm going to call time now, and thank you all very much. And maybe you'll be willing to continue the conversation informally.
Sure.
Michael?
Thank you. My personal thanks to the panel. This was great. We will reconvene here tomorrow morning. Breakfast, which was, for those of you who were here at breakfast, substantial. It was at 8. It's the weekend tomorrow, so the first panel will be 9, not 8:45. Sleep in. And the next event today is a reception. And for those who've been invited, which I think is most of the people in the room, but this is by personal invitation only, and that will begin at 4:30. Some of us will walk. It's about 20 blocks. So how shall we do this? Right, some of you will take taxis. Follow Kelly, who will help you find a taxi, but it'll be a short taxi ride, 6 or 8 minutes, I would think. For those who are walking, I'm going to walk, so you can find me, and we'll leave in a few minutes, okay? See you, I hope, at the reception and certainly tomorrow morning.
You're going to